All right, you can be seated in the courtroom. You ready? All right, the record will reflect we're back on after an extended weekend in cause number CR 14,024, State of Texas versus Eddie Ray Routh. We had a weather delay yesterday. We're back on track this morning, getting started a little late, but the jury's outside the courtroom at this time. State's counsel is present at counsel table, as well as the defendant and defense counsel. There are some matters we need to take up briefly outside the presence of the jury, first of which being in chambers this morning. I was presented with all counsel present audio recordings. I have reviewed those. I listened to them in their entirety in chambers, and I'm aware of their content, and I think those are anticipated to be exhibits this morning. And the state's intending on calling an additional expert. I don't recall his name at this time. Defense had indicated to me that they'd wish to take the witness on a brief 705 hearing, and we'll do that at this time.
His name is Howard Ryan, Your Honor.
Mr. Ryan, I've got a witness chair over here on this side. You've not been previously sworn, so before you're seated, we'll administer an oath. If you'll raise your right hand for me. Do you solemnly promise and swear the testimony you provide in this cause now on trial is the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may be seated.
May I, Your Honor?
You may.
You are Howard J. Ryan, is that correct?
Yes, sir.
And where are you from, Mr. Ryan?
I am from New Jersey.
And how are you currently employed?
I have several positions I'm holding right now. Most of my time is spent as the forensic operations specialist with the County of Morris in New Jersey in their Department of Law and Public Safety.
Okay. And what kind of education and training do you have which qualifies you for your current position?
I was employed from 1987 with the New Jersey State Police, first as a trooper, then as a detective. I retired from there as a lieutenant the 1st of January of 13. During that time in the State Police, the last 16 years of which I was assigned to the Forensic Investigations Bureau. In that bureau, there's 21 counties in New Jersey. The unit that I was assigned to covered the northern 7 counties. We handled all the crime scene work in those 7 counties, or most of the crime scene work in those 7 counties. To get into that particular assignment, you have to get selected to be a member of that unit, and we go through a crime scene investigation school, which at that point was run by the New Jersey State Police. It was a 280-hour course of instruction, which I completed. I was assigned to the...
Specifically, what fields of study were included in that 280-hour course?
It was crime scene management, evidence collection, evidence identification, photography. After that school, there was advanced schools involving bloodstain pattern analysis, several schools involving bloodstain pattern analysis, shooting incident reconstruction, investigation of shooting scenes. I was also a member of the Attorney General's police shooting response team in New Jersey. From there, I went to the office of the sheriff in Morris County, where I was for almost 2 years. I was assigned as hired as the chief warrant officer. I oversaw their criminal investigation division, which included their crime scene unit for that particular county. Currently, I've moved over. I'm with the Department of Law and Public Safety in the county, and working with the Office of the Medical Examiner.
Okay. And touching on you touched on your training in crime scene security, crime
Yes,
scene processing and analysis. What types of experiences do you have in the field in performing crime scene analysis?
Well, as I said, the last 16 years alone in the state police was assigned to a crime scene unit. And on any given day, we were processing scenes from anything from burglaries up to and including homicides, police shootings. where we routinely had to analyze and put together bloodstain evidence and shooting incident reconstruction. And then I went on to actually teach in this particular field as well.
Well, touching on the instructional experience that you
Yes, sir.
have, could you describe for the court the various work, the variety of work that you've done in instructing other law enforcement agencies and individuals in the field of crime scene investigation?
Yes, sir. The instructional portion of it began in the New Jersey State Police, where I became an instructor and later coordinator of the crime scene investigation school. I was there for about 8 or 9 years in that position doing that. That was a side position. In other words, that was in addition to my normal duties as a crime scene investigator. From there, I am currently on the instructor staff at the University of Tennessee's National Forensic Academy, where they run 2, sometimes 3 sessions a year, 10-week schools for law enforcement around the United States and now internationally. And the topic that we teach more often than anything else down there is shooting incident reconstruction. And I also, I'm on the instructor staff of Forensic Training Source out of Alpharetta, Georgia. The difference there is Forensic Training Source provides training on site, whereas the NFA, the officers would come to the University of Tennessee. Forensic Training Source delivers the instruction package on site around the United States.
Indeed, it was through the work at the University of Tennessee with the National Forensics Academy that you became acquainted with a Texas Ranger working on this case. Is that correct?
Yes, sir.
How did that come about?
We were down at the in Oak Ridge, where the NFA is located, and we were giving our 40-hour block of shooting incident reconstruction. When after class 1 of the days, I was approached by one of the Rangers, Ranger Mike Adcock, and he asked if he could ask us a question about a case he was working on. We sat down after class, and he began to explain what the case was he was working on, and asked if we could lend some assistance in their investigation, at which point, obviously, we said sure. And I had dealt with the Rangers before, so we began to talk about it, and then as time went on, and when I say time went on, several weeks maybe, we were back and forth on the telephone, and
So anyway, Texas sends their Rangers to this National Forensics Academy
Yes.
for training in this specific field of crime scene analysis.
Yes, sir. There are usually at least one or two Rangers in every class.
Okay. Now, you've also served as a lecturer for the United States Marshal Service.
That's correct.
What's the backstory on that?
We were asked several times to speak on specifically with the topics of evidence preservation, if they were to serve warrants, if things were to happen on a warrant service, how would they preserve it until other law enforcement or the Bureau, meaning the FBI, would get involved to assist them. We gave a lot of lectures on the evidence preservation and crime scene preservation.
And you've worked as a lecturer for the New Jersey State Police and County Police Training Academy courses too, is that right?
Yes, I have.
And you've also guest lectured for various universities in the region, like Rutgers and Stroudsburg and Morris and Sussex County Criminal Justice Program.
Yes, sir.
And you've lectured for the FBI.
That's correct.
In fact, you've taught courses in which college credit is awarded for in the field of crime scene analysis.
Yes, sir. The Crime Scene School for the State Police is college accredited, as well as the National Forensic Academy program.
Now, your training, looking at your CV in this specific field, dates all the way back to the mid or the early 1990s. Is that right?
Yes, sir.
And you've just a sampling of some of the courses you participated in: the Advanced Homicide Investigation Seminar, a 4-year course in 1996.
Yes.
Is that right? And you participated in bloodstain pattern workshop, a 4-year course of instruction and interpretation of bloodstain pattern in 1998, given by the New York City Medical Examiner's Office.
That is correct.
And you've also participated in a shooting incident investigation reconstruction course, a 40-hour course given by the University of New Haven Institute of Forensic Science.
Yes, sir.
And then you have you attend an annual symposium of the International Association of Bloodstain Pattern Analysts here in Texas.
Yes, sir, it's here in Texas.
Now, that gives you your background and training. As far as, now you've received some awards up in the New Jersey law enforcement community too, have you not?
Yes, sir.
And what were those?
Well, specifically, one was a unit commendation that was given to our entire unit for a culmination of investigations that we worked on. The other one was, I believe it was 2008, was a co-recipient of Trooper of the Year for the State Police.
I'm sorry.
Trooper of the Year? Co-recipient, I'm sorry.
And that Trooper of the Year award was tied to a specific homicide investigation,
Yes, it was.
for your work in that investigation?
Yes, sir.
Now, getting to this specific case, you went into, and we'll go into more detail possibly later as far as how you got involved in this case, but once you made an acquaintance with Ranger Adcock through the National Forensics Academy, we got in contact with you as well through the District Attorney's Office, is that right?
Yes, sir.
And what materials were you provided to review, to give your impressions and opinions regarding the crime scene in State versus Eddie Routh?
What we requested was the same thing we would request on any case that we would review or assist with. It's crime scene photographs, the investigation reports that were pertinent to the case. We also asked for your laboratory submissions, your laboratory results, and any other investigative material that is available that usually that the agency would think is pertinent, because there's times that we ask for things and we don't know everything that you may have in your case folder. So we ask for all of those things and receive them.
Okay, and you received the autopsy report?
I'm sorry, yes, sir.
Chad Littlefield as well as Chris Kyle, right?
Correct.
And the photographs that went along with those?
Yes.
You received crime scene photos which depicted the victims and everything that was at the scene?
Yes, sir.
And you have actually visited the crime scene recently as well, have you not?
That is correct.
And been able to compare those to the photographs you reviewed?
Yes, sir.
Did you receive sufficient information in order to begin formulating conclusions and opinions regarding how the shootings of these two men occurred, relative locations of the victims to the person who was shooting them, and other information that could be useful to the trier of fact in this case?
Yes, sir, we did.
What kind of opinions were you able to formulate relating to this crime scene, just in summary?
Well, one of the first things we look for in any case, and particularly in this case, is when you collect data at a shooting scene, one of the most important things to try to understand is the position of the victim, or the position of any target in shootings in general, and hopefully the position of a shooter, where the muzzle may have been when it was discharged. That's one of the first things we try to look at to see if you can or cannot determine. I feel that we went through the items that were given, and we were able to narrow down an area, a very specific area, where everybody was located, and the possibilities of any dynamic movement that may have occurred during that scene.
Now, was central to your analysis the science or the physics of bloodstain pattern analysis?
Yes, very much.
Were you provided sufficiently high-resolution quality photographs of the crime scene to do a careful analysis of bloodstain patterns?
Yes, we were able to find, we were able to look at the bloodstain, and that very much helped us in our opinions and conclusions of what happened here.
And does that help you narrow the potential locations of victims at the time they were shot, as well as the direction from which shots were fired?
Yes.
And is that really one of the central elements of your conclusions in this case?
It is one of the two central elements. The shooting and the blood are very crucial to that.
And did you also analyze the potential movement of the victims either before or during their shooting?
Yes, sir.
And
did you have sufficient photographic evidence to as well as tying that in and synthesizing it with the autopsy reports? Were you able, and ballistics reports, were you able to formulate opinions as to where they were when they were shot relative to their final resting positions?
Yes, sir.
And you had sufficient information to do that?
Yes, sir, we did.
Now, to be fair, you're not able to give us any sort of animation or detailed account of the order of the shooting or what precipitated the shooting.
Correct.
Were you able to narrow the possibilities based on the independent reports of ballistics, autopsy reports, and then your own analysis of the bloodstain patterns? Were you able to formulate scenarios down to which you could limit the possibilities?
Yes, sir.
Now, getting to those briefly, and we may have the opportunity to elaborate on those more, regarding the shooting of Chris Kyle, were you able to formulate an opinion as to his position where the shooting started relative to his final resting place?
Yes, sir. We have scenarios for exactly where he may have been standing and where his final resting position was there.
And regarding Chad, and what were those conclusions regarding Chris Kyle?
Well, with Mr. Kyle, what we saw was, what jumped out to us right away was the significance of the locations of the entry wounds. I don't want to use the term unusual, but it's rare to see a volume of gunshots sustained in a very small, confined area on the body. In shootings in general, where you have this multiple shots fired, this was actually a small group, a tight area on his body where they were located. It was also located on one portion of his body, meaning his right side. Very linear in shape, but confined. That is something that you don't see all the time, and the reason why is shootings are always dynamic. Shootings are usually always dynamic, and the way that happens, the way you see something like that, is that one or more shots are fired, hit their mark, causing the target to then become stationary or immobilized, and then additional shots can be administered. Or they were all fired at a relatively close range quickly, rendering the victim incapacitated. Normally, at a lot of other shootings, what you see is once somebody is hit with gunfire, there is movement. If it's not a gunshot that is incapacitating or killing somebody almost immediately, it's the body's reaction to move, to the impact, to the injury. We did not see that with Mr. Kyle. It was confined to an area, and there was between the blood and the wound track, it told us there was relatively no movement.
So his final resting place, which we can discuss at some point in photographs, is it your opinion that is the area in which he was
Yes.
first shot?
Yes, sir.
Now, regarding Chad Littlefield, it's a little more complicated regarding Chad Littlefield.
Yes, sir.
Regarding Chad Littlefield, what was your opinion as to the position in which the shooting began on him relative to his final resting position?
Well, the biggest difference you've seen between the two, and the thing that we saw in Mr. Littlefield, was that he was shot at various locations on his body. That is, on itself, just dealing with the ballistic evidence, would indicate movement. Now, you can't just based on that say movement of the shooter or movement of the victim. But when you add to that the bloodstain evidence that was there, it's more consistent with the movement of the shooter. And his wounds were sustained on several different sides of his body.
Now, the bloodstain analysis, narrowing it down to just Chad Littlefield,
Yes.
is it your conclusion that his resting spot after he was killed is at the same location to where the shooting began?
Yes.
So is it your belief that the movement involved the shooter?
Yes, sir. I do.
Now, in your report, you had described two different possible scenarios for shots to the head of Chad Littlefield. Now, of course, the autopsy report describes or designates bullet wounds by number just from head to toe. Was that your assessment of the autopsy report?
Yes, sir, from the autopsy report, correct.
Does not designate the order of the shots.
No, as a matter of fact, it even delineates in the report that it does not sequence the shot. The numbers do not correspond with a sequential order.
Now, specifically addressing two shots that were made to Chad Littlefield's head, one to the near the left eye and one into the top of the head.
Yes.
Based on blood stain analysis and the other forensic reports that you reviewed, were you able to formulate an opinion as to possible scenarios of Chad Littlefield's position when those shots were inflicted?
Yes, sir.
What are your opinions on that?
The wound track on each of these gunshots are both either way. Either scenario I'm about to give you, the body is down lower. When I say down lower, the first scenario is he's on one knee or both knees, and I'll be able to explain through the blood stain how we came to that conclusion. And in that particular scenario, his face and the top of his head is exposed to the muzzle. If in that position, the muzzle is discharged and the rounds strike him in the top of the head or in the face, both of those gunshots passed through the body. In other words, they entered and they exited. The one through the top of the head exited right back here in the back of the head. The one that perforated the face exited towards the back of the left, on the back near the left shoulder. In this first scenario, with him on his knee facing the muzzle, what we would have an expectation that there would be more evidence behind him, forward spatter of blood. When a bullet exits the body, body fluid, tissue, potentially hair, usually travels with it. A bullet impacts at a very high rate of speed, and the entire design of a bullet is to release kinetic energy. That kinetic energy is going to cause damage, tissue damage. And a lot of times when the bullet does pass through, if it has enough velocity and it passes through, it perforates the body, it's bringing some of that biological evidence with it. Now, if Mr. Littlefield was on that knee, and we have to give that scenario because of the body position on the knee, which we're certain of, that bullet passing through the head, both of them would have brought some forward spatter out towards the area immediately behind him.
But you did not find that pattern of spatter.
Correct.
So what is the other scenario that you believe is feasible, synthesizing all the various forensics in the photograph?
The second scenario is, again, he's on his knee at some point and falls backwards, ending up laying on his back with both of his legs bent slightly towards his right, with his head back towards the deck. The reason that we believed this is more plausible is that as the bullet passes through the head, if there was forward spatter with the head in the position low to the deck, the ultimate resulting saturation stain of the body draining blood would basically render any forward spatter pattern invisible. It would have absorbed it. It would have actually went over top of it. The other thing that we have in this particular case is the bullet that passed through his face and exited his shoulder stayed within the clothing. That happens, that is very consistent with what we call a short exit, meaning the body is up against another surface that is hard. It doesn't have to be extremely hard. It just has to be something that as the bullet decelerates is enough to hold the bullet from passing through. And beneath Mr. Littlefield, the projectile, one projectile, was located right next to the wound from the back, which would be consistent with the body being in that position when that bullet was fired through his face.
Now, he wasn't initially in that position. You also have concluded that at some point he was down on his knees. Now, backing up, did you formulate an opinion as to where Chad Littlefield was hit first by gunfire?
Yes.
And where was that?
Our opinion is he was shot in the back, twice in the back, between the shoulder blades. Both rounds perforated the torso of the body, meaning passed completely through. One was more of a horizontal plane to an upright body. The second projectile, and this is, again, I'm not sequencing which one of these two were first, but I should say the additional projectile that passed through his back and out his chest was at a slightly down to up angle, meaning it entered the back and exited a little higher on the chest, which we would be consistent with the body now starting to lean forward.
Per the autopsy report, did one of those projectiles that entered his back, the initial two shots, did it affect his spinal column?
Yes, sir. One of the two shots struck his spinal cord.
Did that factor into your opinion that he would have dropped right there?
Yes.
To his knees?
Yes, sir.
Now, what evidence do you have that he was on his knees?
In several of the crime scene photos, what you see is, well, the short answer is bloodstain evidence. Specifically with the bloodstain evidence, on the area of Mr. Littlefield's right leg, he's wearing a green colored pant, and on the area of the thigh and the right calf, or the right side outside of the leg, we see a substantial amount of blood accumulated there. And when blood accumulates in an area in a large enough volume, what's going to happen is eventually gravity is going to have an effect on it, and it's going to flow. Much the same way if I spilled a glass of water, eventually if it hit the edge, it's going to flow with the direction gravity is going to pull it.
In a very short period of time?
Yes, sir.
So you saw evidence on his pants leg that blood had flowed from the upper part of his body down his pants?
Yes, and it's interesting because it's on the right side. There were no gunshot injuries to his lower right side, so the blood came from the upper portion of the body, landed on his leg, and the flow pattern tells us that the blood flowed towards the floor as gravity would pull it.
Now, on the left side of his body, is there another indicator that he had been on his knees with possibly his hand touching him there?
Yes, he sustained a gunshot wound in his left hand. Again, the bullet passed through, and directly out in front of his left leg on the floor, there's what we call a contact transfer pattern. And in that transfer pattern, there's what we call a swipe. And that swipe passes through, meaning the blood is on the floor, and the pattern within that blood stain is consistent with several fingers in the blood and being pulled back this way. So you see the fingers going through the liquid blood. Now, that blood could be being deposited while the hand is on the floor as well. In other words, the blood not necessarily already there. So the hand is down on the ground, the wound is bleeding, depositing the blood on the floor, and as the hand pulls away and goes backwards, the fingers pass through the liquid blood.
So it appears there was a rolling backwards by...
Yes. In addition, on the leg on the other side, we have not just that saturation stain on the pant leg, we have contact transfer. And what that is, there is also the presence of blood on Mr. Littlefield's right arm, and we believe that the thinner portion of his hand, which is this in here, and his wrist area came in contact with his pant leg, and there's a contact transfer wipe on his arm as his body went backwards.
Okay, and in your ultimate conclusion is of the two scenarios of where the final shots to the head and face were, you believe it's more likely that he was shot while he was on his back and very close to his final resting place?
Yes, sir.
Now, you, in preparing your report, did you prepare some graphical depictions of the various gunshot wounds, trajectories of those wounds, as well as scenarios for both Mr. Kyle and Mr. Littlefield?
Yes, sir.
And do you believe those are accurate depictions of what your conclusions were?
I do.
And would they assist you in presenting evidence, if you're allowed to, before the jury?
Yes, sir.
Now, you also prepared a dummy, a life-size dummy of a nondescript male person.
Yes.
Did you use rods to depict the trajectory and path of the two wounds to the head?
I did.
And would they also be able, since it's in 3D, in addition to the 2D graphics that you prepared, would the use of the dummy assist you in explaining the conclusions that you reached?
I think so, yes, it will, because it goes a long way to show where the muzzle of the weapon would have been positioned while Mr. Littlefield was in this position on the ground.
I'll pass the witness.
Thank you, Alan. Mr. Ryan, my name is Shay Oxon. How are you doing this morning?
Good, sir, how are you?
Do you think that coming to Texas you might get away from the bad weather in New Jersey?
I did think so.
I just have a few questions
Yes, sir.
for you. You said that you went to the scene, and I'm assuming that's recently since you've come to Texas. You didn't do that back when you were writing this report.
Yes, sir, correct.
And there's not any evidence remaining, or you didn't find any evidence or look at any evidence that was still at the scene?
No, sir.
Counsel, and specifically about Mr. Littlefield, which counsel was just asking you about, you talked about a shot or a projectile being on a fairly level plane.
Yes.
In what you initially described as a second shot, and counsel described as a potentially next shot as being more from a downward toward an upward plane, correct?
Yes.
I mean, regardless of how those wound tracks or those projectiles perforating the torso are described, we don't have any way of knowing what the sequence of those shots were, correct?
Are you referring to those two specific shots?
Yes.
Correct.
Okay. Specifically, those two shots that y'all were talking about, you have theories about how to sequence those, but and you have scenarios that are more plausible than others, is what I take from your report.
Are you talking about the incident in general, or again, these two shots?
Well, in general, I guess.
In general, yes.
But with specifics, when we start talking about the next shot or the second shot, specifically to those two, we don't have any way to know the sequence.
Which one of those two came first?
Correct.
No, we cannot.
Okay. In general, back to speaking in general, basically, by reviewing the material and the high-resolution photographs, you're also relying on Ranger Briley's report and Ranger Adcock's report, and have to make some assumptions about what they wrote in the report and that evidence was collected or accurate, I'm assuming.
Yes, most of what we relied on in their report was what was collected and what was submitted.
Okay. Ultimately, in reaching your conclusions as to either specific victim and relying on those materials, though, ultimately what we come up with is a couple of scenarios. That's what you come up with in your report.
We narrowed it down to two scenarios.
Okay. And you indicate that one's more plausible than the other.
Yes, sir.
But ultimately it's not definitive.
Well, I'm of the opinion it's one of the two, and I feel pretty strongly about the one we say is more plausible.
I understand that. I mean, in specifically back again to Mr. Littlefield, that's because that you would expect to see more splatter coming forward, which would be in the direction behind him, if he were on his knees facing the muzzle.
Yes.
Okay, I understand you. The last thing I want to ask you about is do you have any indication from what you reviewed how far away the muzzle would have been? You talk about the shooter position and shootings being dynamic, and you testified that this appeared to be more consistent with movement by the shooter. Do you have a distance based on that review of those materials that you would say, and specifically with Mr. Littlefield, the shot to the face?
Well, I think it's something we can actually see better with the mannequin that's in place, with the flight path rods that are set in place, but it's several feet away. I think the important thing too is that on several of the areas of the injuries of both parties, there was gunshot residue found. No discernible pattern, but gunshot residue found, which doesn't give you an exact distance, but when you're firing specifically pistol ammunition, gunshot residue doesn't travel that far on its own. The discernible patterns bring you into a very close proximity. When I say close proximity, maybe 6 inches to 2 feet. But when you have gunshot residue without a discernible pattern, it's logical to conclude that it's fairly close, but not within that particular distance.
In your scenario, part of your report you talk about there being bolt action and semi-automatic rifles available. In part of your report, as far as assessing the tactical advantage, things like that, you talk about using the 2 handguns.
Well, that's one of the tactical advantages we refer to. Yes, sir.
I said it's part of it.
Correct.
And in your scenario, you testified earlier in regard to Mr. Kyle, this tight grouping.
Yes.
Unusual to see, it didn't indicate movement from either party, the shooter or Mr. Kyle, correct?
Under one of those scenarios, yes.
Okay. And at that point, without being able to sequence those shots, does that require a shooter to be using 2 guns at once under your theory of the most plausible scenario in regards to both men?
Well, that is certainly possible, but it doesn't have to be that way, no.
And lastly, with regard to Mr. Kyle, the same question I had about Mr. Ratliff in regard to proximity. You spoke specifically about Mr. Ratliff and the gunshot residue and
Mr. Who?
Mr. Littlefield, excuse me.
I'm sorry.
And with regard to the gunshot residue and the nature of it, that you could estimate proximity or distance when the muzzle was fired at some point.
I'm sorry, can you ask that again?
Yes. With Mr. Littlefield earlier, you told me you could estimate the proximity of the muzzle because of the gunshot residue, correct?
Well, you can't estimate the exact proximity, no. But you can, it's
Well, when I say estimate, I don't mean for you to be exact.
right.
When I'm asking you, when I asked you earlier, you said it was not 6 inches to 2 feet, but it was relatively close.
Yes, sir.
Beyond, some distance beyond that.
Yes, sir.
That was specific to Mr. Littlefield a while ago when I asked you that.
Yes, sir.
Now I'm asking you about specifically to Mr. Kyle, that
Yes.
same type of question about proximity to the muzzle.
Yes, sir. There's,
Can you make the same conclusions about him?
there is gunshot residue on the area around his injuries as well.
Okay, and is it similar to the answer that you had regarding Mr. Littlefield as far as estimating a distance?
Yes, sir.
Okay, I'll pass the witness.
Just very briefly, the gunshot residue, which was referenced, you were provided with submissions and testing results regarding the location of GSR on the
Yes, sir.
victim, right?
Yes, sir.
And that helped formulate your opinion.
Yes.
To the relative proximity of the shooter to the victims.
That's correct.
And it wasn't point blank, 6 inches to 2 feet, but it was within the normal, relatively short distance that a bullet, or that GSR travels with the projectile.
Yes, sir.
Now, which isn't that far.
No, it's not.
We're talking about single digit numbers of feet.
Yes, sir.
Right.
Usually, yes.
Okay. Now, with regard to Chad Littlefield and the final 2 shots to his face and head, that, besides the GSR that factors into that analysis, you also have a trajectory of the bullet entrance wound and exit wound for each shot that you can then, using just sheer an object in motion stays in motion, map out to a potential intersection with the muzzle of a gun.
Correct. We put the flight paths in position, and you can back extrapolate that flight path backwards towards the muzzle. It'll give you the direction the bullet was traveling.
And so knowing the height of a potential shooter, and then using both the 2D images of the drawings with the trajectory mapped out, as well as the 3D depiction using the dummy, you can get a pretty close estimate of where the handgun would have been held in order to inflict those wounds.
Yes, sir.
So that, on Chad Littlefield, the relative positioning of the shooter to the victim can be assessed using both GSR as well as trajectory.
Correct.
I'll pass those.
Without specifically asking about either victim, just a general question about gunshot residue. Is there any way to discern the presence of gunshot residue on a body, whether it was from a muzzle blast that was pointing at somebody, or whether or not it was gunshot residue from a firearm that they had fired?
You said on the body, anywhere on the body?
Or near a wound?
Well, to answer that, I'd have to explain that a lot of times if we find gunshot residue on the hand, that could be from handling a weapon that had been recently fired. When you find it in odd places on the body, the back, the shoulders, wherever, it's important that that's probably going to be that the particulates from the gunshot residue were airborne and came in contact with the body in that location.
Let me stop you for a second.
Sure.
I'll let you finish, and you can explain it all you want. But consider a scenario for me for a minute that two guys are standing at a gun range next to each other, and they're both firing at targets down the range.
Yes, sir.
Is gunshot residue going to transfer and be on their clothing?
It can.
And can it be from both our firearms?
Yes.
Okay. And it could be in an odd place, like you said, the back or the shoulder, or
That could happen.
not just your hands.
Correct.
I mean, we are talking about a scenario where some guys are at a gun range.
Yes, sir.
Look, that's all I have.
Nothing further, Your Honor.
All right. Any objections regarding the testimony?
Your Honor, we'd make our 403 objection, and I think that's it.
All right, I will find that the opinions, the specific opinions listed this morning are relevant. I'll find by preponderance of the evidence that the scientific, technical, and other specialized knowledge of the witness will assist the trier of fact to understand the evidence to determine a fact and issue. That is the mechanism of the killing that helps to establish or prove or disprove a fact and issue, being the state of the mind or intent of the shooter at the time of the occurrence. I will find further by preponderance of the evidence that the witness is qualified through knowledge, skill, experience, training, and education to render the testimony that he has offered in the form of opinion, including the renditions of drawings and demonstrations. And I'll further find that the opinion is reliable, being based upon recognized areas of expert testimony, being blood specifically, ballistics, shooting incident reconstruction, and bloodstain pattern analysis, and the witness identifying having sufficient information to form those opinions. So I will deny and overrule the objection, finding that the probative value of the evidence is not substantially outweighed by the danger of any unfair prejudice, confusion of issues, misleading the jury, and this is going to take 30 minutes, 45 minutes in front of the jury.
Yes, Your Honor.
There's not going to be any considerations of undue delay or needless cumulative evidence, so the testimony will be presented. Anything further?
No, Your Honor.
No, Your Honor.
All right. As far as the order, are you going to do this witness next? Okay,
Yes.
all right. If you'll, we'll go ahead and bring the jury in at this time.
Can you step down, sir?
Just you stand up.
Go ahead and bring the dummy out.
Let you be seated in the courtroom. All right, the record will reflect that the jury's returned to the jury box this morning, and we knew it was coming Friday when we left, and so we've dealt with it, and I think everybody has been advised regarding maybe a continuing plan with the weather contingency, and we're prepared for this at this point. We've conducted some business this morning. We weren't wasting your time. We were actually in here working. The record will further reflect State's Counsel's present as well as the defendant and defense counsel. Mr. Ryan, I need to administer an oath for you if you'll raise your right hand. Do you solemnly promise and swear that the testimony you provide in this cause now on trial is the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
You may be seated.
State calls him, Your Honor. Mr. Ryan, could you introduce yourself to the jury?
Yes, sir. My name is Howard J. Ryan.
And Mr. Ryan, how are you currently employed?
Currently employed in several positions. The one I spend the most time at right now is in the county of Morris in New Jersey. I'm a forensic operations specialist with the Department of Law and Public Safety in Morris County, specifically with the Office of the Medical Examiner. I also am currently employed at the University of Tennessee on the staff of the National Forensic Academy, and Forensic Training Source is another company I'm employed by out of Alpharetta, Georgia. The two of them are both predominantly training, offering forensic training specific to shooting incident reconstruction.
Now, Mr. Ryan, that's a mouthful of current hats that you wear. What is, how long have you been in law enforcement?
27 years.
And during that time, have you developed a particular emphasis in the forensic investigations field?
Yes, sir.
And what is that emphasis?
Specifically, what we do more of anything right now is shooting incident reconstruction and bloodstain pattern analysis.
Okay. And what type of training do you have in those two fields of shooting scene reconstruction as well as bloodstain pattern analysis?
Specifically to those two areas, I've attended classes given up the University of New Haven in the state of Connecticut under the Henry C. Lee Institute of Forensic Science for bloodstain pattern analysis. I've also gone through a class with the New York City Medical Examiners, OCME they call it, on bloodstain pattern analysis, and I had the opportunity to teach with Mr. Paul Kish in the area of bloodstain pattern analysis as well. As far as shooting incident reconstruction, again, that was through the University of New Haven, and since then we've not only done that as part of the career, but continued on and offered, we actually now instruct in those fields as well.
Okay, and so you, getting more specific, you have participated in a number of advanced training courses relating to bloodstain pattern analysis, have you not?
Yes, sir.
Could you just for the jury's benefit describe in summary some of those advanced and long form courses that you participated in?
You'd like me to explain what bloodstain pattern analysis is and specifically? And shooting?
If you could get through tell me the training you've had, and then we'll go into the details
Yes, sir.
of the science behind it.
Well, the training, the first class was actually offered by, that I attended, was offered by the Office of the City Medical Examiner in New York City, Dr. Robert Schaller. It's a Schaller, I think it's S-C-H-A-L-E-R. It was a 40-hour course given by members of OCME on the geometrical interpretation of bloodstain pattern evidence. It focused specifically on liquid blood being shed from a body and how it is deposited on different surfaces and the mechanism that that is the result of the blood being deposited. I further went on to a class taught by Mr. Kish. He's out of Corning, New York. His specific course, again, was the same type of 40-hour block. A lot of the same principles were taught in that class. And then I got an opportunity later to actually teach with Mr. Kish on the same subject.
Okay, so you participated in a number of these advanced seminars learning about bloodstain pattern analysis, and then you've actually gone into the field of instructing other law enforcement agencies and professionals on the science of it.
Yes, sir.
Now, and we'll come back to some more of the specific instructional work that you've done. What is the basic science underlying bloodstain pattern analysis, specifically in relation to use of firearms?
Well, it's not just specific to use of firearms, it's specific to any bloodshed, and firearms obviously can cause bloodshed, or any other kind of violent impact to a body that would shed blood would cause bloodshed. But what we do is oftentimes we deal with scenes where victims are not there anymore, whether they were taken to a hospital or they just have left the scene but had sustained an injury. What we look for with the blood is how the blood was deposited and what shape it is in as it is still present for us to look at. And a lot of times what that does is blood can be set in motion in flight. If an impact or an energy source is great enough to cause the blood to be set in motion, it will land on a surface. A bloody surface or a surface with blood on it, say my hand comes in contact with another surface, now that blood is transferred. So there's different mechanisms of how blood, liquid blood in particular, is deposited on a surface. And what we can do, because it is fairly predictable as to how it happened, is to look at those stains that are left behind and explain how they got there, and specifically with blood that's in flight, put a blood source back in a specific location sometimes. Each scene is different, each blood stain is somewhat different, but they can tell you the source of the blood and the location of the blood source when the blood was shed sometimes.
It's kind of like in the movie Rocky when they have a slow motion shot of a boxer getting
Hit in the face and his blood and sweat slings in the direction from the punch.
Yes, sir.
So when an injury is inflicted on someone, whether it's with a fist or a knife or particularly with a projectile from a gun, does that affect that affects the direction of the flow of the blood resulting from the wound?
Correct.
And so you can analyze those things based on what you find at a crime scene.
Yes.
Now, do you synthesize that information with other sources of information regarding the crime scene as well?
Yes, sir.
Now, we'll come back to some more details on that, but I do want to, just so we understand why you are here to talk about this. Now, you're from New Jersey.
That is correct.
And so the concentration of your professional work has been in that northeast area, is that right?
Yes, sir.
But you've gone to trainings and participated in instruction all over the country in connection with crime scene reconstruction and bloodstain pattern analysis.
That's correct.
Could you give us a sampling of some of the places and schools you have instructed at over the years?
Well, the two main places that we teach right now are the National Forensic Academy, which is in Oak Ridge, Tennessee. That's part of the University of Tennessee. That particular program brings officers in to Oak Ridge, and they have a 10-week program of instruction, resident program. One of those weeks we are responsible for teaching down there, and they come from all over as far as Kuwait. We've had Kuwaiti police services there, and I believe every state in the U.S. has been represented in the NFA now. But
Does that
most,
include Texas?
yes, it does, quite a bit actually. But they, that is a resident program there. They come to the NFA. Forensic Training Source out of Georgia, they provide a similar instruction, but they bring the instructors to the agency. So we've been everywhere from Maine to, 2 weeks ago we were in Arizona, Washington State, Oregon. Wherever the agencies are in need of it or want it, we will go to them.
Okay. Now, the Texas law enforcement agencies have sent folks to your training work in the National Forensics Academy at the University of Tennessee. Is that right?
Yes, sir.
In fact, Texas Rangers routinely attend that 10-week school.
Yes, sir.
And that is how you became involved in working with this case.
That's
is it
correct.
not?
Yes, sir, it is.
Could you explain how you became involved in working, performing this forensic work for the State versus Routh case?
Yes. It was earlier in the fall, this past year. We were down in Oak Ridge doing our block of instruction on shooting incident reconstruction. and there were 2 Texas Rangers in the class, one of which was Ranger Mike Adcock from here. And he asked on Wednesday, I believe, of that week, if we could take a few minutes after class, and he wished to ask us a few questions about a case he was working on. We said sure.
And at that time, you were serving as an instructor?
Correct.
Okay.
Yes, sir. So he opened up his laptop and he started talking about this particular case, and he didn't tell us right away what it was. And he asked if we could help him with what was left at the scene, some of the photos of the scene regarding the gunshot injuries, the wound patterns, and the bloodstain analysis. And as we began to just talk about the photos, he asked us if there was any way we could assist him with going through their shooting investigation, and we said sure. And that turned into us basically sitting down and doing a shooting reconstruction on this particular event.
And then, after that initial contact and visit with the Texas Ranger involved with the case, did you request specific material that you needed in order to perform a forensic analysis of this scene for the state?
Yes, sir.
And what information did you request and receive to assist you in preparing that for the state opinions?
We asked and received crime scene photographs, any other visual documentation that they had of the scene. We asked for the investigative reports, any crime scene evidence logs, laboratory submissions, laboratory results, autopsy photographs and autopsy reports, and basically anything. We usually just tell them we need everything you have. But those are the itemized lists of what we received.
And did you receive everything you needed?
Yes, sir.
From this analysis, were the photographs of the crime scene that you received, were they of sufficient resolution where you could inspect the surfaces and the victims' bodies and everything that was at the scene for blood-stained patterns?
Yes.
And were you able to formulate opinions regarding this case?
Yes, sir.
Now, to narrow the focus of what types of opinions you were asked to help with, did you analyze the information that you were provided, the autopsy reports, the ballistics reports, gunshot residue reports, as well as the photographs? Did you analyze the potential proximity or closeness of the person who was doing the shooting to the victims when they were killed?
Yes, that was obviously a concern, and it's one of the things we always try to figure out in any shooting scene is position of a shooter in relation to the location or position of a victim. Yes.
Okay. And in many scenes, is that complicated by movement?
In shooting, one thing about shooting scenes is there are always complications with movement, but the evidence a lot of times between the bloodstain evidence left behind and the wound paths or wound tracks will tell you where it took place. And the thing you got to remember is they don't always the dynamics of an incident don't all take place in one specific spot. So the one interesting thing about this case was the movement. That's something we keyed in on right away.
So getting to that, when you began receiving the photographs and the investigative reports and the autopsy reports, what were your initial impressions of this crime scene in general in comparison with other crime scenes that you've worked?
Well, it was very confined. It was a very small area. They were all, it seems certainly that they were all right in the same general area. And specifically one of the things we started to look at, which were very different from victim to victim, were the locations of the wounds, of the gunshot wounds.
What was it that struck you about the gunshot wounds to Chris Kyle and Chad Littlefield?
Well, with Mr. Kyle, first of all, they were all located in one general area, on the upper portion of his right side of his body. And to be quite honest, when people look at that, they may not see what's unique about that, but what is unique about it is when gunfire erupts, people move. It's just, we've always seen it in shootings. You see it quite often. The only times you don't see that is when something happens quickly and very decisively.
Does it also factor in on whether the victim of the shooting knows it's coming?
Oh, that's a huge factor in this. This is, and that was clearly the case here. One of the, almost instantly, the first thing that came to mind was specific to Mr. Kyle is he absolutely never saw this coming. These gunshot wounds that struck him in an area that were incapacitating and isolated to a specific area of his body. And that's unusual. We don't see that often.
May I approach the witness, Your Honor?
You may.
Now, we've taken a sampling of the crime scene photographs, which were already admitted into evidence. I'm going to show you what's been admitted as State's Exhibit 38. Now, is this one of the scene photos that you reviewed?
Yes, sir.
And this State's number 38 depicts the shooting deck at which the crime occurred.
Correct.
Now, have you had the opportunity to actually go out and inspect the shooting range out at Rough Creek Lodge?
Yes, sir.
Now, could you describe the relative size of that shooting deck? In fact, you had explained to me at one point an impression you had that had not gotten from the photographs of the actual shooting deck.
Yes, sir. Looking at all the crime scene photographs, you see the area and you see it very, very clearly. However, when you go stand upon that deck right there, you get a very, very strong sense of how close everything is, what a confined space it is. And I didn't get that much of that impression in the photographs. And you know, the angle at which you take a photograph can do that. Your focal point and all of that comes into play, and your camera lens will capture everything. But sometimes being there and standing right on that, it was very small area, a lot smaller than I. It struck me right away how tight that area was there.
Now, with the very tight pattern of shots that were inflicted upon Chris Kyle, does that affect your opinion about how close someone was standing to Mr. Kyle when he was shot?
Well, that could very well be one of the scenarios. Yeah, to achieve that grouping of shots, it is my opinion you would have to be, if they were all administered one right after another. In other words, if all those shots on his body were sustained in one action, one repetitive shot after the other, I would say that it was fairly close. You're not going to get that far away and administer that type of gunfire in a confined area, specifically with the wounds that he sustained. Because two of the wounds, as spoke about in the report by the medical examiner, were fatal wounds. And one of the wounds that struck him in the mandible of the face passed through the oral cavity and struck his spinal cord, would have been immediately incapacitating. It would have put him right down.
So he would have dropped right there where
Yes.
that shot hit.
Yes. So when you think about that many shots, whether they're fired in rapid succession or not, when you have to consider two of those bullets probably would have put him down right away, incapacitated his motor functions, and for the rest of those shots to get in there, it would be pretty remarkable.
So now when you talk about fairly close, besides the pattern of the shots to Chris Kyle's body, suggesting it was done at very close range or relatively close range, were there other factors that you were able to take from the forensic analysis, the ballistics pattern and trajectory of the bullets that suggest to you how close the shooter may have been to Mr. Kyle when the bullets were fired?
Specific with Mr. Kyle, the other thing that we saw in the reports were the presence of gunshot residue in the area on his clothing that were tested around the wounds, and there was the presence of gunshot residue according to the lab results.
Now, can you give a precise distance at which the shots were fired from based on that gunshot residue analysis?
No.
Now, when you talk about gunshot residue, and I know you know all about it, but for our benefit, could you explain just in general layman's term, what are you talking about when you talk about gunshot residue?
Yes, sir. When a weapon is discharged, whether it's a long gun or a pistol or a shotgun, it doesn't matter. The way the bullet is designed to fire is a firing pin strikes a primer. Primer is a small explosion that ignites the larger explosion, which is the gunpowder within the bullet. The projectile is then exposed to the force of that explosion. The back end of that bullet is being pushed, and that's what's causing the bullet to spiral, come down the barrel, and discharge the weapon. In addition to that projectile exiting that muzzle, you also have a substantial amount of burnt, unburnt, and partially burning gunpowder that is still burning off as this whole thing happens. And you got to remember, it happens very quickly in a blink of an eye as this explosion occurs in the gun. So that byproduct of the cartridge exploding also has a ballistic property. It's in motion. It's coming out. Now, the bullet is usually made up of copper or lead, or a combination of both, or just lead. It's dense, it's heavy, and it's got a tremendous amount of pressure being applied to the back of it. So with that density and that force, it's going to travel a great distance. The gunshot powder does not have that density, does not have that weight. So it's going to come out of the gun, but where it goes after that, it may peel off out into the side, and it's eventually not going to move any further down away from the muzzle. It just doesn't have the energy or the weight to do it. The interesting thing about that is certain weapons and certain ammunition can be tested for a muzzle to target distance. But to do that, to make that test relevant, well, let me explain first what the test is. We'll take the gun in a controlled environment, and we fire it at either a white sheet or something at different known distances. And then we'll have our bullet hole, and then we look at our powder pattern around it. So if we have a certain diameter, we can recreate that or compare it to what we may have found at a scene. In this particular scene, we did not have any discernible patterns. We had the presence of gunshot residue, but no discernible pattern. So it really, it kind of made doing a muzzle to target distance on a control a moot point, because we didn't have anything to compare it to, but we did have the presence of gunshot residue. So as it discharges the weapon, it will travel, but there are factors involved, that affect how far that gunshot residue will travel before it may stick in your clothing or in your hair or on your skin.
But we're talking about ranges of reasonable possibility here. If it was a point blank, say 6 inches to 2 feet, would you have expected to find a discernible pattern from the gun muzzle, from the end of the gun where the gunshot residue blew out with the bullet? Would you expect to be able to say, have a confined pattern on the body around the wound?
Yes.
And that's is that fair to say that's 6 inches to 2 feet where you'd expect to see the pattern?
Well, it all depends on the weapon and the ammo, but yeah, the closer you get, you will see a discernible pattern, and it changes from weapon to weapon and ammo to ammo.
And you didn't see that pattern on Chris Kyle?
Correct.
And so we're not talking about 2 feet, within 2 feet for the shots to Chris Kyle?
I don't think so, no.
But what is the potential range? Now, of course, when you shoot from far off, like if I shoot a deer rifle at a deer at 100 yards, you're not expecting there to be any of that gunshot residue travel that far.
No, sir.
And really, it starts dissipating rather quickly.
Yes.
What type of range of distance would you expect for the type of handguns that we had used in this killing? What range of distances would you expect the shooter to have been?
Well, I believe that they actually did some test fires on several of the guns, and with certain ammo it was 6 inches, and with other ammo it was out to 24 inches. That was the items that were specifically used here, but you have to factor other things when you ask how far do I expect it to go. A simple question: are you upwind or are you downwind? As this loses energy, it is a powder. It's a fine item that's burning off in the air. You get a strong headwind, and I did notice you have wind here. That could have a very strong effect on how far that gunshot residue may or may not travel.
Now, the gunshots to Chris Kyle were going up the back and side, with one in the side of the face. Is that right?
Yes, sir.
Based on that, is it your opinion that he was facing away from the shooter?
Yes, he definitely was not facing the shooter. I believe that his body was turned where the shooter, the muzzle was to the right and slightly behind him. And pretty much all of the projectiles fired into the body came from that same direction.
Okay. Now, and then relating that, of course, the other variable that we got to deal with, we have the shooter and we have Chris Kyle, but we also have Chad Littlefield back behind Chris Kyle. We may come back and talk some more about Chris Kyle in a moment, but there were a number of shots inflicted upon Chad from various angles, were there not?
Yes, there were.
Now, the medical examiner had described those just by number from head to toe, right?
Yes.
And it was very clear in from his report that was not an ordering of the sequencing of those shots, right?
Correct.
They never do at the ME's office. Have you formulated opinion as to which shots to Chad Littlefield's body were sustained first?
Yes, we have.
Well, in fact, may I approach the witness, Your Honor?
You may.
I want to show you what's been previously admitted through the ME as State's Exhibit
205, which was a depiction of the shots. Now we have shots to the back, and to the head and hand and such, right, in this exhibit.
Yes, sir.
Which shots do you believe were inflicted first on Chad Littlefield?
As delineated on that particular diagram you're holding, a shot that is marked number 5 and number 6, I believe were the first two impacts that struck Mr. Littlefield.
And where did they enter his body?
In the back, on either side of the spinal cord, but you can see 6 is almost towards the center of the back, 5 is a little bit off to the right.
Now,
I think it's also important to note they both exited his chest.
so the bullets do not remain in the body.
Correct.
Now, you mentioned the spinal cord in relation to one of these shots, 5 and 6.
Correct.
Right here. The medical examiner's report described one of those hitting the spinal column, right?
Yes, sir.
Would that have been would that affect where he fell?
Yes, it could very much affect where he fell.
And what would be your opinion about where Chad Littlefield fell once those first two shots hit him in the back?
If that bullet struck his spinal cord and did significant damage to that spinal cord and the nerves within there, he would probably fall straight down. Almost collapse straight down to where he is, or start to drop to the floor. In other words, as opposed to...
Your Honor, I want to object to this point, it's non-responsive.
Sustained.
Okay, so he fell right where he was, essentially, though.
Yes.
Would that be fair to say? Now, based on the crime scene photograph, I mean, did you incorporate into your analysis of finding a gunshot residue on the clothing of Chad Littlefield?
Yes, there was some gunshot residue as well, as found by the laboratory.
And did that relate to these wounds to the back as well?
I believe it did.
So these are not long distance shots to the back either.
I don't think so, no.
Now,
Mr. Ryan, now looking at State's Exhibit 38,
Yes.
and Your Honor, may I publish this for use by the witness?
You may.
Mr. Ryan, I believe there, just to
Right here.
clarify, you can use this touch screen to mark on there, on this screen, once this is exhibit up.
Okay.
Stylus and a laser.
Yes, sir.
So I may ask you to, and we have instructions here on the screen. I want to show you State's Exhibit 38, which depicts both of these men and their position at the crime scene. Based on all the information that you synthesized from the crime scene photos, the bullet trajectories, the presence of GSR, have you formulated an opinion as to the area at which the defendant or the shooter would have been standing when these shots were fired?
Yes, sir. There may have been movement on the part of the shooter, but depending on the position of both victims and the areas where they were impacted, he was probably standing positioned with one victim to either side of him or to either side of him slightly in front of him.
would he have been standing, now, looking at the State's Exhibit 38, would he have been standing to the left
of where the bodies are, up on the deck or down on the deck?
I can draw right on this
Sure,
here.
sure.
It will probably be somewhere in this area right in here. The reason we say that too is there was no movement of either victim that we can tell after the gunshots impacted their bodies. Both of the victims sustained very devastating gunshot wounds that would preclude them from moving afterwards. Both of them seem to have gone to the ground in an area right where they sustained the gunfire. And what else tells us that is there is no bloodstain evidence outside of the area that is located immediately around each victim. The bloodstain is right there. With that type of injury, multiple gunshot wounds, it is very common if the injured party is moving, whether walking, running, crawling, whatever it may be, that there will be additional bloodstain evidence deposited on other surfaces, and there is none. It's all right there in and around the victim.
So
both victims.
once they start to sustain injuries, the bloodstain analysis tells you that they did not walk around or slide around or have any other such movement.
Yes, sir, it's consistent with no movement.
So the shooter would have needed to have been in a position where he could, with each of them to their backs to the shooter,
Yes,
but close enough to have deposited gunshot residue on each of the victims,
yes, sir.
and close enough to Chris Kyle to have inflicted the type pattern of bullet wounds that you found in the autopsy.
In one scenario, yes.
Okay. Now, you say one scenario, you have developed a couple of different scenarios of the possible order of shots for Chris Kyle. Could you address those?
Yes, sir. Specifically with Mr. Kyle, what we concluded was, based on the blood stain evidence being located in one specific area and based on where his wounds were located, what you can see adjacent to his left arm on the ground there is what we call a saturation stain in that dirt. That's consistent with his body being moved over to administer first aid, but rolled over. You'll notice that between that saturation stain and his body, there is an area of dirt right in here where there is no additional blood. That's consistent with him being on his side or more towards his face, laying down in that dirt as the blood is released from his body. When they roll him, there's additional blood underneath his head, but there's no blood in between. So that's two separate positions, and it's logical to conclude that he was moved for medical intervention. With the position or the location and position of his wounds on his body, we had to say that it was probably one of two scenarios. One, he's standing up, he's not looking, he doesn't see this about to happen. And there's a number of factors that we use to conclude that as well, other than just the blood in the gun. But he's struck by gunfire. All of the gunfire is delivered in one episode or one event. That's one scenario. The other possible scenario is that he receives a portion of that gunfire, and it would have to be one of the two fatal gunshots, the one that struck the aorta or the one that struck his face and hit his spinal cord, that would have put him down to the ground. And then at some point, additional gunfire was administered to the body on the ground. Either one of those two scenarios are plausible with what we have here.
So either rapid fire at close range that dropped him and all the shots were a single salvo, or a short salvo that completely incapacitated him with follow-up shots while he's on the ground.
Yeah, yes, sir. And you got to think about this. There's two individuals on that deck that he's engaging in gunfire. So at any given time, one of them, if given the opportunity, would engage him. You can't go through this particular investigation without acknowledging the fact that both individuals are armed and never had the chance to present that.
And that's because their weapons, you know that because their
Yes.
weapons were found in their holsters with the safeties on.
Yes, they were never unholstered. You also can't really look at this with a degree of objectivity without taking into consideration the skill set of Mr. Kyle. If he's faced with a confrontation, I have to believe that he's going to defend himself and engage. It's very obvious that he never saw it coming. He was shot in the face and the right side of his body, either all in one violent episode or in two. And those two scenarios, either he takes it all standing up and falls down, or he falls down and takes additional gunfire on the ground.
But either way, he didn't see it coming.
Never saw it coming.
Now, what does the empty revolver and the earplugs in his ear tell you as an analyst?
Well, that goes to what I was just saying about there's other factors here that had to be considered when we went through this. That pistol on the ground, that revolver, is empty. It's fired dry, meaning all the rounds had been discharged. You'd have to ask, and we did, I asked myself, when did this happen? When did the decision to engage them occur? And I don't think it's coincidental that the position of the shooter was in an area where he could engage two targets, either simultaneously or one and then the other in a very rapid succession. And the other thing is, he knew that there was some gunfire going down range at targets, and I don't think it's coincidental that he waited until that revolver was empty.
So the engagement occurred at a time of the shooter's choosing, is that your opinion?
Absolutely. Yes, sir.
All right, so we layer upon layer, you've stated your opinion that the relative position being the blue mark up there on the left of that states 38. That, now, since you've been out to the range, it's hard to gauge distances from where we are looking at this photograph. About how close in feet would that be to each of the victims, Chris Kyle and Chad Littlefield?
Where I just put him there, it's probably, it's under 10 feet to each, maybe 6 to 7 feet, if that. It was, excuse me, it was actually a lot smaller space when I got to see that area than it looks in that photograph. They weren't far away at all.
So the tightness of the pattern tells you these were not long-distance, difficult shots.
No, they were not. I don't believe so.
Now, Chad Littlefield's situation was a little more complicated than the pattern of shooting that went up Chris Kyle. Could you explain what your findings were in relation to specifically Chad Littlefield?
Yes, sir. I don't view it as a complicated. I view it as very different. Mr. Littlefield, the wounds on his body are in different locations and on different sides of his body and on different parts of his body, whereas on Mr. Kyle, they were confined to a linear pattern on one side of the body. I do believe, as we mentioned earlier, that he was shot in the back first. One of those two projectiles that passed through his upper torso from back to front and exited his chest, I believe, were first. And the reason I say that is this. One hit his spinal cord and would have put him in a position of being incapacitated.
May I use let me just use the exhibit from the EME to keep track of what you're telling us. Sorry to interrupt you, but just so we're clear, we have here the wounds of Chad Littlefield. And you told us earlier, it's your opinion, that these two shots to the back, one of which hit the spine and incapacitated him. 5 and 6 were the first.
You know, what's that exhibit?
States 205. States 205, the ME chart.
Yes, sir.
Now, is that correct? The two here were to the back were first.
Yes.
Now, the wounds you're talking about coming from different directions, could you describe those for us?
Yes, sir. I'm going to
Would it
use.
be helpful to step down and point?
Is that okay?
Maybe you're on-
Yes, sir. numbers that are marked out here by the medical examiner. When I use these numbers, it doesn't mean I'm sequencing what happened first. I believe these two were first, or at least one of these was first. And the reason I say that is we can say with certainty that Mr. Littlefield at one point was on his knee or knees, one knee or both knees. And I'll explain why we think that with regards to the bloodstain evidence. The other shots here, I believe, came after these. This is why. Number 3, which enters the back of the head at a very sharp down angle, in a very shallow angle to the plane of the skull, passes through the musculature in the back of the neck and exits the neck just below behind the ear here. And I believe that also re-engages the shoulder over here forward. So I'm of the opinion that number 3 and 4 in one door. Pass through and re-enter the shoulder. The way that happens is, if the body's down on the knee, well, first of all, the sharp down angle of number 3 has to have occurred if that head was lower than the muzzle. It's got to be down, bent seriously down or down low. So this is lower. It has to have been lower than the muzzle. Just and that the angle of the impact tells us that. The marginal abrasion on the bullet wound is very pronounced, and it's a very steep angle. And this line here, you can see the muzzle would have had to be up here somewhere. So it passes through, and I believe it re-engages and enters the shoulder. For that to occur, this shoulder would have had been up, almost like he's leaning. That shoulder comes up as you lean to brace yourself on the floor if you're on your knee.
Yeah, yeah.
If you were to kneel, whether this knee is on the ground or whether just the one knee is on the ground, where that bullet passes through the head and anything, would probably have missed the shoulder, unless the shoulder is up. The shoulder, for me to brace myself, my shoulder has to elevate itself. And if you articulate the body in that manner, that flight path lines up with 3 to 4. Either way, thereafter, he's down on a knee or both knees.
So that shot through the back of the head that exits to the side and through the shoulder, that's not the same initial salvo as the 2 to the back.
No, sir. In addition, there's a substantial amount of blood exiting this wound here, up on the neck, and there's blood exiting the entrance and the exit of what is marked as number 4. If he's in that position, the blood is going to fall down with gravity. It has to fall, liquid blood. And the volume of the liquid blood present is so much that it's not going to hang onto a surface anymore. It's going to drip or flow. So this started to come down. In one of the photos, we'll see he's got blood on the interior of his forearm that actually flows down to his arm. And the way it's going to flow this way, again, is with gravity. So that arm is down here. That blood is coming out, and it's landing down here, and it's landing on his pant leg as he starts to move backwards.
Well, and while you're down here, let's look at what you're talking about here in State's Exhibit 43 or 46. Basically 46, you're talking about blood on the arm here.
Yes, sir.
There's no wound to that arm, right?
No, sir.
So that blood came from somewhere besides the arm.
Correct. Yes.
Okay, so that's what you're talking about. Gravity would have needed to have fed that down the arm,
Correct.
right? Okay. So right here. Sure. Sure. Let's do that. May I publish 46, Your Honor?
You may.
Okay, if you could use the big screen and point out what you're talking about.
The blood specifically that I was speaking about on the arm, you can see right here. And as you can see these flow patterns, they're moving towards the hand. Well, that doesn't flow that way if the hand's out here. It can flow if the hand's here, but the chances are the blood's not going to fall onto the interior arm here. It's also not going to fall onto the leg. So you can't really look at one without looking at both of these. If you notice, there's a substantial lack of blood anywhere on this leg except for these 2 or 3 marks down here. But there's a large amount of blood deposited here. Whenever we talk about crime scene, we try to teach people, look for what's there. And sometimes it's very easy to see what's there. There's a laptop in front of me, but it's right there. We always say to them, what's not there? When you're talking about bloodstain evidence, it's very important to say what's not there. And what's not there is in this area right in here behind the knee. It's what we call a void. Well, if I got blood falling onto this leg, and I got it falling onto the lower part of my leg, and it's flowing this way, from the back of my leg to the front of my leg, stands to reason that it has to be in this position. Okay? So the blood in and of itself on the arm is one thing. When you combine with the blood on the leg and the wound from up here, two wounds, flowing down onto the leg, you'll see it hitting the leg, and you'll see it hitting the right leg and flowing this way. It's moving down this way. That's gravity. That's a large volume of blood and absorb it properly, but it's large enough where it's flowing down. It has to be in this leg. Now, what's not there? See where my pant leg is pinched in? It's hitting here, and it's hitting here. It can't get in there. That void is created because that leg is folded over. And ultimately, we also have what's called the contact transfer pattern. I don't know how to do this with this, but can you zoom on the arm? Okay, on the interior of that arm, you see the blood flow, and then you see this very noticeable line. And then you see faint coloration in there. That's the blood coming in contact, or the arm coming in contact. Somebody's wiping that blood. And what that is pant leg. Because we have a corresponding contact transfer on the pant leg. So he's down, he touches here, and at some point, he's going backwards. And you'll see that mark where the arm with the blood and the other blood on the pant leg, down in here and up in here by the pocket knife. As the body falls backwards, the arm brushes up against it and leaves that contact transfer, and he ultimately ends up on his back.
So, is it your opinion that the initial shots to Chad Littlefield's back, was he upright and standing?
I believe he was.
And, but after those shots, he ends up on his
I believe
knee.
he goes to one knee or both knees. But at some point in there, he also sustains a gunshot wound to his left hand. It's like just a little that way. Sustains a gunshot wound right here. Passes out, comes out right in the inside of the hand. And you can see the hand right here. Substantial amount of blood on the hand. Now, remember what I just said about gravity. When you have that much of a volume of blood, blood will flow. You notice that there's no blood. Again, what's there, what's not there? No blood up here. It's staying down towards the hand. So where's it going? It's going down. The hand is on the floor, or at some point comes in contact with the floor. And just out in front of his foot is the area I believe the hand touched the floor. He deposited the blood from the hand to the floor, and you can see 4 very distinct markings on the floor, which are consistent with a wipe or a swipe. Blood on the floor, finger passing through, and you see it's going backwards that way. You see at the back end of the blood stain right here? You see how it's thick right here on the front, but in the back end it almost feathers out, kind of like a paintbrush. When you get a lot of paint on it, you pass it across the surface. And now it's running out of paint, and all of a sudden, you know, you gotta get more paint on the brush because it's not covering it well. Same thing right there. That hand is going backwards. That hand came in contact with that floor, bloody and wounded, and went backwards. The hand came off the floor right there as he falls back. So we have evidence of him on his knees and falling backwards on both sides of the drawing.
Well, in between the shots to the back and and when he ends up on his back, and we have him on his knee or both knees, how do you have an opinion to address how it is that a shot was fired to the left side of his head that exited to the right side of his neck?
Are you referring to number 3?
Yes.
Well, there's several scenarios. The body could be bent completely forward, or he could have been on that knee, which we know he already is. Certainly he's on his knee at some point. All the evidence is there to tell us he's on his knee. And he turns backwards with that hand on. Almost turned backwards to see a threat, engage a threat. He's already injured at this point, if this is the case. Turns backwards, the hand came in the defensive position, takes a shot through the hand and sends it forward. At that point, he can take that shot right through the head. It would line up with the shirt, the shoulder, and everything while he's in this position. So he may have been shot while he's on his knees as well.
Sure. So, now, getting to shot, looking at State's Exhibit 205 again, we have bullet wounds to Chad, number 1, that entered in the top of the head and exited the back of the head.
Yes, sir.
And we also have bullet wound number 2, which is inflicted upon Chad just to the left of his nose, below his eye, and exited from his back left shoulder.
Yes.
Based on everything that you've synthesized from the crime scene photos and the other experts, have you formulated an opinion as to when those wounds were inflicted?
Yes, sir. We came up, as you look at that, I came up with 2 scenarios. Both of those scenarios engage would have Mr. Littlefield down on the ground in one of 2 positions. The first one is he's on his knees, as I just showed you, with the shooter out in front of him. At that point, Mr. Littlefield would have to expose his face to the muzzle of the weapon. To do that would mean he would be looking right up at his shooter on his knees.
May I approach Ryan?
You may.
Now, with your report, you prepared a diagram depicting the shots from the front, is that right?
Yes, sir.
Is that what you just described?
Yes.
Would it be helpful for the jury if we could have you use this graphic to explain that first scenario of how these shots were inflicted upon Chad Littlefield?
Yes, sir.
Your Honor, I'd offer State's Exhibit 356 for use by the witness.
I don't have any objection to it for that purpose, for demonstrative purposes.
State's Exhibit 356 is admitted for demonstrative purposes.
May I publish, Your Honor?
You may.
Now, I'm going to put 356 up on the screen, Mr. Ryan. Now, you prepared that drawing, right?
Correct.
And does that depict what you were just explaining to the jury?
Yes, sir. Under this particular scenario, like I just said, he would have to be almost showing his face or the front side of his body to the weapon. If that were to happen with the hard down angle of those shots, if he was on his knees, he would have taken one shot through the apex of his head, right through the top, and it would have exited right back here, right behind the head. The second one would have been just to the left side of his nose in his cheek, and it exited down by his shoulder. So it traveled downward and through the neck and out the back. Now, for that to have occurred, we would have the expectation of seeing other evidence. And what I mean is, both of these gunshots were perforating. By perforating, I mean passing through the body, entered and exited. When a gunshot perforates and comes out the other side, a lot of times it will take bone fragment, hair, tissue, and blood with it. A projectile is traveling at a very high velocity, but as it starts to hit, it slows down. They're also designed to deform and slow down. When they deform and slow down, that is designed that way. It's designed to release its kinetic energy. The problem is when it deforms, not the problem, but the design is when it deforms, it also does a substantial amount of tissue damage. As a result, what we would expect to see on both of those exit wounds is the projectile continuing on, maybe seeing a secondary impact mark if there was still enough energy in that projectile as it left the body to impact something.
You mean it hit something else on the outside?
Yes, sir. But more telling would be forward spatter. There's 2 types of evidence that you see specifically with blood that we look for with gunshot wounds. Back spatter, forward spatter. Back spatter, when the bullet hits a surface, it enters and blood will actually come back out. The analogy we always give is you jump into a swimming pool. The water displaces, the water comes back up. It's the exact same thing. The blood will come back out. But more pronounced than that is the forward spatter. As the projectile exits the body part, and quite honestly, regardless of the velocity that it exits, you'd still see some forward spatter. Now, if it's exiting with a lot of its energy still intact and speed, you can see a substantial amount. And if he's on his knee and he takes that gunshot through his face while he's on his knee, I would expect to see a substantial amount of forward spatter in the area often behind his final resting position.
Now, when you say forward spatter, that's in the, you mean forward in the direction of the bullet travel? Right?
Correct. It would have came out this way and traveled, as you're looking at the screen, right to left on both of them.
Looking at going back to State's Exhibit 38, which is a sort of a zoomed out view, where would you, is in the scenario, do you have Chad facing to the right on his knees?
Yes.
Scenario A?
Yes, sir. This is where his the contact transfer of the hand would have been, and had he been up on his knees, I would have expected to see some forward spatter back in this area and maybe a corresponding defect mark where a bullet may have hit a floor or hit something else. On both of those gunshots, we found nothing. There was nothing back there.
So you did not find spatter over there to the left of Chad that we see now?
No, sir, we did not.
All right, so that, now, going back to your scenario A, which is as you described on the exhibit here on 356, and this only depicts the head and shoulders. To get these angles like we have here from a shooter who is standing, and let's just assume we're talking about a shooter who is standing, haven't heard anything otherwise, what would have been the position of Chad's body to have taken these shots in this manner?
If he took it from the front, he would have to have been low, on his knee or both knees, maybe slightly leaning forward for one or the other. Keep in mind, though, there's two shots there. If it were to happen in this position, one shot impacted the body, especially if it impacted his skull, it would have rocked him a little bit. He would have moved. There would have been movement and maybe exposed the face. So what I'm saying is the head's not going to be in exactly the same stationary position for the both shots. One is obviously going to make you move a little bit.
So even if the shots are fired twice, the first one's going to affect the position of...
It should, yeah.
Okay. Now, did you come up, now you explained the weaknesses of this scenario, that being the lack, going back to State's Exhibit 38, that being the lack of blood spatter behind Chad's body.
Correct.
Now, did you come up with another scenario regarding those two shots to the face and to the top of the head, which you believe is more plausible?
Yes.
Could you explain that?
Well, as I previously explained, we're certain he was on a knee or both knees. We know that the hand touched the floor. We have him going backwards. Obviously, his final resting position is he's backwards, for one. And the other thing is we have the movement of already shed blood on his pants and his arm, and that contact transfer that shows us that while that liquid blood is present, there's that movement of him going backwards, ultimately falling to his back. From that point, the second scenario is that while he's on his back, face up or partially face up, he is shot in his face and through the top of his skull while laying flat on his back on the ground.
So that's after he's been shot twice in the back and dropped to his knee or knees.
And shot in the back of the head.
And then shot in the back of the head, and we have him, his hand bleeding, his left hand bleeding on the deck.
Correct.
And then we have blood flowing from the exit wound on his right side of his neck down his arm and onto his pants leg.
Yes.
You see evidence that at some point, with his legs doubled under him, he rolled back onto his back.
At some point, he definitely rolled to his back. The only question and difference between the scenarios is whether he was shot in the face while he was on his knee or whether he was shot in his face while he was on his back. But he was shot in his face at a very sharp down angle in relation to the head and back.
May I approach the witness, Your Honor?
You may.
I'm going to show you what's been marked as State's Exhibit 357. Is this another one of the depictions that you prepared in connection with your report?
Yes, sir.
And would it assist you in explaining scenario B, the one with him on his back, if you were able to use this with the jury.
Yes, sir.
Your Honor, offer states Exhibit 357 for demonstrative purposes.
No objection for that purpose.
States 357 is admitted for demonstrative purposes.
Now, may I publish, Your Honor?
You may.
Now, Mr. Ryan, now we've got State's Exhibit 357. This is the second scenario you just described.
Yes.
Now, comparing this to State's Exhibit 38, does that, the State's Exhibit 357 depict the final resting place of Chad that we see depicted in the photograph, State's 38?
Yes, sir.
Now, from where on this State's 357, where would the shooter be standing in order to inflict these two wounds in this manner?
Somewhere back in this area right here.
Now, if we believe the bullets travel relatively straight through the face, through the shoulder, and then through the top of the head to the back of the head, are these lines depicting the trajectory that those bullets would have been shot from?
Yes, those lines depict the flight path of the bullet before it impacted the body. Excuse me.
So if I, as a guy who's 5'11", I'm holding a pistol, could you sort of position me in this drawing until I intersect with one of these lines and determine that's where I was standing?
You could, yes. Yes, you could, depending on the position of your body. Again,
Now-
go ahead, I'm sorry.
Now, assuming we're dealing with a shooter who's standing up, it's clear he didn't lean down and shooting like this, down low, right?
Well, that could have happened. If he was that close, though, I would expect to see a substantial amount of gunshot residue pattern we didn't see there. So I think it was a little bit further back.
Okay. So you didn't see evidence that the gun was placed at the top of the head and fired?
Did not.
It was shot from further back?
I believe so.
But not real far back, because this line goes up
Correct.
in infinity.
Yeah, there comes a point if you follow that line back out into space where it's just not possible for the gun would be held up in the air, and and eventually it will become impossible. He can't reach. So it's going to be within an area where that individual or that specific height, depending on the position they were standing, whether it was a comfortable stance, whether it was low, but in that flight path right there.
Now, Mr. Ryan, you have said that you believe this scenario is more plausible.
I do.
Could you explain to the jury why you think this scenario of being shot while he's on his back is more plausible than the scenario depicted in States 356?
Yes, sir. From the beginning of the injuries sustained by Mr. Littlefield to this point, we believe there's only one scenario. The shot to the back sends him to his knees. He suffers those other shots, and at that point, when on the knees, there's a potential divergence. It's one or the other. The reason I think this particular scenario is more plausible is, one, the lack of evidence you saw in scenario A, the forward spatter or anything else behind him that we would expect to see. The other thing here is, at the shot that went through his face, bless you, the shot that went through his face, passed down through the neck and exited the area inside his shoulder, between his backbone and his shoulder. The projectile was there. In other words, it was a perforating gunshot. It passed through the entire body from front to back, but the projectile was there. It was present. And that is something that we call can be called a short exit wound. Sometimes it'll show very specific signs of a short exit wound. And what we mean is, if the body or the surface portion of the body where the bullet is going to exit is up against another surface, standing against a wall, laying on the floor. It could be something as believe it or not, as simple as a belt being tight around the body. If the bullet actually passes through and hits that item, sometimes it has decelerated enough and lost enough energy that when it hits that firm surface, which is in firm contact with the body, it will exit and stay right there. When Mr. Littlefield was moved, that projectile was right next to that exit wound. And it's very consistent with a short exit wound, which also is a very strong indicator that he was in that position when that bullet went through his face.
And any, what we would call blood spatter would be confined to that area underneath the body.
Yes, and after, as time went by, minutes go by, the head contains a large amount of blood, and the head will bleed. Even if the body is deceased, the blood will drain if the exit wound is in a place where it's low and it affords itself to drain. All of that forward spatter that would be expected even with the body in this position is not going to show itself. It's not going to be there. One, because the body is up against that shored surface, and two, because the draining of the head and the blood coming out of him at that point is going to pool and have this larger stain, and it will eventually overtake any other visible bloodstain evidence that may have been there. So that's why we don't see it, and that's why I'm inclined to believe that's the position he was in when the two shots passed through one through his face and one through the top of his head.
So based on finding the projectile and the blood stain patterns that you saw, is it your opinion this was in the position Chad Littlefield was in when he took those final two shots?
Yes, sir.
Now, you
Mr.
have
Nash,
also-
hang on, it's 12:15. It's time to take the lunch break. Remember where you are, ladies and gentlemen. We'll take a 1-hour lunch recess at this time. I believe we have food available once again, so let's try to be finished, get together, and reconvene at 1:15. Remember my instructions.
wounds in order to determine the likely trajectory.
Yes, sir. Sometimes we use, excuse me, articulating mannequins as a illustrative tool to show the flight path. And what we do is we put the points of impact and the points of exit on the mannequin as it's described by the medical examiner.
Now, did you do so in connection with those two head wounds of Chad Littlefield, which are depicted in State's Exhibit 357?
Yes, sir.
And, I mean, right here in front of us, we have covered up a mannequin. Is that a mannequin you prepared?
Yes, sir, it is.
And have you made it such that this articulating mannequin matches up with the final resting position of Chad Littlefield as depicted at the crime scene?
Yes, sir.
Your Honor, may we utilize the mannequin?
You may.
May the witness step down.
Yes, sir.
Now, Mr. Ryan, could you, if you want to, now that I've pulled this thing off, can you make sure it's in the position that it needs to be in?
Yes, sir. It's a foam cord mannequin.
Mr. Nash, we can go that way a little bit. Please, folks.
Okay, may the jury stand up, where we've tried to find a position for every seat, and it's almost impossible.
Yeah, if you can.
If we move it this way, then they can't see it, so. Okay. All right, Mr. Ryan, could you explain what you've done to prepare this articulating mannequin?
Well, as I was saying, this particular mannequin is a foam cord mannequin. We use it for illustrative purposes only. What we've done is we've created a body position similar to the position the victim, Mr. Littlefield, was found in on that deck at the gun range.
On that issue, I will show you States 43, which we discussed earlier.
Yes, sir.
Do you believe this appropriately approximates the position?
Yes, sir, with the exception of the arm over there, which doesn't seem to want to stay up in place, and the nature of the mannequin wants to swing the arm backwards. But really what we used this mannequin for was to depict the body flat or close to flat on its back, and specifically the two shots that were sustained to the head.
Your Honor, may I publish 43 for comparison purposes?
You may.
Okay, continue explaining how you then prepared. After you approximated the positioning of the mannequin, could you explain what else you did to prepare this mannequin?
Yes, so what I was saying is, for this particular item here is illustrative purposes only. And what we do is, we identified the areas that were impacted by the projectile and where the projectile exited based on the report that was forwarded by the medical examiner. So then what we do is we place the flight path rods in place, perforating the mannequin to the entry and exits as given to us by the medical examiner. And what we try to do is place the body in the best position that we can to reasonably be similar to what you see up there on the screen of the actual crime scene photo. See the head is slightly canted to the left. The thing that's important to remember is with any body, the body as a whole articulates parts of the body, a hand, an arm, a head, a neck. So to find the exact position the head may have been rotated, we can put the flight path rod in place, but one to the other, the head can be in slightly two different positions as each shot is delivered.
So one shot, whichever one of these two shots was first, would have affected the position of the head
It may
in
have,
being
yes.
aligned for the second shot.
That's right, it may have, yes. It's important to go back to what we were saying earlier to get him in this position. We already have 2 perforating gunshot wounds to the torso, where he was shot in the back. We have another one in the back of the head, through the shoulder, which caused all that blood that enabled us to get him to this position, to say definitively that he was in this position. And then we have these 2 shots, and that short exit wound, which I'm going to point to the flight path rod that depicts the gunshot wound to the face. That projectile was located beneath the victim and his shoulder.
Now, on that point, did it be found beneath the victim? I mean, it still would have been traveling with some velocity when it exited the victim's body, would it not?
Yes, sir.
So what, you've been out to that range, what is the decking made of that would have stopped that projectile?
I'm not sure what the brand is, but it's a composite decking. It's kind of strange, but I have that exact decking in my house. It's a gray colored decking, and it's made with a composition of plastic and wood. It's very resilient. It's very flexible. It's designed actually to hold more body weight with the supports further apart. But if the bullet struck right here, passed through, and decelerated enough, when it strikes that decking is more than sufficient to stop that bullet at that point. But every shot is different. So we can never say that that's always going to happen. But on this particular shot, it did happen. It hung right up in his clothing. But it hit that object that was behind the body, creating that short exit.
And that's one of the reasons you believe this is a more plausible position, because if he'd been upright or kneeling on his knees like this, would you believe that projectile would have gone on through his clothing and landed on the deck somewhere?
Well, the bullet, that's an excellent question. The bullet actually did go through the clothing. There was the hole in the clothing. So if he was upright and he created that hole in the clothing, it would have been gone. Or even if it decelerated, it would have been behind him. But it did break the clothing and stayed there, which is really telling us that he's in this position. It's right against that hard floor when that shot is administered. Now, with respect to the gunshot through the top of the head, there's 2 things that are possible at this point in this engagement. The shooter is positioned in an area right here, standing looking over the victim on the ground. And I say there's 2 possibilities right here. Mr. Littlefield is either already deceased or he's in distress. But either way, he's defenseless. He's in a defenseless position on the floor. At some point, the muzzle of the weapon that fired these 2 rounds is positioned slightly behind and over top of his head and discharged twice into his head. This particular one right here that exits the back of the head, if it's coming more at this angle, there's a possibility that it passes through, which it did, struck the deck and ricocheted, and it is possible it wouldn't leave a mark. That would probably be the case where the head might have been slightly off the deck, if that were to happen. We would have seen more of a short exit, or we would have seen some evidence of a short exit wound to the back, which we didn't see. So I'm more inclined to believe that he was not deceased at this point. He was in distress when that shot went through his head.
So his head likely was lifted off the decking at that point?
Or turned slightly to the side, one of those two. But we had no real identifiable corresponding defect mark, and we had no forward spatter out to the side from the exit wound, like I described before with that forward spatter. So I believe it may have been slightly off the deck, and that leads me again to believe that, at least for this particular shot, he probably was not deceased. Either one of those two shots have been identified as fatal.
Now, we see that the rods here are offset in direction to some degree. How would you explain that if the shooter, and this is a big assumption, I granted, if the shooter were standing in a single position, why would those two shots come from different trajectories relative to the head?
Well, it's important to remember that a shooter can be stationary, meaning his feet planted on the ground, but the gun may move. The weapon in the hand may move. The other option is he's standing, well, there's two things. He could be standing still and firing two shots, and the head could move. And the head may move as a result of the impact of a projectile to the skull, or it may move because the individual is not yet deceased and he has movement. Or it could be that the shooter moves, or the weapon moves. So there's variables, but there's very minimal movement. I mean, this is not far. When you look at this coming back, this particular shot here to the face, look where this flight path comes out. It's almost as if the muzzle is right over top of his face.
Would you expect, you described earlier, you have forward spatter, which is in the direction of the bullet passing through.
Yes.
Would you expect some spatter to come from that entrance wound toward the shooter?
That could happen, yes.
And with this being the source of the blood being at a low point, would you expect that to get high, or would you expect it to?
Well, that all depends on how far away the target surface of the blood may land on is. It's not going to travel very far with that amount of energy release. Back spatter from a handgun may travel back several feet, but what's going to happen is going to have a parabolic effect. It may come back out of that wound and may have enough energy to come up. As soon as it starts to lose energy, it's going to curve and drop down. So if there was back spatter that came out on anything, it's not very far away from it. It's going to be close.
And you wouldn't expect it to hit something very high.
No, if you were standing on top of it, maybe it'd be higher. But as the further you get away, when I say the further, a foot or two is going to make a huge difference. The parabolic effect is going to take place, and it's probably going to fall more towards, as you're standing there, I'd say your pant legs or your shoes or something like that.
I'll pass the witness.
All right, you may be seated. You may return to your seat.
May I please court?
You may.
Counsel. Mr. Ryan, I understand from your testimony that the position of the victim, the shooter, the variables, you've come up with a theory for some plausible scenarios, correct?
Yes?
And tell this jury what, if anything, that tells us about the state of the mind of the defendant at the time of the shooting.
Sir, I don't know that any specific piece of physical evidence.
Does it tell us anything about the state of the mind of the defendant at the time of the shooting?
I can tell you it doesn't tell me anything other than,
That's fine.
let me ask you.
No, that's fine. I'll pass the witness. Nothing further, Your Honor.
All right, you may step down.
May I approach briefly for
You may.
documentation?
Let me clear that quick.
You're on the state calls, Jason Upshaw. Recalls.
Chief Fire Manager still in or?
Yes, sir.
Seems like deja vu all over again for you, isn't it?
That's fine.
Chief, you already testified previously about the jail call recording and preservation system at the county jail,
Yes, sir, that's correct.
and that's still the case.
Okay.
And did you have occasion to assist us in retrieving a couple more calls made by the defendant in connection with, which include information relating to this case?
Yes, sir.
May I approach the witness, Your Honor?
You may.
Chief, I'm going to show you what's been marked as State Exhibit number 358, which is a DVD. Did you get a chance to listen to that DVD?
I have.
And does it include excerpts relevant to this case of a jail call made by the defendant on April 11th, 2014?
Yes, sir, it does.
And is it a approximately 2-minute excerpt from that call?
That is correct.
Have you listened to the entire call?
Yes, sir.
And does this include a true and correct excerpt of that?
It
We
does.
requested that you pull.
Yes, sir, it does.
Your Honor, we offer State's Exhibit 358, which has previously been screened by the court.
Make a 4-3 objection, 358, Your Honor.
Objection is noted in overruled finding. I'm aware of the contents, listening to that in chambers earlier this morning. The probative value of that exhibit is not substantially outweighed by the danger of unfair prejudice or confusion of issue. Admitted.
Thank you, Your Honor. Now, I'm also going to show you what's been marked as State's Exhibit 359, which purports to be a telephone call made by the defendant on May the 31st of 2013.
Yes, sir, that's correct.
Now, actually, is this a combination of a series of four sequential calls made by the defendant on May the 31st, 2013?
That is correct.
Now, a portion of this call has already been admitted into evidence, is that right?
Yes, sir.
And now that we're to this stage of the case, we've asked you to retrieve portions of the other 3 calls.
That is correct.
And have you reviewed all 4 of the calls in their entirety?
Yes, sir, I have.
And does this Exhibit 359 contain true and correct excerpts from those 4 recordings?
Yes, sir.
Your Honor, the State offers State's Exhibit 359.
Same objection, 359, Your Honor.
Same word. 359 is admitted.
May I publish these, Your Honor?
You may.
Now, just to be clear, Chief, State's Exhibit 359, the 2-minute call, that was made on April 11th, 2014.
Yes, sir.
Mr. Nash, did you say 358 or 359?
358. 358 is the April 11, 2014 call.
Yes, sir.
Press 1 para español o prima 2. Or enter the area. At the tone, say your name.
Eddie Routh.
Please wait while I connect your call. Your party has answered. Please hold for billing acceptance. Hello? Hello. This is an Infinity operator calling from. All phone calls are subject to monitoring and recording. You have $7.34. Hello?
Hey. I don't know, watching this thing, some kind of pig show or some shit, I don't know, it's just a big pig show, or Boss Hog, that's what it's called. These people are, I guess they're down like Grossback, they're here in Texas somewhere, I guess Grossback area. And they're, you know, trapping and shooting hogs and stuff, and they got a barbecue day. Partnered up with this black woman and this other black dude to cook barbecue or whatever, cook pigs. The black chick and the black cook went out with the old man to go get a pig out of a trap. And they were like, no. They didn't want to have nothing to do with it. And she's like, no way, that's where it comes from. He's like, yeah, this is where your meat comes from for your food at the barbecue joint.
Oh my gosh.
And then they butchered it up and everything. And cleaned it. She was freaking.
I'm trying to think where Grossbeck is. I think it's kind of down south.
That's, I don't know, I don't know what relation it is to here, but
Yeah.
I guess he's
It's
here.
like on the way to these
No,
stands.
he's here. It ain't that far. It's only about an hour away from Midlothian.
Now, just to be clear, Chief, that State's Exhibit 358, that call we just listened to, was made on April 11th, 2014,
That is correct, yes, sir.
and that's what we've called the Boss Hog Call.
Yes, sir.
Now, may I publish State's Exhibit 359, Your Honor? Now, this call is actually done about 10 and a half months before that Boss Hog call, right?
That would be correct.
May 31st, 2013.
Yes, sir.
That's after the defendant's been in the jail about 4 months.
That would be right.
The charges for this call will be an operator service charge of $1.25 plus an additional 50 cents for the first minute and 50 cents for each additional minute. Hello, this is a call at no expense to you from an inmate at
The Erie County Jail.
This call will be recorded and subject to monitoring at any time. To accept this call, dial 3. To refuse this call, dial 9 or hang up now. Thank you for using Infinity Networks. You may begin speaking now.
Now, one question before we continue publishing this. Is this a call to the New Yorker reporter?
Yes, sir, it is.
Hello?
Hello?
Hey.
Hey, Eddie.
How you doing, man?
I'm doing all right. Yourself?
Well, you know, it's morning here in Texas. I figured I'd wait till 8 until the sun came up good and bright on my ass, you know.
How's life? How things been going late?
It's good. It's been going good. You know, I've just been hanging out this morning. You know, I got up early and came across the concrete. Got me, you know, a warm cup of water and drank that for breakfast, and then, you know, read some letters and stuff like that.
Are you aware that your article came out on Monday?
Did it really?
Yeah, so we just put an issue in the mail to you. So you should be getting it maybe today or tomorrow.
I'm excited to read it.
Yeah. I think you know, your mom and dad and Laura were all very, very helpful, and Jen was all very, very helpful. Do you think about that day?
Did I think about that during the day?
Do you think about that day in February? Is that something that
I do, you know, it tore my fucking heart out when I did it. I don't know why I did it, but I did it. I feel so shitty about it. I guess you live and you learn, you know?
Can I ask you, in February, when you met Chris and Chad, what did you all talk about that morning?
You know, they didn't talk too much to me. They were real quiet. They like weren't answering me for a reason, I guess.
But so
I didn't even know Chad was Chad. I didn't even know his first name. All I knew he was Littlefield. And Kyle.
Well, they picked you up at your house, right? And you all drove from there to Rough Creek?
They did.
And so in that whole car ride, y'all didn't really talk about anything?
Well, I tried to, you know, they kind of answered me, they give me like a half-ass answer. And then, I think we were in Midlothian. Mr. Kyle was trying to hand me his cell phone. He said my girlfriend was calling. Well, I broke up with her that morning. You know, why is this bitch trying to call me again? I told her to get the fuck out. She was already reluctant to leave. Well, hey, get the fuck out.
Why'd y'all break up?
Well, I stayed up all night that night, and I don't know why I wanted to tell her to kick rocks that day, but I told her to kick fucking rocks. Well, when you say kick rocks, you know what I mean? We got river rocks in my driveway in Lancaster, you know.
But you had proposed to marry her the day before, right?
Well, you know, things change, you know, just like that overnight, you can change.
So, sorry, we're getting back to that day though. So Jen called on Chris Kyle's phone?
Yes, sir.
And she must have gotten the number from your mom, I guess, yeah?
Well, it was on the freezer. So I guess she obviously remembered it.
And when
I can't remember it.
That was on the drive, though? That was as you all were just leaving?
Yeah, that was when we were heading to the range. She tried to call, and I said, fuck that, I don't want to talk to her. I already stated my facts that morning, you know. Told her how it was. I got up early. I mean, I got up fucking early now. It was, I don't know, 4 in the morning or so. And, maybe even earlier than that. Started some coffee. Cooked myself a sandwich. Made a, bacon, egg, and cheese sandwich. And I asked her if she wanted anything to eat. And she was like, no, I'm good. She still ate a piece of bacon, you know. I guess that's how you earn your bacon, you know. Earn that fat back. That's what they call it. It's really on the belly. But you know where it comes from.
So as you all were driving after she called, then you didn't talk much the rest of the way, or you did a little bit?
Well, I mean, they just didn't want to talk, you know. We stopped at Whataburger and got us a bite to eat. And, I thought that was strange, you know. I didn't tell them I was hungry. They just pretty much like force fed me. I mean, I guess they didn't force feed me. I mean, I still ate, but I didn't ask them to eat. They just went through the drive-thru and pulled up to the first window, and I told them, aren't you tired of eating all, tired of eating all this other stuff and all this shit, all the shit everybody else is eating? And they're like, well, yeah. I mean, I don't know about you, but, you get tired of eating the same old shit day after day. Which, you know the Army and the Marine Corps have been fighting it out for fucking years now.
y'all kept driving and got to the gun range, and then what happened there?
We got out, and Chris, he was shooting the 45, and he handed me a 45. Well, okay, he handed me it was a Navy. I'm pretty sure it was a single action.
Mm-hmm.
And, or no, I guess it's a Cold Army. Go Army.
Mm-hmm.
And, the Army, he handed that to me, and I set it down, and I was like, nah, it's all right. Well, I picked up a 9mm, started loading the mag, I filled the mag, shot a magazine. He shot a magazine. Oh, okay, so we're shooting pistols here, huh?
Mm-hmm.
Okay. I guess that's pretty much saying duel, motherfucker, So I loaded up another magazine. It was the smell in the air that morning, it smelled like shit.
Mm-hmm.
And, that's when I had to take care of business, and then I took care of business, and then, I got in the truck and left, and, was fucked up, got back in the truck, put in a fucking deal, started heading north on 67, and, stopped at the Dollar General, trying to buy it was a Dr. Pepper, and then the line was out the ass, and I was like, fuck this. So I threw the Dr. Pepper down in our ass, and I got to Alvarado to my Uncle Jamie, or James, I guess you could say, Uncle James. And then, got sick. I remember the Mexicans next door, they just got back from the grocery store, and they're carrying in some groceries. And,
So do you still have 9mm with you at this point?
I did.
And so you all were both at the range and both shooting at targets about how far away?
Mine was at 25. I think his was at 50.
And you just then, did he say something to you, or did you just turn? I mean, what sparked?
What sparked it was, I kept looking at Littlefield, and I was like, what the fuck are you even doing here, man? I asked him a couple times, I go, hey, you gonna shoot? You gonna shoot? You gonna shoot? You gonna shoot? And he's like, no, I'm good. What are you doing? Is it a spectator sport? It's a shooting sport. You shoot. And that's what got me all, wired up. And I was like, this motherfucker, all he's doing is watching. He watched it.
Did you shot Chris first?
No, I didn't shoot Chris first. I shot him second.
And did Chris fire at you as well?
Oh, he was shooting right beside me,
Yeah, but did he? So you're standing there and you shot Littlefield, and then you turned and shot Chris.
Yes, sir.
And did Chris, after you shot Littlefield, did Chris try and come after you or shoot you or anything?
Well, it was like I started shooting, and he was just finishing a magazine. He just finished it, last shell. Jumped right out of the gun. I guess that's how he dropped the 45,
So he was shooting the 45, yeah?
Yeah, he's shooting 45. 45.
And
I guess I really should have picked up the 45, They work better. They got more weight.
Did you on the ride there that day, did you feel like, you came back and you said something to Laura, I think, that you couldn't trust them, and so, you had to kill them before they killed you.
Well, yeah, I mean, that's how I felt that day, That's how I was feeling.
And, you felt that way from the time, I mean, almost from the time they picked you up, that whole car ride, that's how you felt?
Oh, yeah. Well, I mean, there was other times, it smelled like, cologne, you know? It smelled like sweet cologne, and then it'd go being sour like a motherfucker, I guess it was love and hate, you know? It's smelling love and hate. They were giving me some love and hate. You can smell it when it's in the air, you know? I mean, don't you smell it? You're out there on the East Coast.
What's in there, though? Well, I don't know how that relates to what was, you know, you were smelling that, you smelled that when you were in the truck with Chad and Chris?
Yeah. I guess it really wasn't, I guess I was smelling myself, really. I was riding in the back seat.
So you went from your uncle's house, you went to Laura's house, and then from there, where did you go?
So, hey man, I went to the house after.
Chief, that call we just heard, Exhibit 359, that was May the 31st, 2013,
Yes, sir.
to Nicholas Middle, the New Yorker report.
That is correct.
Pass the witness.
No questions.
You may step down.
Your Honor, the state rests for rebuttal case.
What you say, John?
Does it stay closed also, Your Honor?
Both?
Depends on what's on, Your Honor.
That's fine, Judge. I'll call Dr. Dunn rebuttal.
Yes, Your Honor.
May I proceed, Judge? Just for the record, once again, state your name.
Mitchell Dunn, MD.
And are you the same Dr. Dunn that testified last week in this case?
Yes, I am.
And just to refresh the jury's memory, tell us a little bit about your educational background and where you work.
Just quickly, I went to medical school in Dallas, did a residency in psychiatry at University of North Carolina Hospitals in Chapel Hill. After that, I did a fellowship in Maryland, and then I took a job as the medical director of the forensic program at Terrell State Hospital outside of Dallas. I have a private practice in forensic psychiatry as well as general adult psychiatry, as well as my position at Terrell.
And you have 2 separate board certifications in psychiatry?
Psychiatry and forensic psychiatry, that's correct.
Let me ask you, you were present during testimony last week when Dr. Ramula testified from San Antonio, who is in the audience today, and I think also Dr. Price, who testified last week. Is that correct?
Yes, I was.
And they had each, well, Dr. Price is a psychologist and Ramula is a physician. Is that right?
Yes.
Judge, bear with me. My sinuses are killing me today. And you heard each man's, I guess, for lack of better words, diagnosis of what they think is wrong with Eddie Routh.
Yes, I did.
And your position is different than their position, correct?
Yes, it is.
So what the jury has to figure out is we have 3 different experts testifying to 3 different opinions in terms of their evaluation of my client who's on trial for killing Chris Kyle and Chad Littlefield. Is that fair to say?
Correct.
And I ask you to go back and look at the records carefully like you did in the past, the hospital records, and look at each diagnosis from Dr. Price and Dr. Ramula, and then come back and testify to some issues of rebuttal to challenge their position. Is that correct?
Yes.
And the first thing I ask you to do is, would you, just so the jury can have a definition once again of what schizophrenia is, What is schizophrenia?
Schizophrenia is a mental disorder that's characterized by some disorder in thinking, usually in terms of perception of reality. And it's an illness that's not caused by an intoxicating substance. You'd have to rule that out. And that is characterized by a number of different symptoms. You have to have at least 2 of 5 possible symptoms to make a diagnosis of schizophrenia. Hallucinations would be one. We talked about that before. It'd be these false sensory perceptions. Delusions or fixed false beliefs. Disorganized speech or disorganized behavior are 2 other types of symptoms. And then the 5th would be the negative symptoms that we've talked about, the kind of flat affect, the avolition or kind of lack of motivation, the general social withdrawal. Those are the 5 possible symptoms that we look at in terms of making a diagnosis of schizophrenia.
And how would one make a diagnosis for, Dr. Ramler's diagnosis is mood disorder. How would you make that diagnosis? How would you know someone has a mood disorder?
Well, there's so many different mood disorders, the most common being major depressive disorder and bipolar disorder. And there are certain diagnostic criteria that we look at in terms of making that diagnosis. If it's major depressive disorder, there are 9 different diagnostic criteria. You have to have 5 of those. If it's a bipolar disorder, then we're looking at whether somebody's also had a manic symptom or manic episode, and there's 4 of 7 diagnostic criteria. I believe that's the number. Don't hold me to that. But you have to meet diagnostic criteria in that regard. And then if you think it's a mood disorder secondary to some intoxicating substance, then there has to be the temporal relationship between the intoxication and that mood disorder. You can also have a mood disorder secondary to a head injury, for instance. So there could be a lot of different potential causes, or it could be secondary to some medication that was prescribed for you, and it could cause that type of problem.
Do the medical records, which when Mr. Routh went to different mental health hospitals, either the VA or Green Oaks or other hospitals, does a scientist deals, I guess a scientist in your field deals in behavioral sciences based on someone's thought process, but also deals in actual science. Is that fair to say?
Well, we're not talking about basic sciences. It's obviously a mental health issue.
More advanced science, mental health sciences. My point of my question is, does the evidence in the medical records support Mr. Routh having a mood disorder?
It's my opinion that a mood disorder is not the diagnosis that Mr. Routh has suffered from. Certainly there were times that the medical records indicated that he had some symptoms of a mood disorder, and oftentimes that was a rule-out diagnosis as well. But it's my opinion that the most likely diagnosis is schizophrenia.
Now, regarding the antipsychotic medication, Dr. Ramula indicates, and he testified under oath, that he believes the medication that Mr. Routh was taking was for mood disorder, and you disagree with that. Is that correct?
That's correct.
And help the jury understand why you disagree with that and how someone's dosage might start at a smaller amount but increase over a certain period of time.
Certainly.
Go ahead.
I understand why Dr. Ramula said that the Rebuttal was for mood disorder, because actually the VA records indicated that in the text. But each time that he was at the VA, he was diagnosed, if you remember, with both a mood disorder and a psychotic disorder, or one time it was a major depressive disorder with psychotic features. So he was always diagnosed both with the mood issue and with the problems with psychosis. And each time he was discharged on a separate mood stabilizing medication, Depakote. So if the Rebuttal was just for a mood disorder, there would have not been a reason to give him an antipsychotic medication. He was already on a medicine for a mood disorder, that Depakote. Dr. Ramula also indicated that he was given a dosage that was 1 milligram twice a day, which is a dosage that's normally given simply for a mood disorder, not for psychosis. But that's simply not correct. When the studies were done with Rebuttal for mood disorder, for bipolar disorder, the dosing was always, in those studies, 4 to 6 milligrams, except for on one occasion they started with 3 and then could go up. But there's also no difference in the dosing that is used for mood disorder versus psychotic disorder with Risperdal. So the idea that a lower dosage simply indicates that it's for a mood disorder, not for psychosis, is not accurate. A lot of doctors will start at lower dosages, such as 1 milligram twice daily, as Mr. Routh was on before, an increase in dosage. And that's simply to see if somebody responds at a lower dosage or to try to decrease the risk of side effects, and then dosage might be increased according to the symptoms that they're having. But the idea that you would delineate a mood disorder versus psychotic disorder secondary to the dosage of Risperdal is not consistent with what I normally see in clinical practice.
So there's no reason for a physician to give those two separate medications if the person just has mood disorder, is that right?
Well, they can be given, but it's not common unless somebody's still having significant and marked mood symptoms, for instance, continued mania, then you might add one of those agents. But if you look at the clinical record, the problem that he was there in the hospital for was not that he was, speaking 1,000 miles an hour and he was euphoric, or that he was markedly depressed. One time he did go in because of the suicidal threats, but the clinical records would indicate that the symptoms that the people were most worried about was this disorganized thinking and the paranoid delusional thinking, and sometimes there were some mood symptoms mixed in with that. So unless there was, continued marked manic symptoms, one wouldn't expect to add on an antipsychotic agent if there wasn't also psychosis.
Now, what is a delusion specifically?
Well, you've heard this definition before. Delusion is a fixed false belief.
And, I think we had examples last week of what that is, but give us one idea of a fixed false belief.
If I believe that I'm president of the United States, and you tell me, no, we have a president, and here he is in the newspaper, and I say, well, I'm sorry, that's the false president, I'm actually the president, then I've been confronted with, evidence to the contrary, and I still hold that belief with the same strength that I had before.
And Dr. Ramela's position is that patients that have delusions only have, well, let me start over. A patient usually only has one delusion, less frequently 2 and most 3. Is that a fair assessment of someone that's schizophrenic or has delusions?
Yeah, Dr. Ramela did testify that usually people only have one delusion, certainly no more than 3. And I'm simply not familiar with that concept. That's nothing I ever heard before in terms of either my training or what I've taught. I've been board certified in psychiatry and then had to be recertified twice, most recently last year. I've never heard of that concept. And I can tell you that at the state hospital where I deal with people with schizophrenia all the time, we don't count their number of delusions. I have a number of people in the hospital with, more than 3 delusions, and we don't say, oh, it's more than 3, you don't have a delusion or you don't have schizophrenia. Frequently they do have 1 or 2 main delusions, but they may have several more than that, and that's certainly, not consistent with what I've heard before about mental illness or about schizophrenia.
An example would be his delusion about his neighbor being in the Mexican mafia. Would that be a delusion?
Yes, if he believed that his neighbor was in the Mexican mafia and, despite contrary evidence, he's continued to believe that would be a delusion.
And his co-workers at the cabinet shop being cannibals, would that be a delusion?
Yes, if he believed that. Now, nobody really confronted him with evidence to the contrary, but if he believed that, despite evidence to the contrary, that would be a delusion.
And he had a belief the night before the knife-wielding incident, his statements to his girlfriend about being a demon and a crack whore, would that be a delusion?
Right. If he believed his girlfriend was actually a demon and a crack whore, then that would be a delusion.
What about Dr. Ramela's basic feeling that, well, I guess to say Eddie's feelings were scattered and moving around meant that he had a mood disorder? Wouldn't that be inconsistent with someone who was otherwise schizophrenic in terms of that behavior?
Well, a mood disorder doesn't mean necessarily that your feelings are scattered and moving around. When I looked at the interview, it seemed to me that Mr. Routh's thoughts were scattered and moving around, that there wasn't really a whole lot of feeling that was in there. It was, you know, pretty flat in terms of affect. So I just didn't think that that was an actual accurate representation of what we were seeing in the videos that we saw.
Now, Dr. Ramley kept saying that if he's intoxicated, the game's over. Just as a matter of fact, like, hey, that's it. That's just the way it is. Tell me how you feel about that. What was your evaluation of that specifically?
Well, Dr. Rambula is right in that if somebody is having their mental illness simply secondary to voluntary intoxication, then you can't end up pursuing the not guilty by reason of insanity plea. But just because somebody's intoxicated doesn't mean that the game is over. If the mental illness is not secondary to that intoxication, if somebody's been drinking, yet they have significant psychotic symptoms that would qualify them for the not guilty by reason of insanity plea, the game is on. It's not that the game is over. And so if you're saying because of my intoxication, that's why I have this mental state, that's why I have the psychosis, then I would agree with him. But you don't stop just because somebody's intoxicated. You then, you know, evaluate whether that intoxication was what was caused that mental state. I don't believe Mr. Routh was actually intoxicated at the time of the offense based on a lot of things that he did, shooting tragically but accurately at the victims, driving 105 miles, after that not having an accident or anything, and you know, not having slurred speech or other kinds of things that we associate with intoxication. But even if he was, that doesn't mean the game is over unless that intoxication actually caused that mental state.
And I think Dr. Ramley stated, everything comes from the brain as actions speak louder than words. Express your professional opinion about that.
Well, I mean, actions are important, obviously, but words are important too. I mean, we're psychiatrists, so we evaluate people on what they're saying. What they're saying usually indicates what they're thinking. And I believe what's more important was during that interview with Officer Briley, he wasn't able to put his thoughts together. He was really all over the place, and his thinking, you know, was quite scattered. His you know, if he was trying to put together or, you know, get a message across, he wasn't doing a very good job at all. And so I think, you know, the words are important. That's how we go about evaluating people.
And basically, also, Dr. Ramley testified that the interview that my client gave with Ranger Briley was basically a red herring. It was inconsistent with any mental illness. What's your position on that?
I thought that interview with Ranger Briley was really the best kind of real-time evidence that we had regarding his mental state at the time. There was an hour or so of interview, and then you got to kind of watch him beforehand, a little bit afterward. And to me, that wasn't the red herring. That was what showed the way his mental state actually was. And I can tell you this, as much time as I've spent with people with schizophrenia, I couldn't have done what Eddie Routh did if I was trying to fake mental illness, if I was trying to purposefully get something across. The capacity to, you know, answer those questions in such an unusual manner, I couldn't have done unless I was reading off some type of script, because he really, you know, was asked a question, and then sometimes the very beginning of it might be in response to the question, but then he kind of went off in another way entirely, off on tangents. And people who are able to think clearly, I don't think they can replicate that at all. So to me, that was the very character of mental illness there. That wasn't a red herring. That was Eddie Routh in his state on that day.
The jury heard the video and heard the audio and saw the video. Could you, just for the juries to refresh their memory, what did Eddie Routh, in that crazy state of being psychotic and schizophrenic, say to Ranger Briley specifically? Some of the things he said, do you have that in front of you?
I have a transcript here.
Could you just, not all of it, just read specifically what he said so the jury can recall in their mind how he was acting that day?
If you remember, Dr. Rambula had said that he thought that Mr. Routh was kind of setting up a possible insanity defense because when he was back of the police car, he said something about, I've been paranoid and schizophrenic all day, am I going to the insane asylum? And then he's in custody of the police and he goes to the Lancaster police station, he's waiting, and we watch him there, you know, waiting, he's got his head down on the table and he's kind of walking around. And if that was the case, and I would think during that time he would really be putting together the opportunity to, you know, really present his idea, to say, you know, officer, I'm really crazy and this is what I was thinking. But instead the officer walks in, the very first thing that Mr. Routh says, and I'm quoting here, everybody knows there are right things to do, you know what I mean? The right thing and the wrong things to do in the world, there are certain things you got to start doing. Seriously, I just hope my mom and dad aren't too late. Why is this world, why didn't we see it coming before? So that's not the message of a guy that's trying to set up an insanity defense. That's the guy who's just kind of talking about what's on his mind. And then the officer says to him, we'll have to talk to these guys about doing that stuff. After he asks about getting the handcuffs off, and he responds, me too. I'm trying to find out more about the world that I've been living in too. I never knew I was in this deep. When I was looking at those computer screens, when I was in Iraq, I never thought I was. I never thought I was. I mean, you look at those computer screens, it doesn't make sense to you at the time, then you realize what's happening, you know, it's like astonishing, you know. So here's his opportunity to kind of present his case, and he's not making a whole lot of sense. He's talking about something about the computer screens that made sense to him, but doesn't make sense to us. And that's the character of schizophrenia. That is the disorganized thinking that you heard me testify about last week. And I think the evidence is here throughout. I'm not going to necessarily quote everything, but if he was setting up the insanity defense, I think you would have heard that. I don't think he's smart enough to know that the character of mental illness is disorganized thinking. I mean, most people, you know, they're going to say, officer, I was hearing the voices telling me to do such a thing. We didn't hear that from Mr. Routh. We heard this.
And based on your practice, I mean, you are a person who actually sees real patients in real hospitals. Is that correct?
Yes.
Not to go anything that's privileged, how many patients do you see on a weekly basis?
I have 30 on my unit, and I do consultations, maybe 5 or 10 more, so 40, and then in my private practice, I might see, 8 to 12 on Fridays.
How many, not to disclose anything that's medically privileged, how many folks do you treat with schizophrenia on a weekly basis?
Probably 2/3 of those people have either schizophrenia or something we call schizoaffective disorder, so 20 to 30.
How many folks do you treat on a daily basis with a drug-induced psychosis?
We don't have any.
How many folks do you treat in the hospital with a mood disorder?
Maybe on a weekly basis, maybe 5 to 10.
Now, Dr. Ramley talked about that Routh changed the description of the killings from killed when he spoke to his uncle to murdered when he spoke to his sister. Does that carry any weight at all?
Not for me.
In
I
your
think,
opinion?
no, I don't think so. I think he's just using 2 different words that he thinks mean the same thing.
Ultimately, he said he had to take 2 souls before they took his soul, correct?
Correct.
And there's some implication that religion and other stuff like that, do you, based on your evaluation, Mr. Routh, and looking at the records and looking at all the investigation, do you believe he means soul meaning a person, or is that some analogy he's given to taking someone's life?
I think he means taking somebody's life.
Now, there's a testimony and evidence that Mr. Routh, after he shot these 2 men, left the scene in Mr. Kyle's pickup truck, and we don't need to hash all through that. We've heard 30, 40, 50 minutes of testimony about that. Based on what you see, does it appear to you that Routh is trying to get away and flee, or going to a place where he felt safe, and that'd be his house.
You're an object, that's gotta be based on speculation. There's no way he can know that.
Well, what does the evidence show you then? Where's Routh heading?
He went to his uncle's, he went to his sister's, he went to his house. I think he got his dog. He went to Taco Bell, he went to try to find a friend, then he went back to his house.
Now, there's some statements when Mr. Routh is in the back of the Lancaster PD car with Officer Salazar, and he uses the word about being paranoid and schizophrenic, and he's felt this way all day. What do you make of that?
I think he was paranoid and schizophrenic all day.
And so that's what he's telling the officers, hey, I'm paranoid and schizophrenic?
Yeah, this was a statement that Dr. Rambula indicated perhaps was a setup for an insanity plea, but, you know, he was paranoid, and in my mind he was schizophrenic, so he was simply stating the case as it was.
And we've heard today and the other day some phone calls that were intercepted by the law enforcement of Mr. Routh and his family, and Mr. Routh and Schmidl, the New Yorker magazine reporter. I guess 14 days after the date of his arrest, there's a conversation with Schmidl about talking to him. Did you go back and look at the records from the hospital regarding his dosage of medication at the VA, and if it increased, in other words, the milligram amount from Dr. Stock, I think his name was?
Yeah, Dr. Stock had increased Mr. Routh's dosage of Risperdal from 2 milligrams a day to 4 milligrams a day on January the 30th.
What does that help someone do that's schizophrenic?
Well, that's a more appropriate dosage for psychosis. So about 2 weeks before that phone call, his dosage had been increased, doubled.
Does that help folks change their behavior based on their medication?
Yeah, it's more likely that his psychosis would have been treated with that dose than with the lower dosage.
Go ahead.
If I can indicate that Dr. Rambula had said that it was unlikely that somebody's symptoms might improve after 2 weeks of medication, that sometimes it usually will take 3 to 4 weeks. But again, I don't think that's entirely true. I mean, we at the hospital will frequently see a response to treatment with antipsychotic medication, at least the initial response in 1 week. And if somebody hasn't responded within 2 weeks, we're either changing the dosage or changing the medication. We don't wait 4 weeks to see a response for psychosis. That doesn't mean that the full response will occur at 2 weeks, but we're usually seeing certainly a response of significant improvement, oftentimes by 1 and certainly by 2 weeks.
And I think Dr. Rambula talked about what's in evidence about what Eddie believed in terms of if Chris Kyle and Mr. Littlefield were going to try to kill him, he had to take them out first. I'm kind of paraphrasing that. Dr. Rambula said without more information, he couldn't testify under oath that that was a delusion. Was it a delusion that in Mr. Routh's mind that Chris Kyle and Mr. Littlefield were going to try to kill Eddie? Was that a delusion?
My opinion that was a delusion, yes.
And the state's trying to imply that, which would be really very tragic, extremely horrible, that Eddie took Mr. Kyle's life and Mr. Littlefield indirectly because he was jealous of Mr. Kyle's accomplishments in life with his family and the military, and it's kind of matter of fact, you know, I'm kind of jealous of what you've done, so I'm just going to kill you. Does that make any sense at all?
There was nothing in my interview or the clinical record that would indicate that jealousy was the motivation for this offense.
Now let's focus briefly on Dr. Price, who's seated behind the prosecutors. And I don't know Dr. Ramey, but I can state that I've known Dr. Price for a long time, and actually I consider him a friend of mine, even though I might not agree with everything he testifies to. The DSM-5, how long has, I know we had the DSM, I know what it stands for. What does DSM stand for again?
Diagnostic and Statistical Manual.
And as Ms. Starnes held up prior to her presentation, it's kind of a Bible for folks in the field of psychiatry and psychology, is that right?
Yeah, it's what we use for the basis of our diagnoses.
And when did the DSM-5 come out?
It was published, I believe, in 2014. It might have been 2013. I think maybe the spring of 2013.
Now, you heard Dr. Price's, and you also heard, first of all, he's testified that in the history of his practice, which has been for teaching for 40 years, been a psychologist for 30 years, in the history of his practice, he's only analyzed or diagnosed in his entire history 2 folks. I don't know, I'm not that good at math, 2 folks with the possibility or probability of having a drug-induced psychosis, and more specifically, marijuana. The first one was last year. The second one was, well, maybe last year, year before last. The second one was this year. Did you go back and look at all the medical records to determine if you believe that my client had a drug-induced psychosis, most specifically with marijuana?
Yes, I did go back and review the medical records.
And more specifically, what is your scientific diagnosis of that, not just some opinion?
It's my diagnosis that he does not have a cannabis-induced psychosis, but rather that he suffers from schizophrenia.
What did the DSM-5 say about marijuana-induced psychosis specifically?
I'll actually read here. Cannabis-induced psychotic disorder may develop shortly after high-dose cannabis use and usually involves persecutory delusions, marked anxiety, emotional lability, and depersonalization. The disorder usually remits within a day, but in some cases may persist for a few days.
Now, there was an incident with, Jennifer Weed. Also, prior to the incident, I think Mr. Routh went to dinner with her parents. Is that right?
Right.
Was there any evidence of any drug usage, marijuana consumption at all during that time frame?
No. She picked him up from Lancaster on January the 17th, and then that night he was very frightened, scared. On the 18th, though, he was fine and went to dinner with her parents and reported that there was no problems at all, no evidence that he had smoked marijuana during that time. So no evidence of psychosis then.
And did anything unusual happen the next day?
Well, actually, that night, he was terrified. He thought that he was going to die. He told her that I'm going to be dead when I wake up. And
that'd be a delusion in and of itself if you're dead when you wake up, wouldn't it?
yes, it would.
I mean,
but that was a delusion he was having, that he was
Yes.
he was going to die that night. He was absolutely terrified. And then the next morning was when he had the knife wielding incident with the ninja sword. Again, without any evidence that he had smoked marijuana just before that. So if there's no evidence that that incident was related to marijuana use at all, but it was clearly one of psychosis. He ends up going into the hospital, and then while he's at Green Oaks, admitted that day, he actually goes in with a diagnosis of psychotic disorder, NOS, and
NOS is not otherwise specified.
not otherwise specified, right? And then the doctor who's seeing him, Dr. Eric Swafford, indicates that he's going to place him on order of protective custody because he thinks he's still psychotic. And in fact, he changed his diagnosis from psychotic disorder, not otherwise specified, to undifferentiated schizophrenia. So
Now, wait a minute. What does that mean specifically?
Well, we talked about, kind of rule out diagnoses before, rule out psychotic disorder and NOS. Dr. Swafford decided during that admission that because Mr. Routh's psychosis had actually worsened, he talked about him having worse behavior. He intimidated a nurse, that this was not some type of drug-induced psychosis or worsening, or something that cleared up after, a period of a day. This was a worsening of mental illness, and he determined that it was undifferentiated schizophrenia. In DSM-5, we don't use the subtypes anymore. That's why you haven't heard me talk about undifferentiated schizophrenia or paranoid schizophrenia. But back in early 2000, that's why you haven't heard me talk about undifferentiated schizophrenia or paranoid schizophrenia. But back in January of 2003, we were still using 2013, we were still using the DSM-4, which did have those subtypes. And Dr. Swafford also indicated that the urine drug screen was negative, meaning that there wasn't any positive findings on the urine drug screen. So that was the first time I'd caught that when I went back and reviewed those records. But at least that's what was entered. And he determined that it was schizophrenia, not a psychotic disorder NOS. And he planned then for the transfer to the VA hospital.
And folks with drug-induced psychosis, or schizophrenia, you saw the behavior in the police car, how Routh was acting calm. If folks that are under some type of drug-induced psychosis, don't they act anxious, or their behavior is not that calm, is it?
Right. As I read to you, usually these people are markedly anxious if they have a drug-induced psychosis or a cannabis-induced psychosis. And, looking at him, both in the car and also waiting for Officer Briley, he wasn't agitated. He didn't appear to be terribly anxious. He was most anxious about, getting a cigarette and getting the handcuffs off, maybe seeing his parents. But that did not look like a cannabis-induced psychosis. I guess the other thing to note is that, we already talked about how rare cannabis-induced psychosis is relative to schizophrenia. And, with this episode at Green Oaks, he then got hospitalized at the VA, and he was there for 5 more days. And on the second to last day, the doctor is still writing in there that his thoughts are disorganized. So now, after the 2 days at Jen's house, 2 days at Green Oaks, and then 3 days at the hospital, we're at 7 days. His thoughts are still disorganized. We know from reading the DSM that usually those symptoms remit after 1 day, may last a few days. So we're talking about the rare exception to a rare event, whereas schizophrenia occurs commonly.
So the explanation for that would be he's schizophrenic.
That's my belief.
And when folks that are have cannabis-induced psychosis or drug-induced psychosis, in a hospital setting, don't you have to sometimes strap those folks down? They'll try to pull up on those leather straps to try to get up and scream and yell. I've seen it before. I mean, that happens, doesn't it?
The use of restraint nowadays is incredibly rare. We try to avoid that at all costs.
And I mean, in the past, that used to be the case. Is that right?
Yes, sometimes in the emergency room with somebody who has a drug-induced psychosis, they do have to strap them down. It rarely happens in a hospital setting because they clear, usually within several hours or a day or two. Certainly would be the farthest out, but not several days later.
Is there anything else you'd like to explain to the jury why you believe this was not a marijuana-induced psychosis or cannabis-induced psychosis specifically?
The fact that he would have periods where he was relatively calm and then would make his delusional statements. The fact that when he was at Gin Weeds before that incident and he hadn't smoked yet he got psychotic, I think is clear evidence that he has an underlying psychotic illness, that his episodes of psychosis are not related to the cannabis.
I'll pass one to Sean.
Starting just 2:35. It's a good time for the afternoon break at this point in time. Not an overly long one. Let's take an afternoon recess for about 15 minutes. For 2:50. All right, you can be seated in the courtroom. Mr. Starnes, you may proceed.
Thank you, Your Honor. Good afternoon, Dr. Dunn.
Good afternoon, Ms. Starnes.
May I first order, Your Honor?
You may.
You said that the defendant wasn't positive for THC or positive for drugs on the January 2013 Green Oaks admission, right?
That's what Dr. Swafford's notes indicated, yes.
Will you take a look at these? Those are records from Green Oaks.
Yes, I see it.
From the January 19th admission.
Correct.
There's several pages in front.
I see.
In fact, the defendant was positive for THC during this visit.
Yes.
And in fact, he admitted that he was a user of marijuana, hashish, THC.
Yes.
And so that was incorrect when you said he wasn't positive during that admission.
Right, Dr. Swafford's note was incorrect.
Okay, so the records do show that he was positive for THC, for marijuana during that admission.
On that urine drug screen, correct.
So that would be every hospitalization that the defendant's ever had, he was positive for some sort of cannabis product, whether it's marijuana, hashish, whatever form he's smoking it in.
Yes.
And in fact, every hospitalization he's had is either precipitated by him being very intoxicated or committed some kind of violent act.
Yes.
And he commits a violent act, and he goes to the hospital often.
Well, there's an exception. The incident where he thought he had a tapeworm, I don't think there was any violence or threat at that time.
Right, so that one though was the one where he said that he had been smoking marijuana that was possibly laced with embalming fluid, right?
Correct.
And then there was you've seen the records, there was a DWI where he came out saying, I'm a veteran with PTSD.
I heard that testimony.
During that arrest. And so that often, you understand about cause and effect, when people have kind of learned behavior. If you do something and you get one result, then it wouldn't be unusual to try and do that again.
Correct.
And just to be clear too, on those VA records, it wasn't just psychosis, it was psychotic NOS.
Correct.
And I think we went over that the other day. That basically means we can't really tell because there's something interfering with the diagnosis, probably alcohol or drugs.
Sometimes it's that, right? Sometimes they just haven't done enough of a history.
But it means kind of we're not sure.
Correct.
I mean, and you work at a hospital, you understand that that's often kind of the shorthand though at the hospital for this person's intoxicated and we got to wait till they dry out or sober up till we make an accurate diagnosis.
Sometimes that's the case.
Now, during the, I think you had made in your testimony, you said something about the one time he went in for suicidal threats. Are you talking about the fish fry incident?
Yes.
Okay. And it was more than just suicidal threats. He was making homicidal threats to his family as well.
That's correct.
You were talking about the different delusions the defendant had. You talked about the one, his neighbor maybe was in the Mexican mafia.
Yes.
That's one of the ones that he had.
Correct.
I mean, that doesn't have anything to do with Chris and Chad, his neighbor being in the Mexican mafia.
That's right.
Or believing his neighbor's in the Mexican mafia.
Correct.
So Chad and Chris were not incorporated into that delusion.
Correct.
And then he had a delusion that his coworkers were cannibals. And again, that doesn't have anything to do with Chris and Chad.
Correct.
They weren't incorporated into that delusion. You classified him calling his girlfriend a crack whore a delusion. That sounds more like just an insult, doesn't it?
The basis of that was apparently he believed he saw something in her room or there was a crack pipe, and she said that there was no such thing. So he was misinterpreting some type of stimulus as being the basis of that belief.
Maybe she did have something. You don't know that for sure, do you?
You're right, I don't know that for sure.
And then you talked about you don't think he's intoxicated because of the way he carried out the crime. Was that kind of the way he did the shooting? Is that what I heard you say?
I said, yeah, that to me, that would be at least an argument against him being intoxicated at that time, because he, did tragically yet accurately fire the weapon and then drive the 105 miles.
Right. I mean, you were in the courtroom this morning when Howard Ryan was testifying.
Yes.
And so you understand that we're not talking about, more than, say, 20, 30 yards. We're talking about within feet of each other.
Yes.
So it might be easy, even if I'm not a very good shooter, I could maybe hit a target at, less than 10 feet.
Perhaps you could.
And somebody maybe even intoxicated could hit something at fairly close range, particularly if they're a trained, skilled marksman.
Yes.
And then driving 105 miles without an accident, I mean, you certainly have heard of tolerance.
Yes, I have.
And so people who are regular drinkers and regular consumers of marijuana would be expected to have some degree of tolerance, wouldn't they?
Yes.
And so you were talking about, I think there was something that Dr. Price actually had said, and it sounded like you were agreeing that if a delusion or the illness is secondary to intoxication, then the person can't come in and claim insanity. In other words, if they have cannabis-induced psychosis, that would not be insanity.
Right. If the psychosis is secondary to their cannabis induction, then in Dr. Raymond's words, the game is over.
And you're aware that the DSM-5 says for substance or medication-induced psychotic disorder, that it can actually, the symptoms can persist for a substantial period of time, for example, about a month.
Not for cannabis-induced psychosis. Sometimes we'll see that with methamphetamine-induced psychosis, particularly thought disorganization, but the DSM-4 says that in cannabis-induced psychosis, that usually remits within a day and may last for a few days.
Can I approach the witness again?
You may.
I'm just going to show you this. This is substance medication-induced psychotic disorder.
Right. This is a general description of a substance-induced or medication-induced psychotic disorder, but what's specific to cannabis is what I read previously when I was doing the rebuttal.
So this doesn't specifically say not cannabis.
No, but page 114 does, where I read from.
And then, but, yeah, do you have that there?
Yeah, it's right here.
Can you read it?
Sure.
Having sounded really good 13 days later.
Cannabis-induced psychotic disorder may develop shortly after
Hold on a sec. Can I ask you, I thought you said you're on page 114
Yes, that's where I am.
of the 5?
Yeah, the hardbound edition.
Oh, okay, you're on a hardbound edition.
You want me to find
You
it
can
for
only
you?
afford the paperback.
I can find it for you if that would
Okay.
be, you'll need to bring
Sure.
that up here.
Let me bring it to you.
That's it. So, right here. It is page 114 for you also.
Okay. Tell me what you're reading from here.
So on page 114, the second paragraph, the fourth line at the end, cannabis-induced psychotic disorder may develop shortly after high-dose cannabis use and usually involves persecutory delusions, marked anxiety, emotional lability, and depersonalization. The disorder usually remits within a day, but in some cases may persist for a few days.
Okay. And so, high-dose cannabis use, persecutory delusions, marked anxiety, emotional lability, and depersonalization. Okay. Usually goes away within a day, but can persist for a few days.
Yeah.
And then you heard the other day, we have the defendant on the phone about 13 days after he's arrested, and he sounded markedly different than he did the night of February the 2nd, 2013.
Yes, he did.
Yeah. I mean, just because something is rare doesn't mean it doesn't happen, does it?
That's correct.
I mean, plane crashes are rare, but they happen.
Right.
Right? Capital murder is rare, but it happens.
Object, Judge, that's improper.
Overruled.
Right.
Something else that you said something about the defendant's comments about looking at computer screens in Iraq. Were you aware that that's part of an armorer's job, that they might be looking at something that's going on the outside on a computer screen?
It doesn't surprise me. I simply thought it was odd that he was mentioning that when the ranger came in to speak with him about the offense.
And you talked about, the number of people that you treat that have schizophrenia, and these are people that are in the hospital.
Correct.
And of course, they're not people in the hospital with drug-induced psychosis, because once they're sober, their psychosis goes away, right?
Right.
Now, you were saying something about the defendant going, you don't think he was fleeing because he went back to his house? Is that what I was understanding you to say?
Actually, on the rebuttal, I didn't make a mention of the term fleeing. I was just asked to describe where he went, and I said that he went from one place to another and ended up back at his house.
Okay, and he got his dog, he went to Taco Bell. We don't really know what order that happened in, right?
Right, but when he appeared back at his house, the dog was already in his
Right, so he had gone to the house to get his dog. Perhaps he forgot something. We don't know that.
Right.
Right? You don't know that.
I don't know that.
But certainly, the jury saw on the video, he flees from the Lancaster police from the front of the house.
He takes off, yes.
And certainly, just because a crime doesn't make sense or is a senseless crime doesn't mean the person was insane.
Correct.
I think we talked about that the other day. There can be many other motivations for somebody to commit a crime.
There may be.
Even if they're mentally ill, they might have something that's unrelated to their mental illness, right?
Right.
I think we went through some of those. I mean, you don't think it's jealousy, but it could also just be anger or frustration, or they're irritated, or they're just having a bad day.
Those can all possibly occur when crimes occur, right?
Even if somebody's mentally ill, they can still be mad at somebody.
That's right.
They could still be irritated by someone.
They may.
They could be offended by somebody.
Yes.
Now, there are instances, certainly, where the defendant has either lied to you or lied to other people. You've seen that throughout the records, haven't you?
Yes.
In fact, he lied to you when you met with him on April, was it the 14th or the 15th?
I'll have to check. I think it's the 15th, but I'll check. April the 15th.
Okay, so on April the 15th, it's when he told you that he didn't smoke marijuana that morning of February the 2nd.
Correct.
But it sounded like when you testified the other day, you were agreeing that that wasn't consistent with everything else you heard.
Right.
So he lied to you about that.
He did.
And then he, apparently, according to everything else we've seen, he lied to family members about his experiences in Haiti, about dead babies and piling them up in mass graves and that kind of thing.
Yes, again, I questioned as to when that might have been and whether it was secondary to psychosis, but certainly what he told was not the truth.
And then he told Dr. Arambula, I know I've told other people differently, but I really did know I was going to a shooting range. So he lied at some point about whether he knew he was going to a shooting range.
Yes.
And we talked about the other day the fact that you know this from your forensic experience, when somebody is facing a serious felony charge, particularly something as serious capital murder, they have a different motivation than somebody who's just coming to you as a treating physician.
Absolutely.
And so you're not so naive to think people don't lie to you when you're doing a forensic exam.
Correct.
Right. I mean, would you say that the defendant is an accurate historian given how many times he's lied about certain things?
No, I would not say he's an accurate historian.
And I mean, that's a term that y'all use in your profession. Somebody's not an accurate historian.
Right, that's kind of an unusual term, but it means, do they, accurately tell what happened?
I mean, the bottom line is they might tell one story to one person, they tell another story to somebody else.
Right, that would be an inaccurate historian.
It's sort of a polite doctor way of saying somebody's a liar.
Sometimes it's that, sometimes it's confabulation or dementia. It could be practically anything. It didn't indicate the motivation, just that they're not telling the same story consistently.
It just means they're not truthful for whatever reason.
Right, but again, if we use that in dementia, we don't use that in terms of truthfulness. It's just that they don't tell the same story each time.
Right, I mean, you're not saying the defendant has dementia, though.
No, I'm not. I'm just trying to clarify the term.
But it could just be a plain old lie.
Right.
And so the defendant tells you the story about the pig assassins and the hybrid pig people, people turning into half pig, half human.
Yes.
And you were in here and you heard that he just, 3 days before that, he's on the phone talking about watching this show, Boss Hog.
Right.
That has to do with pigs.
Yes.
Has to do with hunting pigs.
Correct.
Barbecuing pigs.
Yes.
Heard the other day that their main character is called Pigman.
I did.
Did you go over the weekend and look anything up about that show?
I did not.
Did you look up anything about the Seinfeld episode about Pigman?
No, I didn't.
Did you go and look up the Twilight Zone episode where everybody looks like a pig except the attractive woman? It's called Eye of the Beholder.
No, I didn't look that up.
Have you seen that before?
No, I haven't.
I mean, there's plenty of stuff out there in TV or media, movies about pig people. Right?
Right.
And
From what you said.
Let me ask you this. If Eddie Routh were a deaf and mute person and couldn't tell you that he was having this delusion about pig people, where would you get that? I mean, how would you determine that, whether he was having that delusion?
If he couldn't communicate to me at all, I wouldn't know.
If he couldn't communicate to you about whether he knew his actions were wrong, how would you know that? Would you be able to look at his actions and tell that he knew what he did was wrong?
No, I wouldn't be able to.
You don't think that's possible, to look at someone's actions and tell that they knew what they did was wrong?
No, in some cases, you certainly may. But based on what he has told us, I believe that he did not know that.
And you've already said, though, he's a very inaccurate historian.
Yes.
And you heard this morning, well, actually, it was early this afternoon, when we played again that 13-minute or so conversation with the reporter from the New Yorker about the crime. You heard him discuss that.
Yes.
He kind of discusses it in pretty elaborate detail, doesn't he?
Yeah, he's pretty descriptive.
And that was, 4 months after the crime happened.
Right.
Nothing in there about hybrid pig people or people turning into pigs.
Right, nothing about pigs.
In fact, he didn't say he was afraid of these men until the reporter reminded him, didn't you tell your sister that you felt a fear of them or threatened by them?
Correct.
We asked you the other day, you understand that what is the legal definition of wrong when you do a forensic examination of someone for sanity?
By case law here in Texas, it's illegal.
Okay. I mean, you understand that people can commit violent acts and crimes that might be unrelated to their mental illness.
Absolutely.
You understand that the law requires that it's as a result of their mental illness, and that for them to not know that their conduct was wrong.
Yeah, I'm quite familiar with the definition.
Okay. And I think we went over a bunch of things the other day about things that he either told you or actions that would indicate that he knew what he did was wrong.
We went over the things he told me, yes.
Are you aware of a VA record from January the 30th, 2013?
Yes,
You
Dr.
know what I'm
Stock.
talking about?
Yes.
And then there's actually, now I think you said something at one point about the dosage of Risperdal. And so he was increased to 2 milligrams
2 milligrams twice daily, correct.
on 130.
Yes.
Have you ever prescribed that dosage of Risperdal to a patient?
Many times.
For what?
Psychosis.
2 milligrams.
2 milligrams twice daily, yes.
Okay. For anything
Common
else?
dosage.
For anything else?
I said common dosage. I believe I've used that for bipolar disorder, although that would perhaps be 1 or 2 times.
And that's a mood disorder?
Yes.
And now, I thought though, I had heard you say 4 milligrams was more appropriate for psychosis.
2 milligrams twice daily is 4 milligrams.
Okay. And then, but actually the defendant has been on 2 milligrams for a long time, hasn't he?
2 milligrams twice daily, yes.
And have you ever prescribed that dosage for anything besides psychosis?
I told you I may have prescribed that dosage for bipolar disorder a couple of times.
But that's because the majority of the people that you see are schizophrenic.
In the state hospital, the majority have psychotic illnesses, schizophrenia or schizoaffective disorder, as I testified.
Right, so I mean, that's the majority of the people that are in your, under your care or that you see in your private practice.
Risperdal is not usually a first choice medicine for bipolar disorder.
But it can be used for that.
It can be used, and they have received approval for that.
May I approach the witness, Your Honor?
You may.
I'm going to show you this note from 130 from the VA hospital, so you kind of know what I'm talking about. You have that in your record somewhere?
Yes, I do. This is actually not from 130. This here, that's an addendum from March the 12th.
Right, but they're talking about the 130-13 visit.
Right, yeah, Dr. Stock's visit.
Right, so you know what I'm talking about.
Yes, absolutely.
So this is another doctor, Dr. Westhafer, talking about the Dr. Stock visit on 130.
Yes.
And you realize that this doctor says that the defendant, as of his last appointment on 130, his thought process was identified as linear. He was fully oriented to name, date, location, and situation, right?
Yes.
His behavior was cooperative with fair eye contact.
Yes.
Insight and judgment were fair.
Right.
He has no noted suicidal or homicidal ideation.
Right.
There was no symptom of mood disorder. I'm sorry, while he did have possible symptoms of mood disorder, possibly mixed bipolar disorder, which were addressed.
What do you mean, which were addressed?
It says he did not have symptoms of mood disorder, possibly mixed bipolar disorder, which were addressed.
I think he means by increasing the Risperdal.
and then it says, while previous diagnosis includes psychosis NOS, there was no noted evidence of hallucinations, delusions, or other symptoms of an active thought disorder on 1/30/13. It says that, right?
Yes, you have that note. I don't have that note, but I'm actually looking at Dr. Stock's note that he's quoting from, so I know what he's referencing.
Be happy to show it to you.
It's okay.
Okay, I mean, you believe that it's in there?
Yes,
There are lots of records.
there are.
And so, we know though, between 1/30/13 and 2/2/13, the defendant smoked marijuana, drank alcohol on February 1st, right?
Yes,
And he also smoked marijuana and drank alcohol on February 2nd.
correct.
Now, going back, talking about the Risperdal, the defendant was actually on 2 milligrams of Risperdal per day for about a year before the date of this crime. Right?
He'd been prescribed that. He had stopped taking it for a decent portion in 2012.
Okay. But that's what he was on up until 1/30 is when they increased it.
Correct.
Okay. And now, you didn't go to Green Oaks Hospital and talk to Dr. Swaffer, did you?
I did not.
So you don't know the reason why he put down the diagnosis he did?
In the note, he indicated that psychosis was worsening.
What? Well, you actually said that he intimidated a nurse. He actually threatened and kind of assaulted the person, didn't he?
It appeared that he backed her up into a corner or something of that nature. So you can use the word intimidation, you can use the word threatened, but his behavior was certainly frightening to her.
Right. But you didn't go and sit down in person and talk with Dr. Swaffer?
I did not.
Do you know how much time he actually spent with the defendant?
I do not.
Would it surprise you if he said 10 minutes one day and 30 seconds the next?
No.
I mean, that would be about typical for a hospital that busy.
In the psychiatric emergency services, that wouldn't surprise me.
And would it surprise you if he said that a lot of his diagnosis was based on the defendant's age?
Well, that was a very typical age for schizophrenia. If that's what he said, then that wouldn't be surprising.
Would it surprise you if he said he wanted to make sure the defendant went to the VA hospital and wasn't back on the street?
That wouldn't be a surprising thing to hear.
Because he knows that the defendant is being put there for this threatening incident with the knife.
Correct.
And so you were incorrect about him not being positive for THC on the January 19th hospitalization.
You're right. I saw that in the note, but I was definitely incorrect about that.
I mean, and certainly you weren't with the defendant and Jen Weed around the time of that knife incident.
I was not.
Right. You're basing it on either her telling you the truth or the defendant telling you the truth about that.
Yes.
And you said he's not an accurate historian.
There's certainly evidence that he told one thing to one person and another thing to another person.
There's lots of it.
Yes.
Pass the witness.
Very briefly, Your Honor. So, you heard Dr. Price indicate that my client Eddie has average intelligence.
Yes.
And so his indication and what you read in the records about Jen being a pig hybrid, and is that a delusion?
It's my opinion that that is a delusion, yes.
And you've been asked questions about when you examined with respect to my client Eddie Routh, is that right?
Yes.
That was on April the 15th of 2014?
Yes.
So he's pretty darn smart to know that you're going to come see him on April the 15th, 2014 when he's being interrogated by Texas Ranger Briley on February the 2nd, 2013, didn't he? He's pretty brilliant, isn't he?
He did make mention of pigs and pig excrement on that day.
I guess he had some great revelation that a physician who's an expert in the world of psychiatry was going to come see him. He could talk about pigs. So you remember when he told Briley, well, I keep talking to Chris, you know, I keep talking to Chris's in the world. Every time I talk to another man named Chris, I get sent another man named Chris. I think about talking to the wolf, the one in the sky. I think about fighting through war, you know. The ones in the sky are the ones that fly, you know what I mean? The pigs in the world can truly say that they're pigs. He's pretty darn smart to figure out you're going to come see him over a year later.
I don't think that's why he said that stuff.
I've been smelling it this whole time. I'm just tired of, pardon my French, everyone's fucking bullshit. I can smell bullshit and pig shit, you know. I can tell the difference between two different kinds of pig shit. He's darn smart, isn't he?
That would be one interpretation.
I don't know how you can smell your shit. I'm not saying nobody's shit's stinking, but shit's stinking, you know. So all this surmised by the state of Texas that they want to think he has some great pig revelation in April, he was pretty darn smart to know that you're coming to see him over a year later, wasn't he?
I think he was psychotic on February 2nd, 2013.
I approach the board, Your Honor.
You may.
So let me make sure we understand, at the time of the conduct charged, my client, as a result of severe mental disease or defect, did not know his conduct was wrong. Do you agree or disagree with that?
I agree.
So was he schizophrenic?
Yes.
Was he psychotic?
Yes.
Did he have some mood disorder that caused him to take the life of these two fine men?
I don't think it was a mood disorder.
Was he have some kind of psychosis induced by marijuana that caused him to take the life?
I don't think it was a marijuana-induced psychosis.
Absolutely.
He shot both of these men, shot one of them 6 times, and one either 6 or 7, depending on whether one of the bullets exited and re-entered, right?
Yes.
And he reloaded a 9mm weapon before he fled the crime scene.
Yes.
In fact, he used that word himself, I fled.
Yes.
And he didn't call the police for that 105-mile journey.
Correct.
Judge, I would suggest to the court this is beyond repetitious. Ask and answer. Object. It's not rebuttal to anything, Your Honor.
Overall limit.
Went to Taco Bell and even said he went there because he knew he was going to be arrested.
Yes.
Went and got his dog.
Yes.
Because he's not going to leave town without that beloved dog.
I don't know what the motivation was, but he got his dog.
That makes sense, though, that he loves that dog. He's not going to leave without it.
Right.
And then he got in that standoff with the police. He knew they were surrounding him.
Yes.
And then we see him peel out and go on a high-speed chase.
Correct.
And then we saw him get out of the truck with his hands up, and he complied with demands.
He did.
And then he told you it's a pretty shitty thing to do to kill someone.
Right.
He told you, I just shot 2 guys, that's terrible.
Yes.
He told you, it says in the Bible not to kill anybody.
Correct.
Asked if other people would understand what he did, he told you, I figured I'd be arrested.
Yes.
You know you're going to be arrested if you know you did something illegal, right?
You know you're going to be arrested if you've killed somebody. He would have to explain why.
He said, as he told you, as soon as I did it, I knew I'd made a mistake.
Yes.
He told other people things about fleeing and why he did what he did.
He also told people he had to kill them because they were going to kill him.
And so we have to believe him that he's telling the truth, though, to believe that, right?
Right. If you don't believe that he thought he was going to be killed, then you don't believe that.
And so the whole premise of him saying, you know, I thought I was in fear for my life, we have to believe that he's telling us the truth about that.
True.
Pass the witness.
Well, his perception would be his own perception, correct?
Right.
It goes to what he's believing at the time of the specific event. Is that correct?
Exactly.
And that's a question of fact for this jury to figure out, nobody else.
That's their job.
No further questions.
I have no further questions for Dr. Dunn.
All right, you may step down.
That's all the rebuttal we have specifically on it at this point.
Nothing further, Your Honor.
Stay close.
Yes.
We close, Your Honor. May Dr. Dunn be excused.
He may be excused.
Thank you.
All right, ladies and gentlemen of the jury, that's all of the evidence that would be presented in this trial. As we have talked to you about since the very beginning, you don't have to be a lawyer to be a juror in this case. The judge will prepare all the instructions you need. I cannot do that until I hear every bit of the evidence. So I've got to do that at this point in time. I promise to you, I've been working on it as we've gone. The attorneys have been working on it with me during these breaks, and we are nearly done. We need a short recess now that every piece of evidence has been submitted to you to make the final touches to that charge, to the instructions to you. We will get that squared away. When that is done, the lawyers will present their closing statements and you will be discharged, deliberate, and we're going to do that today. So if y'all just take a recess for a little while, get ready to go to work, because we're going to be back in a few minutes. St. John, Mr. Moore, and Mr. Isom. I have reviewed the proposed charge of the court in this matter. Are there any objections or exceptions to the court's charge by the state?
None, Your Honor.
By the defense?
Yes, Your Honor. We would object to, on page 3, that court's charge on the definition of intoxication and the statement that voluntary intoxication is not a defense to a commission of a crime. We would object to that being included in the charge.
All right, that objection is noted and overruled.
Well, you understand, we also, besides voluntary intoxication, we are requesting a inclusion in the charge, an instruction to the jury, according to the Code of Criminal Procedure, what the result would be should they come to a verdict of not guilty by reason of insanity, what the code provides for what would happen to the defendant if that was their verdict.
All right, I'm aware of that request. I will deny that request. In fact, the charge has the instruction, the counter instruction of that, and that is contained in paragraph 7. You may not consider in your deliberations the potential consequences to the defendant of a verdict of not guilty by reason of insanity, that being also contained within chapter 46C of the Code of Criminal Procedure. So that request is denied. Anything further?
No, Your Honor. May we be seated?
You may be seated. I was going to have the audience stand up because I'm fixing to bring a jury in anyway. Anything further by the state?
No, Your Honor.
Anything further by the defendant?
No, Judge.
All right, let's bring the jury in. All right, you may be seated in the courtroom. All right, ladies and gentlemen of the jury, the charge has been prepared. All requires that I read that to you at this time. As you're well familiar, I have an aversion to reading anything. I'd rather talk with people. But the law requires that I read this verbatim, and I'll do so. Before I get through with this and forget, I have an original. It's stamped an original. I've got 11 copies. The reason I don't have 14 copies, I've got 2 alternates, and I'll give you specific instructions. You won't need a copy until you're instructed to participate in deliberations. So the 12 jurors that were selected will have a written instrument before them during their deliberations for their use. Also, when closing arguments are underway, the attorneys have a limited amount of time to present those. So at various intervals in those, I'll be reminding them of time. Don't worry about that. That's a housekeeping matter for the court. Ladies and gentlemen of the jury, the defendant, Eddie Ray Routh, is accused of capital murder. The defendant has entered a plea of not guilty. You have heard all the evidence that will be produced on whether the defendant has been proved guilty. Both sides will soon present final arguments. Before they do so, I will now give you the instructions you must follow in deciding whether the defendant has been proved guilty or not. You will have a written copy of these instructions to take with you and use during deliberations. First, I will tell you about some general principles of law that must govern your decision of the case. Then I will tell you about the specific law applicable to the case. Finally, I will instruct you on the rules that must control your deliberations. The indictment is not evidence of guilt. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these instructions or these circumstances. The defendant is proved innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence. The burden of proof is on the state to prove the defendant is guilty of the indicted offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and believability of the witnesses, you must apply the law that is provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court in writing and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for your examination. Certain testimony can be read back to you by the court reporter if certain requirements are met. To request that testimony be read back to you, you must follow these rules. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, states that it is requesting that testimony be read back, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during your deliberations. However, you may not share your notes with the other jurors, and you should not permit the other jurors to share their notes with you. You may, however, discuss the contents of your notes with other jurors. You shall not use your notes as authority to persuade your fellow jurors. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the lawyers. Notes are valuable as a stimulant to your memory. On the other hand, you might make an error in observing, or you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of what the evidence was during the trial. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said had he taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. During the trial, you have heard evidence that the defendant may have committed wrongful acts not charged in the indictment. The state offered the evidence as proof of the defendant's motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, as those factors relate to the offense charged in the indictment. You are not to consider evidence of such wrongful act unless you find, beyond a reasonable doubt, that the defendant did in fact commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the offense charged. In other words, you should consider this evidence only for the specific limited purpose I have described. To consider this evidence for any other purpose would be improper. The law requires that you render a verdict of either guilty or not guilty by reason of insanity. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. A person commits the offense of capital murder when he intentionally or knowingly causes the death of more than one person during the same criminal transaction. Criminal transaction means a continuous and uninterrupted chain of conduct occurring over a very short period of time and in a rapid sequence of unbroken events. A person intentionally causes the death of an individual if the person has the conscious, objective, or desire to cause that death. A person knowingly causes the death of an individual if the person is aware that his conduct is reasonably certain to cause that death. Intoxication means a disturbance of mental or physical capacity resulting from the introduction of any substance into the body. Voluntary intoxication is not a defense to the commission of the crime. You are instructed that you may consider all relevant facts and circumstances surrounding the killing, if any, and the previous relationship existing between the accused and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the killing in question, if any. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about the 2nd day of February 2013 in Routh County, Texas, the defendant, Eddie Ray Routh, did then and there intentionally or knowingly cause the death of an individual, Christopher Scott Kyle, by shooting him with a firearm, and did then and there intentionally or knowingly cause the death of another individual, Chad Hudson Littlefield, by shooting him with a firearm, and both murders were committed during the same criminal episode, then you will find the defendant guilty of capital murder as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of capital murder and say by your verdict not guilty. It is an affirmative defense to prosecution that, at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong. The term mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The burden of proof is on the defendant to prove an affirmative defense of insanity by preponderance of the evidence. The term preponderance of the evidence means the greater weight of the credible evidence. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Eddie Ray Routh, committed the offense of capital murder as alleged in the indictment, but further find by a preponderance of the evidence that at the time of the conduct charge, the defendant, as a result of severe mental disease or defect, did not know that the conduct was wrong, then you will acquit the defendant and say by your verdict, not guilty by reason of insanity. However, if you find from the evidence beyond a reasonable doubt that the defendant, Eddie Ray Routh, committed the offense of capital murder as alleged in the indictment, and you further find the defendant has not proved by preponderance of the evidence that the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong, then you will find the defendant guilty of the offense of capital murder and say so by your verdict. You may not consider in your deliberations the potential consequences to the defendant of a verdict of not guilty by reason of insanity. You must follow these rules while deliberating and until you reach a verdict. After closing argument by the attorneys, you will go into the jury room to conduct your deliberations. Your first task will be to pick a foreperson. The foreperson should conduct deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the court, all jurors must follow these rules. You must not discuss this trial with any court officer or the attorneys or anyone not on the jury. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. You must not conduct any independent investigations, research, or experiments. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proved guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. That's been filed of record as of this afternoon. I have attached to the back a verdict form. This verdict form sets out in the top paragraph, we the jury find the defendant Eddie Ray Routh guilty of the felony offense of capital murder as charged in the indictment. It has a place for the signature of the foreperson. The second blank, we the jury find the defendant Eddie Ray Routh not guilty, also has a signature blank. The third sentence, we the jury find the defendant Eddie Ray Routh not guilty by reason of insanity, also having a signature blank. It's one signature on this verdict page, and that's for the verdict that the jury returns. I have read the court's charge at this time to the jury, and I will allow the state to make closing arguments. The defense will have an opportunity to make closing arguments, and the state will have an opportunity to respond. Ms. Starnes, you may proceed.
Thank you, Your Honor. We started this process, about 2 weeks ago? And if you recall, we promised you all that if you sat on this jury, you would end up knowing way more about this crime than anything that's going on outside these doors, or that's in the media, or in the paper, or online. You all would know more about this crime than anybody. And I hope that you agree that that's correct. You know by now that it's unfair and it's inaccurate to just call this the American Sniper trial. It's unfair because while Chris Kyle was phenomenal at his job, the true measure of a man is way more than what he does for a living. The measure of a man is more than just his job. Chris Kyle was a father, a son, a brother, a husband, and he was a friend. But you also know that to call it the American Sniper trial is inaccurate because it wasn't just one person that was killed out there at Frog Creek Lodge, it was two. Chad Littlefield, while he wasn't famous, he never wrote a book, didn't have a movie made about him, he was also a father, a husband, a brother, and a son, and a friend. He was Chris Kyle's friend. 2 people were killed out there at Rough Creek Lodge. 2 people were murdered. And that's what makes it capital murder. And that's why we're here today. Chris and Chad were friends to each other, and they made it a mission in their life to be friends to other men in need, to be friends to veterans, to men that needed to go outdoors, do guy activities together, feel the therapeutic value of being outdoors. And if you're into guns, that's therapeutic to you. But don't you know that that friendship that they had for each other and that compassion and friendship that they were showing to men like Eddie Routh, and including Eddie Routh, is ultimately what cost them their lives? Don't you know that that need for compassion, that need for friendship, that instinct to show that friendship and compassion to men, caused them to override any kind of sense of self-preservation? Don't you know that that need to be Eddie Routh's friend that day is what made them override any kind of little, if the hair on the back of their neck ever went up, their need to be his friend overrode that instinct. Because don't y'all know by now that somewhere along that ride out to Rough Creek Lodge, Eddie Routh let his true colors show, let his freak flag fly to some degree. We don't know what he said, if it was that comment about Whataburger or something else he said along the line, but he said something that caused Chris to send Chad that text, "This guy is straight up nuts." And Chad wrote back, "He's right behind me, watch my 6." We don't know what was said that caused them to say that. We also don't know that they're not kidding. Well, we all know that texts and emails and that kind of thing sometimes don't, if you look at it in black and white, you don't see sarcasm or humor in that. We don't know what they meant. But don't you know that anybody who's met Eddie Routh, if they drove by and saw him out there driving his VW Beetle painted by a ladybug, saw him out there working on it, how many people do you think said, "That guy's a nut"? How many people do you think saw Eddie Routh at the store wearing Jen Weed's clothes and her pink Argyle socks and said, "That guy's nuts"? Probably a lot of them. But don't you know, whatever went on in that truck on the way to Rough Creek Lodge, it wasn't so alarming or scary that Chad and Chris said, "Hey, Eddie, I just got a text from my wife. My kids had an emergency and we got to go back. We got to go, the kid's going to the hospital. We got to abort this trip." That was never said. And it certainly wasn't so alarming that they didn't get to Rough Creek Lodge and then just say, "Let's leave the rest of these guns in the truck and just shoot the handguns." No, they got out all the guns. It certainly wasn't so alarming that they didn't put a loaded gun in Eddie Routh's hand. But we're not here to blame Chad and Chris for their deaths. We're here to blame and hold accountable the man that put 12 or 13 bullets in those 2 men. That's what we're here to do. We're not here to fix the VA system. We know that that's a screwed up system. We can't fix that here in this trial. That's not what we're here for. We know that the healthcare system for the mentally ill is not perfect. We all know that. We know that mental illness is scary and it's disruptive and it causes a lot of problems in people's lives, and it's very real. That's not our job to fix that whole healthcare system today. What is our job today? We've spent the last 2 weeks, you people have disrupted your lives and gone out of your way to give Eddie Routh a fair trial. And we've sure done that. You all have certainly done that. Your job today is to follow this oath that you took when you became a juror on this case. And to follow that oath, all we're asking you to do is take the 9 days of evidence that you've heard, the 9 days of evidence that you've seen, the law that Judge Cashin has given you in this jury charge and look at that evidence, look at the law, and then just follow the law and let that guide you to your true and correct verdict. Now, we told you at jury selection that it's always going to be the state's burden of proof to prove to you that the defendant committed the offense of capital murder. That's our burden of proof beyond a reasonable doubt. Did he do this? Did he commit capital murder of these two men? Well, there's not a whole lot of debate about most of these elements. I don't think there's any disagreement that this is February the 2nd, 2013. I mean, we know that's the day that they died. They were found out there at Rough Creek. But let's go through some of these. We know that it happened in Routh County because you remember Deputy Keith Martin, who works for Somerville, he says he knew as soon as he passed that little rock cottage there and you get up to the lodge, that's Routh County. He had passed into Routh County. Frank Alvarez told you that. He's the general manager. He pays the tax bills. He knows that where this happened out at the range is Routh County. There's no dispute about that. Well, we know it's the defendant. He's the one that did the murders. I mean, how much more clear could it be? We see him driving his victim's truck, getting out of his victim's truck, holding his hands up. This is not a whodunit case. We know he shot him with a firearm. Well, there is the .45 that he killed Chris with. And there's the 9mm that he shot Chad with in the door pocket of Chris's stolen truck. We know it was the same criminal episode because there they are, dead at the same time, found dead at the same time. They were alive and breathing, just who knows, within an hour or so before they were found. Let's talk a little bit, though, about the intentionally or knowingly aspect of a murder. Now, y'all remember back from when we did jury selection, throw out anything in your mind about premeditation. That is not part of Texas law. That's California law or some TV law. We don't have that. There is no requirement in Texas that we prove any kind of crime, even capital murder, was premeditated. We have to show that he killed these two men intentionally or knowingly, and that's it. And you remember when we talked about in jury selection, intent can arise in a minute. Something can happen, but what is going through his mind when he pulled the trigger on that gun, pointed at those men, and pulled the trigger? What was he thinking? Well, you know that it's not an accident, it's not a mistake, it's not reckless to shoot Chris Kyle 6 times. And Chad, either 6, according to Howie Ryan, that one went through the back of his head and then into his shoulder. Dr. Bernard was counting that as 7. So he shot Chris 6 times, and he shot Chad 6 or 7 times, depending on if you think that one re-entered or not. But that was deliberate, that was calculated, and that was cold. That's not any kind of accident or mistake or being reckless. And what did he do? What was the timing of all this? Well, the defendant, even according to him, what he told various people, he waited until Chris's gun was spent before he started shooting. He waited for the opportune time. What does that tell you about his intent to kill these men? He waited for the opportune time. And how did he shoot him? He shot Chad in the back. Twice, at least. Shot a man in the back. And then quick succession, he shot Chris in the back of his shoulder. That's the one that goes through his spine, through his aorta, and caused massive bleeding. He shot him in the face. That's the one that went through his spinal cord. And in quick succession, he shot him in his shooting arm. You know, why can the skilled marksman not shoot back? He's shot and broken his shooting arm. And you heard from Dr. Bernard and Howie Ryan that this man that was this awesome, skilled marksman who survived 4 tours of duty in Iraq and came home unscathed, died face down in the dirt at a luxury resort shooting range, bleeding to death. But you also heard that Chad's death was not as quick. That after he shot Chad in the back, he then shot him in the back of the head. And you know that from the evidence of Chad being shot in the hand, that he had to have seen at least one of those shots coming and shield his face from that gun. And you know that Chad was on his hands and knees, bleeding, when he reached out and ran his fingers through that pool of blood. And then you know that as Chad lay dying on that ground, on that shooting deck, that he went around and he shot Chad in the top of the head and in the face, not to prevent him from getting up, but to finish him off. He didn't just want Chad dead. He wanted Chad dead, 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 dead. And he wanted the same for Chris. What did he tell Dr. Rambula? If you're mad at Chad, why couldn't you just kill Chad? Because he knew if he did that, Chris would come after him. Chris would kill him. So he had to kill Chris too. And then what does he do? After he kills these 2 men and leaves them bleeding to death at Rough Creek Lodge, he stands over Chad's body, or right near it, on that deck, and he reloads that 9mm, puts 15 bullets in that magazine. And you saw when Mr. Jeffries was here, how long does that take to put 15 bullets in that magazine? And he reloads it. Why is he reloading it? What does he need a loaded gun for? For a shootout later with the police? He took that one because it was a trophy. That's the one that has the Navy insignia on it. And then he stole Chris's truck and he flees the crime scene. He wasn't just conveniently going somewhere else, he was fleeing. He had to get away from this bloody mess that he had just left out there at that shooting range. He even used this word when he was asked later, "What did you do?" "I fled." What does that tell you? Then he went to his sisters and he said, "I just committed a murder. I'm in too deep. I'm going to run to Oklahoma to get out of this mess," that bloody mess that he left at Rough Creek Lodge. Then he goes to Taco Bell for his last free world meal of 2 burritos. Got his dog that he loved, because you know he's not going anywhere. He's not going to go to Oklahoma or leave town without that dog. He got in the armed standoff with the Lancaster police while in Chris Kyle's stolen truck. He got in a high-speed chase. Oh, and then he confessed. Confessed to Ranger Briley, confessed to the New Yorker reporter Nicholas Schmidl. He confessed to Deputy Gene Cole. Remember what he told him? "I shot him because they wouldn't talk to me." Oh, and if that wasn't enough, we also have scientific evidence linking him to the murders. Most tellingly, we have Chad's blood, Chad's DNA on the defendant's boot. And what does that tell you? Remember when Howie Ryan was testifying? He's standing over Chad, shooting him in the head, and you saw him on that video how he tucks his pants into his boots. He's got Chad's blood on his boot. So to know whether or not this defendant committed this capital murder, what are we doing? We're looking at his actions and we're looking at his words. And we have overwhelming evidence that he has committed this capital murder. We have proved to you beyond a reasonable doubt that he committed this capital murder. Way beyond it. we showed you that he did it in a cold, methodical, calculated way. It was awful, it was bloody, and it was a senseless crime. But just because something's a senseless crime doesn't make a person insane. So now we'll go to their burden of proof, is to prove to you that he was insane at the time of the murder. Remember, we don't have to prove that he was sane. They have to prove that he was insane. And if you're going to, and it is a preponderance of the evidence, and I'll give you that. It is a lower standard of proof than did he do it. But what have they brought you? Have they met their burden of proof? No, they haven't. Because remember when we talked about during jury selection, if you were going to take a human life, if you were going to stop a beating heart of another human being, then you have to fit this very narrow definition of what is insanity under Texas law. It's not just part of it. It's not like Dr. Dunn wants you to do and just, oh, well, he has this, and let's ignore all of that. It's all three of these things. It's all three parts of that definition. That's what you have to squeeze through, that narrow definition, to avoid criminal responsibility for taking the lives of two other human beings. Who do they bring you? They brought you his family members, his employer, his girlfriend. They brought you Dr. Dunn. And I'll give you that Dr. Dunn has credentials as a qualified psychiatrist, but he seems to want to ignore the great weight of all the evidence and all the common sense. And to him, it seems like it all stops if you believe him that the defendant is schizophrenic. And he wants to ignore everything that shows by everyone's common sense that the defendant knew his conduct was wrong. He was wrong about, Dr. Dunn was wrong about a lot of things. He sat there and told you, oh no, he didn't test positive on that January 19th hospitalization. Yeah, he did. I showed it to him. Okay, he made a mistake. Who do we bring you though? We brought you two extremely qualified expert witnesses, Dr. Price and Dr. Arambula. And Dr. Price has been at this 30, 40 years. He's board certified psychologist. He gave the defendant over 10 tests there at the jail. He spent over 10 hours interviewing the defendant. He's been a college professor. He's been at this for years. We then brought you Dr. Arambula, who is a board certified psychiatrist, a board certified forensic psychiatrist. He's also has a doctorate in pharmacy and has actually practiced as a pharmacist before he went to medical school. And he's the president of the Texas Medical Board. Guys who know what they're talking about. Very credentialed men. And he also spent over 3 hours talking to the defendant. And what do they tell you? Well, Dr. Price tells you that the defendant is just a naturally suspicious person. He's got paranoid personality disorder. That's just part of who he is. He's suspicious about people. He's one of those people that thinks somebody's always trying to do him dirty. Oh, and then add to that, though, extremely heavy marijuana use, alcohol, frustration, frustrated with his life. I mean, who wouldn't be frustrated if you lived his life? He had a fight with his girlfriend, jealousy, irritation, feeling slighted, and what happens? He murders Chris and Chad. And Dr. Price tells you that he has what's known as cannabis-induced psychosis. Yes, it's rare, and we're not talking about, some reefer madness. You use one joint and you go, cannabis-induced psychosis. We're talking about somebody who uses a whole lot of marijuana regularly. Yeah, he has some mental problems, but they don't rise to the level of severe, according to Dr. Price. But the bottom line too, for Dr. Price, is the defendant knew what he did was wrong. First of all, his cannabis-induced psychosis, like the name implies, is a psychosis caused by voluntary intoxication. And so he can't then get over here and say, oh, well, I can claim insanity. Why? Because voluntary intoxication is not a defense. If you ingest something, a mind-altering substance, and you go and commit a crime, you don't get to say, well, I wasn't, I have an excuse. I was intoxicated. You can't say that. And you also then can't make yourself become with psychotic symptoms because of heavy marijuana use and alcohol, and then say, oh, well, now I'm insane, because it was caused by the voluntary intoxication. The bottom line is the defendant knew what he did was wrong, according to Dr. Price. And then he's setting up his defense, like he's done many times before. He commits a crime, he does a violent act, he gets wasted out of his gourd, and he goes to the mental hospital. And that's what he wanted to see happen again, the night of February the 2nd. He was setting up his defense. And then he comes up with this preposterous pigman hybrid pig story that he tries to sell to Dr. Dunn, and apparently did sell to Dr. Dunn because he fell for it hook, line, and sinker. And you reasonable people of Routh County know that that story about the hybrid pigmen and the pig assassins is a load of hogwash. Then Dr. Rambula came and told you that, first of all, he does not have a severe mental illness. He's got some mood disorder, probably some depression. And he was voluntarily intoxicated. Game over. It's all intoxication, according to Dr. Rambula. But, just in case there's still a question, Dr. Rambula tells you that he knew what he did was wrong. And he's faking it. As you remember, he used the term secondary gain. People lie to get out of trouble. They don't lie to get into trouble. And every lie that Eddie Ray Routh tells is him trying to get out of trouble. So let's go through what is some of the evidence that he was voluntarily intoxicated. We know, we heard it from all these kind of people, even his friends and family, even his sister. This is a family where it's their culture. They're marijuana smokers. Jen Weed told you that he smoked a lot. Everybody says that about him. What do we find at his house? We found this little tin with the pipe in it. Remember Uncle Jamie? He said, oh yeah, that's the pipe we smoked out of that morning. We smoked a couple of bowls out of that pipe. He even took a whiff of it and said, yep, that smells like marijuana to me. And he should know, he told us that. He's been smoking it since he was a teenager. And then what did the defendant tell Ranger Briley? What's in the bong? Some pot? What else is in it? Well, it's probably laced up with something else. You can't trust anything here in Texas. It's usually laced up. What would have been laced with? Probably some of that wet, which you heard is either PCP or formaldehyde. What do you mean by that? Well, it could have been anything. I mean, don't you know that's the nature of street drugs? You don't know what you're getting when you buy something off the street. What was it laced up with? What kind of wet? What are you talking about? Maybe Purple Hearts? Maybe formaldehyde? This guy knows the drug culture. He knows the street lingo for drugs. We heard from Uncle James. They smoked a couple of bowls that morning in that pipe that he identified. Now, for some reason, he wants to say we might have drank some whiskey. I don't know why he wants to deny that, because Eddie tells everybody we drank whiskey that morning, and you saw that almost empty whiskey bottle on the table. What did he tell Dr. Dunn? He went through a lot about his history of substance abuse with Dr. Dunn. Significant history of alcohol abuse. In high school, he would smoke 2 to 3 days a week, used hydrocodone and Xanax, drank 30 packs with a couple other guys in the military, and then after the military, at least every other day would smoke marijuana with his mom and dad, sometimes a joint before dinner and one after. And he admits to experiencing paranoia when he smokes marijuana. Then what did he tell Dr. Dunn about the second? That he drank whiskey that morning? Oh, and then he denied smoking marijuana to Dr. Dunn, but even Dr. Dunn believes that's a lie. And then he told Dr. Price he smoked marijuana the night before, drank whiskey the night before, drank whiskey the morning of February 2nd. Again, he denied to him that he smoked marijuana that morning. I think everybody agrees that was a lie. I mean, the uncle came in here and told you, yeah, they smoked together. But then to Dr. Rambula, he got into great detail about his marijuana use, talked about how he liked the very potent variety of marijuana, the hydro. And he would get high with every additional smoke, and it would last 4 or 5 hours, and then when the effects would start to wear off, he'd reload. Talked about how he sometimes would go to work high, and it didn't affect him because he had such a tolerance. But then he told Dr. Arambula about February the 2nd that he was smoking marijuana with his friend, Greg Lindemood, his dope dealer, and they drank whiskey too, and Jen Weed tells you that too. That in fact, she caught him and Greg Lindemood the day after he got out of the VA hospital the week before, sitting around smoking dope and drinking with Greg Lindemood. He said he felt suspicious that night, and then he was writing the notes to Jen, hey, let's cook up a batch of pot cupcakes and we'll make money selling pot cupcakes. That doesn't sound like any kind of psychosis. That just sounds like a guy that's stoned. Drank more whiskey. But then that morning, he tells Dr. Rambula, he got up early, drank some vodka from the freezer, drank whiskey when his Uncle James came over, smoked some leftover marijuana, and then we know he smoked some more with his uncle. The guy's intoxicated. And remember, we're talking about 3 to 4 o'clock in the afternoon, after all of this going on in the morning, drinking and smoking. He doesn't have to still be high at 11 o'clock at night. We're talking about, is he under the influence of some substance 3 to 4 in the afternoon when he kills these men? Yeah. You can't drink all that and smoke all that and not have some effect. But if you don't believe that, let's just look at this insanity defense. And what does it say? Like it says up here, we're looking at the time of the conduct charge. As a result of a mental disease or defect, did not know his conduct was wrong. Now certainly this number 2 is in dispute. Dr. Price and Dr. Rambla both have told you it's not a severe mental disease or defect that he has. You know, I think we can all agree that Eddie's got something wrong with him. He is a weird guy. But it is not a severe mental disease or defect. But even if you believed that, look at number 3. Did he know his conduct was wrong? And let's look, just like we looked at, did he commit this capital murder? Look at his actions and look at his words. So let's look first at his actions and how they show that he knew what he did was wrong. What did he do? Even Dr. Rambula said that. Actions speak louder than words. It all comes from your brain. What are his actions? He went downrange and turned his back on Chris and Chad while they were shooting. And he knew they had guns, and he turns his back on them, yet he wants people to believe that he was afraid of these guys. You're not going to turn your back on 2 men with this arsenal of weapons if you're afraid of them. That's ridiculous. So let's look at this. Look at how the methodical, calculated nature of the murders. Waiting for the opportune time, like he said, for Chris's pistol to be dry. Waiting for that. Does somebody who's just out of their gourd insane do that? Wait. I know how many bullets that gun holds, and I know when it's spent. Here I go. He finished Chad off. That wasn't necessary. That was not fear. He did that out of anger. And then he loads that 9mm methodically, puts 15 bullets in it before he steals it and steals the truck. Took that 9mm with him. Why is he doing this? Why does he need a loaded weapon? What's going to happen? He stole Chris's truck and he fled the scene. He's not going to something, he's running away from something. He's running away from that bloody mess at the crime scene. And he fled 105 miles. You saw this. 105 miles from Routh Creek Lodge to his uncle's house, to his sister's house, to Taco Bell, somewhere in there is the dollar store, to his own house. From a place he'd never been in his life. Out in the middle of the country. Finds his way out of these country roads to the highway some way. Does that sound like somebody who is insane? Goes to Taco Bell. I mean, that's just incredible that somebody, you kill 2 men and you're going to go to Taco Bell. But I mean, think about that too. What does it take to go and order fast food? You've got to go through the right lane. You've got to place your order. You've got to interact with the clerk. You've got to give them the money, get your change, get your food, and go. It's not something that somebody that's just out of their mind delusional does. What does it sound like? It sounds like somebody that's got the munchies and they got to go get their Taco Bell. And he went and got his dog. And what's interesting about this Taco Bell receipt and how we know that this is him and not anybody else, because that time on that receipt, you know by 6:50, everybody else who's been in that truck is dead. And instead he wants to go to Taco Bell. But then you saw, how do you know he knew what he did was wrong? He gets in this standoff with the Lancaster police, and then you see this happen. Well, you saw that video. And you saw how he peeled out. He got rammed by that truck. And not only did he speed up, right after he gets rammed, there's that cloud of smoke, and he is hauling, you know what, to get away from those police officers. And he goes 100 miles an hour on a police chase with how many officers behind him, running red lights, going through stop signs. Why? Why do you run? Why do you run from the police? Because he knew what he did was wrong. Let's look at what he said. What did he tell people that indicates that he knew what he did was wrong? There's plenty of it. First, you heard from Deputy Cole. I shot him because they wouldn't talk to me. I was riding in the back seat and they wouldn't talk to me. They were taking me to the range. I feel bad about it, but I'm sure they've forgiven me. There's his motive right there. I shot him because they wouldn't talk to me. These 2 men that you heard, that's just their nature. They're not real talkative guys. They got killed for not talking to this guy. That's what he said. Not, I thought they were the hybrid pig people. Just shot them because they wouldn't talk to me. What did he tell his sister? I just committed murder. Murder is a crime. Using the word murder indicates that he knows he has committed a crime. And the fact that he used that word shows that he knew that he did something illegal. And when she tries to persuade him to turn himself in, what does he say? Nope, I'm in too deep. I'm going to run to Oklahoma to get away from this mess. Acknowledging that there is a mess to run away from shows you that he knew what he did was wrong. What did he tell the Lancaster Police Department during that standoff? Y'all want to barbecue my ass right now. That shows that he knows he is in deep trouble. He has the ability to negotiate this standoff. I'm not coming out. I know y'all want me to come out, but I'm not getting out because I'm in control in this truck. You know, he asked, y'all have guns? Well, so do I. He knew what was going on there. There were, 15 cops around him. What did he tell Ranger Briley? After you killed him, what did you do? I fled. Again, the use of that word fled and the actions of fleeing. You know? Crazy don't run. He would have stayed there at the scene and said, hey, they were going to kill me. He ran away. Ranger Briley asked him, the reason you fled, because you knew that you did wrong. He says, I knew there was certain shit that was wrong about it. Well, Ranger Briley says, some of that certain shit was killing him. You knew that was wrong, right? And he agrees, right. Ranger Briley says, he's talking to him, and Eddie Routh says, I'd like to hug my mom one last time. Because he knows he's going somewhere where he's not going to get to hug his mom for a long time. He says, that's because you knew what you did today was wrong. You shot Chris and Chad, right? Yep. What would you say to the families if you could? He says he'd apologize. Say, I'm sorry for what I did. If I could, I would have done it differently. Why do you need to apologize? You apologize when you know you've done something wrong. You tried to run from the police. And basically he's talking about the standoff. You weren't complying because of what happened. Yep. He knew why Lancaster PD was there. What did he tell Dr. Dunn, even his own doctor? These statements that Dr. Dunn wants you to ignore that show that the defendant knew what he did was wrong, he tells Dr. Dunn, it's a pretty shitty thing to do to kill someone. That's kind of a variation on the old Clint Eastwood quote. It's a hell of a thing to kill a man. Asked if he thought he made a mistake, he said, it says in the Bible not to kill anybody. He knows it's not just legally wrong, but what he did was morally wrong and against the Bible's principles. He told Dr. Dunn asked him if other people would understand what he'd done. What did he say? I figured I'd get arrested. He knew he had done something illegal because why else are you going to get arrested unless you know you did something illegal? He then tells Dr. Dunn, as soon as I did it, I knew I had made a mistake. I felt like I was defending my rights, but after I killed him, I felt this isn't going to look good. He's right about that. Then he went to Taco Bell and got the burritos because, in his own words, I figured I was going to get arrested pretty soon. Why does he think he's going to get arrested? He knows. Went and picked up his dog. Told Dr. Dunn, running from the police was dumb. I drove recklessly. I endangered other people. He recognized that was wrong too. What did he tell Dr. Price? Other motives for what he did. He was mad. He was irritated about Whataburger. For some reason, most people find Whataburger to be delicious, but that irritated him for some reason. He was mad and offended that they didn't shake his hand. And you remember how Dr. Rambula offended him by not shaking his hand. That irritated him. That offended him. He felt slighted. He was mad they didn't talk to him. He was offended they didn't talk to him. He thought about killing Chad and Chris while in the truck, but figured that the truck would wreck and that he might get killed in that wreck. That doesn't sound psychotic or insane. That sounds actually pretty well thought out. What else did he tell Dr. Price? As soon as I shot him, I thought, Jesus Christ, what have I done? And I immediately became remorseful. Why are you remorseful? Because you know you did something wrong. I didn't plan it methodically, but in some kind of tactical scheme, I shot the target facing me, Chad, and then I shot the target facing away from me. Well, that's kind of bragging about his skill, but he's also telling a lie in there, because you know from the evidence Chad wasn't facing him. He shot Chad in the back. And then he says he saw Chad on the deck shaking and convulsing. And he says this: I shot Chad in the head to keep him from getting up. And you know that that's a lie, because there was no way on God's green earth that Chad was ever going to get up from that position on that shooting deck. Then what does he tell Dr. Rambula? Oh, he admitted that he lied to a lot of other people about knowing that they were going to a shooting range. He said, I'd never told anybody else this, but I really did know that we were going to the shooting range. He's comfortable around guns. They want to make it look like, oh, he panicked around guns. But there was nothing that he ever told anybody that indicated that something out there alarmed him or made him afraid of the weapons. The guy's an armorer. You know, he loves weapons. I mean, that's his life. He was comfortable. Thank you, Ron. Don't you know from everything you saw, everything you've heard, including those calls to the reporter, he was mad and irritated and offended at Chad's presence out there. You know, we heard him say over and over on that call to Nicholas Schmidl that he said to Chad, aren't you going to shoot? Aren't you going to shoot? Aren't you going to shoot? What are you doing here? This isn't a spectator sport. And then what did he say? Yeah, he watched his own death coming. Then what else did he tell Dr. Rambula? As he asked him, if you were so bothered by Chad, why not just shoot Chad? And he says, because if I shot Chad, Chris would have shot me. So he had to shoot them both. Ladies and gentlemen, that is not insanity. That is just cold, calculated capital murder. And he's guilty of capital murder. And he was not, by any means, insane.
Mr. Moore.
Thank you, ma'am. Please, court. Good afternoon, ladies and gentlemen. I stood here a couple of weeks ago and told you that an absolute tragedy had happened down at the Rough Creek Lodge on February 2nd of 2013, down south of here in the tip of Erath County. And it was an awful tragedy. You have now seen what happened down there. You've seen all the evidence. And in a few minutes, you'll go back into your room and you'll just try to decide, why did this happen? Why on earth did Eddie Routh shoot two men that he had never met before in his entire life? Was it because they smoked a couple of bowls of marijuana that morning and didn't shake hands with him and kissed him that he decided, I'm just going to kill these two guys? That's what they want you to believe, that he was intoxicated. Or was it because he was suffering from a severe mental disease or defect at that time, such that he didn't know what he was doing was wrong? Basically, that's what you all have to go back there and decide. It's really pretty simple. That's the issue. I want to talk to you for a little bit about the judge's charge to you. You were told at the beginning that you didn't have to know any of this law, that the judge would give it to you, and indeed he has in this charge. And I'm going to go over it with you. There's some areas that need to kind of explain to you. And not that it's difficult to understand. He starts out by telling you here in the middle of the first page about an indictment not being evidence of guilt, presumption of innocence, and burden of proof on the state. That's really not important in this case. Usually in a criminal case, that's what we're fighting over. We've pretty well conceded. It's pretty obvious that Eddie Routh shot these two men. But then in the next two paragraphs are perhaps the most important paragraphs in this whole document. Because number one, it tells you what your job as jurors is. And it tells you that you are the judges of the facts, just like you know. And what that tells you is the facts come from the witness stand. If they didn't come from the witness stand, you don't consider them. And it also tells you that the only thing that you are to consider are two things: the law and the evidence. Well, what that implies to you and what it tells you is, let me put it this way. When we try most criminal cases, that doesn't happen. There may be one or two family members out there, but this doesn't happen, folks. It's not on CNN every night. It's not out in the national media. This is. And I know you've been instructed not to read or hear or watch anything about this case. But when the judge tells you you are to base a decision on two things, the law and the evidence, that isn't to be considered. And you swore to us that you wouldn't consider that, and we're going to take your word at it. It also tells you not only the media, but the community. You about to sneeze. This is a small community. It's a great community. But you can't go back in there and let that affect how you view this evidence, how you judge the evidence. You can't go out back in there and say, oh, I can't do this. What would I say to my neighbor? What would I say to my friends at church? You swore when you sat in this box that you would base a decision on the law and the evidence and not those outside forces. And we're holding you to it, regardless of what your verdict is. The next page, the judge tells you that he tells you up here that give terms their common meanings that aren't defined. And he defines certain words in here for you. And if they aren't defined, you use your common everyday meaning. And we'll get to that in a minute on certain words. He also tells you in the next paragraph that while you're to only consider what the evidence is, you can draw reasonable deductions from the evidence. And that's just using your common sense. What you shouldn't do is fall into a trap of believing illusions and innuendos. If the evidence is there, if you want to draw a conclusion from it, that's fine. But certain things have been brought up in this trial that are just not based on what the evidence is. You remember Ms. Starnes told Eddie said something about voodoo at one point in time. And she asked the witness, well, he went to Haiti, didn't he? Well, there's no basis in evidence to think that he knew voodoo or practiced voodoo from Haiti just because of that. And this wet marijuana that's just been saturated in this trial. Eddie said, well, it may have been something, it may have been Purple Heart. The chemist told you it was not soaked with anything. It was just plain old marijuana. So that's what I mean about don't be falling prey to the innuendos and the illusions. Base any kind of a decision on valid deductions of the evidence. Then he tells you that if you want to see some of this evidence out here, you're certainly entitled to do it. Just send a note out, and you'll be able to see it if it's an evidence. He's allowed you to take notes, but sometimes there's an actual disagreement or conflict in what people think they heard. The only time that Tommy here can read back any kind of information to you is if y'all have a conflict or a disagreement. So make sure before you waste your time that there is a disagreement. He tells you about a defendant's right not to testify. And that's a cornerstone of our criminal justice system and our Constitution. He even tells you that if somebody gets back there and says, well, I sure would have liked to have heard what he had to say about it, the foreman is supposed to say, stop, we can't talk about that, we can't consider it for any reason whatsoever. That's what the judge tells you the law is, and that's what you have to follow. Then he tells you about some what we call extraneous offenses. Extraneous offenses are other crimes, wrongs that you may have heard of that are not capital murder. And the judge tells you in here there's only one thing you can use that for, and that's what he tells you, whether it's motive, intent, those kind of things, you can read it. That's what that means. Now, on the top of the third page in the second paragraph, he tells you that two important things here. He says there's three possible verdicts in this case. Come on, there's only two. There's not a not guilty in this case, okay? We'll concede that. So you're going to be looking at guilty of capital murder or not guilty by reason of insanity. Those are the two things, two verdicts that are possible in this case. But he also tells you in that paragraph that you can return a verdict either way, either not guilty by reason of insanity or guilty of capital murder, only if all 12 of you agree. It has to be unanimous. And what that means is this. If you're back there and 8 of you for one way and 4 of you for the other way, the law contemplates that you try to talk it out and come to some kind of unanimous agreement. But sometimes you can't. That's just all there is to it. You can't get to a unanimous verdict, and that's okay too. That happens in criminal cases. The thing that I want you to know is don't violate your conscience just to make somebody else happy and switch. If you have a conviction one way or the other, don't violate your conscience by switching just to go along with the crowd. We ask you in Boyd Ire, if you're the kind of person that would stick to your guns and if you truly felt the way, and that's what that means. And then he actually defines some terms for you. He tells you what the definition of capital murder is, what criminal transaction under our law means, what intentionally means, and knowingly. Then he talks about intoxication, and that voluntary intoxication is not a defense of the commission of a crime. I'm going to come back to that in just a minute. Then there's a special provision in this paragraph about you can consider all relevant facts and circumstances surrounding the killing, if any, and the relationship that existed between the people, and the facts and circumstances going to show the condition of the mind of the accused at the time of the killing. And that is a special murder provision in our law. And it allows us to show you what was going on in Eddie's mind when he shot those two guys. Then it's called an application paragraph at the bottom of that page, and it tells you about all the elements of capital murder. Then on the top of the next page, here is insanity, okay? And the judge tells you it's an affirmative defense to prosecution that at the time of the conduct charged, that means at the time of the pulling of the trigger. That's when you look at, that's the time that is of importance and that you look at. That, and you've heard this, as a result of severe mental disease or defect, that he did not know his conduct was wrong. Now, you've heard wrong is case law defined. You'll see in here that Judge Cashin did not define what wrong means for you, because it is not defined under our penal code. And so if you follow his instructions, you give wrong its common meaning. Not unlawful, not illegal. You use wrong the way you would in any other situation in your common everyday affairs. Now, we know we have the burden, and it tells you right here that we have the burden to prove by preponderance of the evidence that Eddie was insane at the time that he shot them. And you'll remember that, and then the judge will tell you in here, that a preponderance of the evidence means simply the greater weight of the credible evidence. It's a civil standard, not a criminal standard. It's like when people have car wrecks and one of them sues the other for damages. All they have to prove is the other person was at fault by 51% or the greater weight of the credible evidence. And you'll remember that's your job to determine what is the credible evidence regarding our burden of proof.
15.
Thank you. And then here's the whole crux of the case, number 6, circle number 6, because it tells you that if you find from the evidence beyond a reasonable doubt that he committed capital murder, as alleged in the indictment, but you further find by preponderance of the evidence that at the time of the conduct charged, as a result of mental disease or defect, he did not know his conduct was wrong, you will find him not guilty by reason of insanity. The next paragraph says if you don't believe we proved it by preponderance of the evidence, you find him guilty of capital murder. Simple as that. Now, number 7 will tell you that you can't consider during your deliberation, when you're back there tossing around this evidence, you can't consider the potential consequences to a person, to the defendant, if you find him not guilty by reason of insanity. You were told at the beginning that if you find Eddie guilty of capital murder, his sentence is an automatic life sentence without the possibility of parole. That's our law. No punishment, no stage, no nothing. It's automatic. Judge Cashin sentences him right then. We can't tell you by law the result if you find him not guilty by reason of insanity. Now, I want to talk to you just a few minutes about voluntary, well, the rest of it is some simple instructions that you can read back there once you pick the form. But what we get back to is this voluntary intoxication. And let me tell you, we're not, it's not our position that Eddie was even intoxicated. That's their position. We're saying that if you look at the time, that morning, Uncle Jamie comes over and they smoke a bowl or two of just regular old marijuana. And he said, finally, he told Ranger Briley, well, that may have been 30 minutes before Chris Kyle came to get me. Or I asked him, he said it could have been an hour, could have been 2 hours. But if you look, and everybody's testified, well, regular marijuana may last 2 to 4 hours. And if you look at the timing, this incident had to have happened around 4 o'clock in the afternoon. Because you know where they are at 3:15. And to go set up, it had to be around 4 o'clock in the afternoon. The effects of marijuana would have worn off. But I want you to consider something else when you consider the credible evidence. Eddie was talking to Ranger Briley about 11:30 at night. And you can look at that videotape and you can see the delusional gibberish that he's talking at 11:30 at night. He and Mr. Nash, the district attorney, are both there at the Lancaster Police Department. There is a judge at the Lancaster Police Department. He's ready with his pen in his hand, ready to sign a search warrant. In fact, he indeed signs a search warrant for the search of Eddie's house. And you know that out at that crime scene, they collected every shell casing, they collected every fiber, every bullet, went to Eddie's house, collected everything they could, went to Chris Kyle's truck and collected every single piece of evidence. But yet they're sitting in the Lancaster Police Department with Eddie sitting right there in the room with a judge in the next room, enough probable cause to get a blood sample from Eddie, and they decide not to do it. And you know from their own Dr. Price, you can analyze blood and see how much THC's in it. Yet they made the conscious decision that night not to get a sample for y'all. It would have been the simplest thing to go to that judge and get it and have it analyzed, and you would have that evidence. We would have that evidence. But they decided not to do it, and yet they want to stand here and tell you how intoxicated he was. But didn't go get a sample of his blood to show you if he was or not. So when you're looking at the credible evidence, keep that in mind. So I guess the bottom line is, did we prove to you by the greater weight of the credible evidence that Eddie was insane as it's defined at the time he took their lives? And we brought you evidence through his mother that Eddie was going along just fine. He was going through life. He was happy-go-lucky. Yet he went to the military and came back and fell off. That's what their Dr. Price told you is the sign of mental illness. And he went to the VA in Green Oaks 4 different times, was diagnosed with some kind of psychosis, given psychotic medication, And the January 19th incident, you know he wasn't smoking marijuana during that psychotic incident. And we brought you Dr. Dunn, who works with schizophrenics every single day of the week. And he has for 20 years. They brought you Dr. Price, who's a nice man and a smart man and a good psychologist, but he doesn't deal with schizophrenia. And he has only diagnosed this cannabis-induced psychosis one time in 30 years. And they brought you Dr. Adam Bula, who's president of the Medical Association in Texas. Sounds like that's about what he does most of his time. He's not dealing with patients like Dr. Dunn does every single day. And Dr. Dunn told you Eddie's suffering from schizophrenia. You have the tapes you can look at of afterwards of Eddie's interviews at the various stages that night. So did we prove to you with credible evidence, the greater weight of the credible evidence, that he was insane at the time? Absolutely. Thank you.
May it please the court,
You may.
counsel, ladies and gentlemen of the jury. First, I suppose you should be thanked for your service. I'm an Routh County boy, born and raised, and I know for a fact that your fellow residents are proud of you for doing this job, because it's not an easy job, and we all know that. Regardless of what the outcome of this trial is or your verdict is, to a man, every single resident is proud of you. And you've done it with dignity and class. And I thank you for that. I'm going to be up here a little while because this was a pretty long trial, and we're going to go over some of the facts in this case. We're going to go over some of the reasons why somebody might spin it one way or another. Tim talked to you about innuendo. If counsel for either side attempted to intimate some detail about this case on a PowerPoint slide or otherwise, and it's taken out of context, or it might be somebody's remembrance of how somebody said something, whether it may be in dispute whether they said it at all or not, I want to remind you, anything that the lawyers have said in this case is not evidence. Okay? And I know there's a mound of it, and you may have to go back and look at some of that. One glaring example, okay, and this is a typical example of how we want to insinuate that somebody said something they didn't. Dr. Aaron Beulah said, Eddie said the marijuana was probably wet. On the slide we just saw in her closing, she said Eddie said it could have been, in quotes, okay? That may not be a huge deal to some people. It may be a huge deal to some people, but it's an example of how we take things out of context, okay? And that one's on videotape, all right? So you can go back and take a look at that and find out if the slide was right, or if Dr. Aaron Beulah was right, or if I'm right, okay? So you can go back and look at it, all right? The video doesn't have a dog in this fight, all right? It's objective. Most of what witnesses say have some subjective amount of perception to them, okay? And I'm going to get to Ranger Briley and Ranger Armstrong and Laura Blevins, and I'm going to get to all those people in due time. But just in response, as another example, okay, about how we spin things or we put those innuendos out there, Taco Bell, okay? And I'm not saying it's wrong, but you could certainly take the position, as the state has, that because Eddie Ray Routh could negotiate the drive-through at Taco Bell in Red Oak, Texas, well, he must have had organized linear thought, because he could negotiate not only the drive-through, but he could order what he wanted, And maybe because you've saved the receipt, that also indicates some sort of organized linear thought. But from the state's perspective, that's something they just argued to you. He couldn't possibly be insane because he can negotiate the Taco Bell drive-thru in Red Oak, Texas. And the reason I bring that up is just to illustrate any single purported fact, whatever it may be, could be looked at one of two ways. Now, some of them are easier to do than others. Certainly, I would submit to you that somebody who's just shot and killed two people, if they're actually fleeing, we don't stop at Uncle Jamie's house. We don't stop to get a Dr. Pepper at the Dollar Tree. We don't stop at Taco Bell. If his intention is actually to flee to Oklahoma, you don't run by the house and pick up your dog, go around the block a few times to find a couple of friends to talk it out with, and then show back up at the house when the police are sitting there. You don't think he saw him when he's driving up? He knows Jesse. That's his neighbor. Detective Chavera. He's not fleeing, he's going home. And then that's the point. The point is, the state says, well, he fled, he's guilty, he knows what he's doing is wrong. He's not fleeing, he's going home. And the criminally insane that wasn't actually fleeing to Oklahoma would go pick up their dog, leave, drive around and look for a friend to talk it out with, and then show back up. I submit to you that fact in his case, the second time he goes back to the house in Lancaster on 6th Street, certainly could be interpreted as evidence that he is disorganized thinking. One of the symptoms, as Dr. Dunn and the other doctors told you, of a severe mental disease, schizophrenia in this case. Now, let's kind of roll through this and as best we can chronologically, because you were told in opening, we're going to observe the conduct before, during, and after. Okay? On the one hand, you've got conduct, all these actions and words. Okay? And that was one of the slides that Jane used. Let's look at actions and words to try to figure out what the issue is in this case. Okay? So you've got, in one sphere over here, you've got all these actions and words, and then this other sphere over here, you've got all these guys with letters after their names giving you what their opinion is. Okay? And really, they're basing their opinion on two things. Actions and words. Okay? Some clinical testing, but mostly what people say, including Eddie, and what they saw. Okay, I reviewed all the police officer reports, reviewed all the videotapes. Everybody reviewed everything. Also reviewed all the medical records from the prior doctors at all the VA hospital in Green Oaks. Okay, so and some of that was done a while back, and some of it was done 3 weeks ago. Okay, Dr. Ambula was out there the last week of January of this year. And so, and there's been a lot of testimony about the change over the 24 months and the antipsychotic medications that he's taking and when the dosage was doubled. And so we're going to kind of run through it. And there's a limited amount of time. All right, so I apologize to Tommy and I apologize to you now. But I'm going to try to roll through this in a limited amount of time. And I may misspeak, but you're going to know what I mean. All right? So, here's what we know. All right? We know we've got Eddie Routh, troubled veteran. Okay? After high school, goes to the Marines, gets out, and we've got a troubled veteran. And the state would have you believe that he's not psychotic and that he's setting up his own defense once he starts to get interviewed by the police. And you heard Warren ask Dr. Dunn, well, he must have been brilliant to know you were coming a year in advance when he, starts his pig references. But there's other examples. And there's some strong evidence there. You know, he went to the VA in July of 2011. And you remember delusion, a fixed false belief? You're confronted with evidence to the contrary. No, Eddie, you don't have a tapeworm. Okay? Eddie had a delusion. Eddie was delusional as far back as July 2011. Thought he had a tapeworm. So, I don't know if it started years or months or weeks, but I suspect, and I submit to you, the evidence indicates that Eddie started to show signs of a psychosis. I'm not talking about a mood disorder, all right? I'm talking about severe mental disease or defect. This schizophrenia started, and undisputed, that's the prime age that someone develops schizophrenia. Eddie's right in the center core, right in the heart of it when all this starts. And he has this delusion about the tapeworm. He goes to the VA for the first time after he got out of the Marines in 2010. And you know the history. I'm going to go over it with you, but it kind of goes downhill from there. So after he has his delusion in 2011, he rocks along there. Of course, the reason that delusion is important is that they're going to tell you later on, hey, he's setting up his own defense. He's going to claim he's crazy to get out of trouble. But it just doesn't make any sense that if he goes as far back as 2011 with those trips, that he would think that far ahead. And Dr. Price tells you, you know, and like Tim told you, he's been doing this 30 years. Actually, he's diagnosed 2 cannabis-induced psychoses, but one was after it. Okay, so Tim's right. I think 34 years of practice, and in all that time, he's diagnosed 1 cannabis-induced psychosis. And Dr. Dunn told you it's rare. Jane told you it's rare. And not only that, it's the rare exception of cannabis-induced psychosis if it continues on past today. And we'll get to that January 19th incident here in a minute. But so cannabis plays a big role in this thing. And I think it's abundantly clear that most of his adult life, Eddie smoked marijuana. And I also think that it's fairly undisputed that everybody that knew Eddie said that marijuana calmed Eddie down and helped him relax, and that he didn't have violent outbursts that sent him to the VA over that. I actually think that was probably some evidence that there was an adverse effect on Eddie when he drank too much. And I think that there's some evidence that the fish fry, the family fish fry, that he drank too much and he got drunk and he got in a fight with his dad and he had an episode there. I don't know that that's a psychosis. I mean, but certainly there's some evidence that he didn't handle his alcohol very well. And certainly, if you think he's drunk on February the 2nd, it certainly would have been helpful. I mean, for every single misdemeanor DWI nearly in the state of Texas these days, we get a blood warrant to go draw blood for a Class B misdemeanor. Some Tarleton kid gets drunk, gets pulled over, and without a doubt, if they refuse, the vast majority of those get a warrant signed to draw their blood. Nearly all of them. And it's extremely easy to do. It's really easy to do when you got a judge sitting in the jail ready to rubber stamp anything you ask for at that point, because you got 2 dead bodies in Erath County that you're investigating. So ultimately, Dr. Dunn opines this is rare, and Eddie actually exhibits the symptoms more than 2 of the 5 required under the DSM, the Bible for the psychologist and psychiatrist, schizophrenia. It's virtually undisputed that he's right there in that wheelhouse for the age that somebody that develops schizophrenia would develop schizophrenia. And ultimately, we know what his opinion is. His opinion is that the mental disease or defect was so severe that Eddie didn't know, because he was delusional, because he thought that he was going to be killed, and that wasn't the first time that Eddie thought he was going to be killed. I mean, he at least on 2 other occasions thought that he was going to die. Maybe not be killed, but he was going to be dead when he woke up on one occasion. Then at another occasion thought he was going to die. So he's clearly delusional, and has been at least since July 2011, with some frequency. And on February the 2nd, he was delusional about whether or not he was going to live or die. And some of the actions and words that we're talking about, of course you see some of them on video, but you see some of the things that are talked about around that time, and even later, about what he could smell in the air, that he could smell love, he could smell hate. Then he wasn't sure if he was smelling it coming from them, he wasn't sure if he was smelling it coming from himself. But that's a pervasive theme throughout the entire trial about what he could smell in the air, or what he could smell. And that's another example of him being delusional and interpreting what he thought he smelled. Dr. Price would have you believe that that's cannabis induced, but there's so many examples throughout the trial where it doesn't have anything to do with that, where he can smell something without regard to that. So these events began to unfold in the weeks leading up to that fateful trip down to the Rough Creek Lodge shooting range that sort of paint this picture of a young man that's suffering from paranoia, suffering from schizophrenia, suffering from this severe mental disease. And the time immediately leading up to this, Jen Weed's at the center of it, okay? She's his girlfriend. She's with him off and on when he's not in the mental hospital. And she at one time was his girlfriend, but she really doesn't have anything to gain, if you think about it, from coming up here and making anything up, okay? And she's called as a state's witness, and she's under subpoena, and she takes the oath, and she sits up there, and of course, you know, she's the last person with him that led up to that last commitment in the hospital, which ended just 8 days before this trip to the shooting range, right? And she describes a whole bunch of things going on with Eddie, and she denies that there was any marijuana use leading up to that incident, but you just look at actions, okay? Actions and words. And you start looking at some of the actions, and keep in mind, you know, this is a couple of weeks before, so if he's tipping his hand, okay, if he's setting up his own defense, he's having to anticipate some things. You know, she describes him at this point leading up to the shooting as catatonic. She describes him staring at the wall. He's in tears. He's laughing.
20 minutes.
Thank you, Your Honor. And then she describes an incident where she let him borrow her brother's shirt, and he's fine. 1 minute, she's getting ready. The next minute, he's visibly shaking, and he's sweated through. I mean, we're talking sopping wet, sweated through the entire shirt. Okay, I think she said it was a light blue polo. First of all, that's going to show that you sweat pretty good. Probably it's a short sleeve shirt. And this is January. Of course, it's probably warm that time, not so much this week. But she describes him as doing all that, and then shortly thereafter, we have the incident where she says he's not violent and he's not threatening, but he's paranoid. I mean, he's standing over there peeking out the window with a ninja decorative sword, and eventually at some point, for whatever reason, gets a butcher knife out of the kitchen block, out of the knife block. And he's looking out the window, and he's saying, no, we're not leaving here. They're going to get us, okay? And if you go back, just as a general overview, and look, there's repeated references, and there's references from the doctors that he had a paranoia about the government and about people trying to listen. And Jen even talked about the incident where he put his hand over her mouth. She's trying to have a conversation with him, and he gets a legal pad and starts writing down, and no, he puts his hand over her mouth because he thinks they're being listened to. It has nothing to do with smoking marijuana, okay? And it has nothing to do with setting up some sort of defense to some criminal activity that's going to occur in the future, okay? What it has to do with is Eddie having schizophrenia. And, you know, he goes to the hospital. They again prescribe antipsychotic medication. I think this time they double it, so now we're up to like January the 30th. And Jen would see him again, and he would propose, and then he tells her, kick rocks, get out, next morning. Just typical, riding that roller coaster of emotions, never know from one day to the next. And so she leaves him with Uncle Jamie. And we all heard that testimony. Okay, Uncle Jamie's up here. There's a lot of assumptions made about when he smoked that marijuana. That's an area of dispute. And Tim touched on it. But Uncle Jamie left at 8. Eddie got up before 4 that morning. They ate breakfast before 5 that morning. You know, she got him showered. He hadn't showered in weeks. All right? Take that for whatever it's worth. And Uncle Jamie says, I live 45 minutes away. I left around 8. Okay? Give them the benefit of the doubt and say left at 9. All right? They talked, drank coffee. He doesn't remember if they drank whiskey or not. Eddie says they did. They don't have any idea how much whiskey was in the bottle that morning when they started. But he said he had drank whiskey the night before. So they have some talks about advice on women. They have some talk about spiritual things. And I think he said he even played him a hymn off his phone that he had recorded. But they talked about that. And they may have talked 15 minutes, they may have talked an hour and a half. I don't know, and I submit to you that there's not any evidence in this record to suggest when those 2 bowls of marijuana were smoked. But I will submit to you that somebody that smoked marijuana most of their adult life and smokes some marijuana sometime that morning and has some tolerance for its effects on you was certainly not intoxicated at 3:45, 4 o'clock, or 4:15 that afternoon down in Erath County, Texas. And I also submit to you that there were witnesses that took the stand that were asked, you know, would Chris take somebody to the range that showed any kind of sign of intoxication? And I mean, you talk about red herrings. Throwing alcohol into the mix is a red herring. I mean, that's just another thing the state can throw out there to try to get you to bite on, but they certainly had the opportunity to pull his blood if they wanted to, but they didn't. There's no evidence to suggest that Chris Kyle or Chad Littlefield, for that matter, would have taken somebody to the range that smelled or showed signs of intoxication. And you know, James, he says the marijuana is just plain old good marijuana. The first person to suggest that this marijuana was wet was Ranger Brown. Okay? And that's part of the slide. Of course, they were taken out of order. That conversation was taken out of order, out of context. And when he says, you know, was it wet? Eddie said, it could have been. And he asked Eddie, after every question, you knew what you were doing was wrong, right? You ran from the police because you knew what you did was wrong, right? And Eddie said, right. He said, yes, sir. Let me just pose this question to you. If Eddie's truly crazy, what good does it do him to ask that question? If he really doesn't know the difference, what good does it do him to ask the question? That answer is not dispositive of anything. If he doesn't know what he's doing, he's not really capable of answering that question. That's just like asking him if the sky's purple. Regardless of what his answer is, it doesn't get you anywhere. Okay? It doesn't make it any easier for you to answer the issue. So, they decide, as Tim told you, in their wisdom, that they're not going to pull his blood. They don't need it because they got Ranger Armstrong out there searching the house, and he's found a grinder, a pipe, a broken pipe, and a little bit of plain old marijuana. Okay? Now they wanted to, certainly the innuendo and the suggestion was PCP, LSD, embalming fluid, formaldehyde. Of course, embalming fluid and formaldehyde are the same thing. Fact of the matter is, you can't dip marijuana in formaldehyde and keep it for a while and then go smoke it later. The fact is, formaldehyde is so volatile that it evaporates quickly. If you were trying to preserve it with the marijuana in some sort of airtight container, it's going to mildew and you're not going to be able to smoke it anyway, right? So formaldehyde needs to be dipped and then smoked. So, I don't know. I'm trying to figure out why in the world Ranger Armstrong testifies under oath that he collected 2 vials of clear liquid, found them in Eddie's house in the metal box, unless that's an insinuation that it's some other substance, because that mess had to be fixed, because the lab tech was fixing to come up here and say, no, I put those in there. Despite the fact that he swore under oath that he collected those in Eddie's house, the state had to take those out of evidence out of that exhibit. We also heard from the Lancaster PD. You can watch those videos again if you need to. Submit to you that he's not intoxicated. He does appear to be paranoid and disorganized in both his thought and his speech. There were autopsies, the shell casings. There's a Spheron space-age 360-degree camera. The Secret Service. You've got all these law enforcement officers at the disposal of the state. And the Secret Service brings you this text message that says, Chris Call, text Chad Littlefield, dude is straight up nuts, all right? And the state talked about that on their closing. Chris sent that text message. Chris Kyle sent that text message without the benefit of any psychiatrist's opinion. He knew it without seeing any of these videos or interrogations of Eddie Routh. He knew it without knowing how many times he'd been in the VA hospital or Green Oaks. And there's not anybody here, there's not anybody that doesn't wish that these deaths could have been prevented. As Jane said, but the state certainly wanted Chris Kyle to have the benefit of knowing all that stuff because, and how do I know that? Because when Jody Routh was on the stand, when she's on the stand, they asked her 15 times, don't you think that would have been good information? Don't you think you should have told Chris Kyle that Eddie's crazy? That's basically what they asked her a dozen times. Over and over, every time that she took the stand. And the state wanted that, and they demanded that. She should have warned him. And the fact of the matter is, you can't have your cake and eat it too. You can't ask Jody Routh to warn Chris Kyle that he was crazy, and then ask this jury to not find him crazy. Thank you, Aaron.
One more, Mr. St. John.
How much time do we have left, Your Honor?
Doing the math right here.
I'm sorry, Judge?
I'm doing the math right now.
Oh, yes, sir.
$34 minutes.
Thank you, Your Honor. May it please the court?
Yes, sir.
Members of the jury, I'm not going to take all of my time, because I suggest you've been diligent and deliberate in listening to all the evidence in the case. But let's go back and think about the testimony of the experts. Here's what's neat about filing a lawsuit. You get to use your common sense. Remember during voir dire, I said, could you be steadfast in what you believe and not be swayed by what others want you to believe? And I also said to think about this, and think about it now, because when I said it to you, you didn't realize this. You'll never have as much power today as you ever had in the rest of your life, because your power is real. Think about it. How much power the 12 of you have to make the correct decision in this case. Think about it. And I'm not from Stephenville. I've had the privilege of trying cases here before. And I will tell you that you are blessed to have Judge Cashin as your judge. I try cases all over the state of Texas. I try cases in federal court. You are blessed to have him as your judge. He's the judge of the law. You're the judge of the facts. You get to determine what the truth is. Think about it. You determine what the truth is. Do I believe Dr. Dunn? Do I believe Dr. Price or Ramula? All three professionals make different diagnoses. Excuse me? Two are psychiatrists. Two are medical doctors and one is a psychologist. Dr. Price is not a physician. He doesn't prescribe medicine. He gives tests. Use your common sense. Dr. Price talked about a cannabis-induced psychosis. Anybody ever had a beer on the jury or consumed any wine? Common sense. At 4-something in the afternoon on February the 2nd, how in the world was Eddie intoxicated? How? Because the law is, at the time of the event, did he suffer from a severe mental disease or defect? He didn't know his conduct was wrong. You know why? Because he went to Taco Bell. They want to focus on Taco Bell so much. It's so simple. He didn't know his conduct was wrong because he went to Taco Bell. It sounds silly, but it's true. It's absolute. Why would a man who just killed 2 people go and get something to eat? Not because he thinks he's going to go to jail or prison, because he didn't know his conduct was wrong. That's Eddie when he was in the Marine Corps as a young man who wanted to be a success for this country, like Mr. Kyle was and Mr. Littlefield was. He didn't kill those men because of who he wanted to be. He killed those men because he had a delusion. I want to say it again. He killed those men because he had a delusion. He believed in his mind that they were going to kill him. You know, we have a state-of-the-art crime scene guy get up here and talk about what could have happened. What could have happened? What could have happened? That's all conjecture. It's all speculation. You take those crime scene pictures back there, you look at what happened. Eddie took their lives because he thought they were going to kill him. Not because he rode down Highway 67 in Mr. Kyle's black Ford 350 jacked up truck. He didn't know these guys. Never met them in his life. They were honorable. They were trying to help a veteran who Eddie's mother sought out at the Littlefield Elementary School. He was doing a good faith deed and he lost his life. Eddie didn't know these men. So the inference that, I find it somewhat shocking that the state of Texas wants you to believe that Eddie killed them because he didn't, Mr. Collins shake his hand, they went to Whataburger, he's jealous. That is outrageous. It's offensive. It's absolutely offensive to believe that. And you know, the state doesn't have to prove motive. They're trying to show you a motive why he killed them. You know why? You know why? They have to show you something because they know he's been ill. They know he's been ill. And they're so worried that you're going to believe the testimony of Dr. Dunn that he was psychotic. See, let's flip it around. Let's focus on he's a bad guy. Mr. Collins, shake his hand. That is outrageously offensive to pure logic and common sense. What do we know from Laura Blevins? And look. Do I think you should smoke marijuana? I'm a good Southern Baptist. No. Do I think you should get drunk? No. But I can't control someone's behavior. We know Laura Blevins has seen her brother intoxicated with alcohol before and high on marijuana. What does she say to the authorities? That's not right. I looked at his eyes, and for a second I saw Eddie again, but then he went away. Folks, that's psychotic, delusional process. That's schizophrenia. That's not intoxication with marijuana. That's not my brother. That's not the man depicted in that exhibit that she saw that day in her house outside in Midlothian. And look at the delusion. Look at the delusion of Eddie's mind. And he is not sophisticated enough to plan a defense. That is beyond comprehension. He's that sophisticated he can plan his defense. He's that sophisticated over a year before Dr. Dunn sees him. He talks about pig extraction. He's not that sophisticated. Look what he tells Ranger Briley, who's sitting right there. Look what he tells the Ranger. And I have great respect for that Ranger. He did his job. But guess what? He can't change what was in his mind. He can't change what Eddie thought. Riley asked Eddie, so you saw your sister today. What did you tell her? I told her, listen to me, I told her I had to kill men today. It wasn't a want to, it was a need to. Does that make your skin crawl? I had to get out of that situation I was in today. If not, this is his mindset. I was going to be the next one out there getting my head shot off completely, getting my head completely off, you know. He's not that sophisticated, folks. As Mr. Moore did state, we're not contesting, and the state did a good job of legally establishing beyond a reasonable doubt that he killed those two men in the same criminal episode. We're not contesting that. What you need to look at, and the judge has given you the instructions, which is the court's charge. Now, bearing in mind, this is the law. You'll take it back and you'll pick a foreperson. I suggest, if you want to, you look at every piece of evidence in here, but especially every video. That shows you who Eddie was. The Eddie you saw on February the 2nd, 2013 is not the same Eddie over there. You know why? You know why? Because he's taking his medicine. Why would you prescribe antipsychotic medicine to someone who's not psychotic? Why? If the state wants you to leave with a drug-induced psychosis, why does he still take the medication? Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Eddie Ray Routh, committed the offense of capital murder, he did commit the offense of capital murder, as alleged in the indictment, but further, now listen to me, but further find by a preponderance of the evidence, the burden is on us, the greater weight of the evidence. It's a civil burden of proof. That at the time of the conduct charged, the defendant, that's Eddie, as a result of severe mental disease or defect, did not know that his conduct was wrong. Then you will acquit the defendant, say by your verdict, not guilty by reason of insanity. Here's the privilege about being a citizen of this community and a citizen of Texas. As I talked about during War Dire, my family's practiced law in this state for 119 consecutive years. But guess what? Your integrity is the most important thing, and your honesty to the oath you took as a king. As Shay talked about, you're going to go back to the community and you're going to go to church and go to work, and guess what? You be steadfast in what you believe in and not be swayed by what others want you to think. Because I asked everybody individually that question, and you all said you could do that. So how do we know he suffered from a severe mental disease or defect at the time of the offense? Use your common sense. The state has two experts, but it's bizarre because they don't agree with each other. It's kind of weird. You sponsor an expert that doesn't agree with one or the other. Dr. Price, who I've known for a long time, says it's a marijuana-induced psychosis, but look at his actions. And the idea that he goes down range, and first of all, there's no way he went down range while they're shooting. Where did that come from? I never heard any evidence about that. There's a lot of inferences the state likes to make, and I will say Mr. Nash, I have respect for him, and I think he's a good prosecutor. There's some inferences that really bother me in this trial, though. The questions Mr. Nash asked to Donna Taylor about Eddie at work, where he is having these catatonic states. Well, he must have been catatonic because he's smoking pot at work. No, he's not smoking pot at work. And Mr. Nash asked a question about, well, did he go out in the back and smoke pot with some employee? Donna Taylor, no, he didn't do that. I've never heard of that. That's a false impression the state wanted you to have. They want you to have a false impression about the marijuana being wet because it makes Eddie look like he's intoxicated. Nope. No evidence of that. Now, I will say, to his credit, for the record, Mr. Nash is the one that discovered those vials in that evidence. That was a mistake by the lab person. But here's what's very bothersome. Very bothersome. A ranger in the Dallas section of the Texas Rangers testified under oath that he took the vials from the house.
Your objection, Your Honor, that was not the testimony of the ranger, and he knows it.
Sustained.
The bothersome thing is, Alan Nash paraded in front of you a vial and asked the ranger, is this the kind of thing you stick a syringe in? Inference? False inference. False inference. Not in evidence, improper. Dr. Dunn, who, let's think about it. If you're going to have a house built, do you want someone that knows how to build a house, or someone who has some idea about building a house? I'm going to pick someone like Dr. Dunn that actually sees patients and works on folks that are mentally ill. Arambula, what in the world does he do? He's president of the medical board that gives exams to people who want to be doctors. How does that deal with psychosis and schizophrenia? And I asked Arambula all these examples, and he says, well, it could have happened, it could have been, it might have been. He couldn't answer anything. Well, he was a waste of time, folks. What did he tell you that helps you at all? Nothing. He told you absolutely nothing that was beneficial. Well, Mr. St. John, I might need more information than that. I might need this, I might need that. And to say it's a mood disorder? It's not a mood disorder. It's a psychosis based on schizophrenia. Randy Price talks about marijuana-induced psychosis, and I'm about to sit down because I see y'all are getting tuckered out, and we got to go a little bit longer. How would you be able to shoot a gun like you did, which is horrible? Think about this, and go back and look at the pursuit. You can put whatever label you want on it. Eddie didn't want to go to jail. He realized that part of it. Go back and look at the pursuit. How do you drive a truck like that if you're intoxicated? He was not intoxicated, folks. He was psychotic. Go back and look at the tape of the conversation that the officer had with him in the truck before he took off. That's psychotic. Testimony from the DPS rangers and all the folks at the scene. You smell alcohol on him? No. Did he smell like marijuana? No. This is a tragic situation for my client, his family, for Mrs. Kyle, her children, his parents, Mr. Littlefield's family, his parents, his wife, his child. It's tragic. We can't change what happened. But you have to make a decision based on the law and the evidence. So here is the issue. At the time of the offense charged, did my client suffer from a severe mental disease or defect? And did he not know that his conduct was wrong? That's the issue. I said that once you deliberate, you can only come to one conclusion. You'll choose your foreperson and go back and make a decision. You have to have the integrity to follow your belief. The integrity to follow your conviction. Did the state prove to you beyond a reasonable doubt that Eddie killed those two men on that day? Yes. Did we prove to you beyond the constant evidence that on that day, February the 2nd, 2013, that he suffered from a severe mental disease or defect and did not know his conduct was wrong? Yes. So on the verdict form, it's the last thing that the foreperson has to sign. Can't tell you where he'll go. We can't tell you that. The law doesn't allow it. Do I agree with that? No, but I'm not in the Texas legislature. You can figure that out.
Mayor's phone. 30.
Ladies and gentlemen, this defendant has gone to the deep well of excuses for his violent behavior one too many times. and it is time for it to end right now, right here. We have heard for 2 weeks excuses after excuse after excuse for violent behavior in this case, as well as all those cases before. This defendant gunned down 2 men by shooting them in the back, and then Chad Littlefield in the back of the head, and then twice in the face and on the top of the head. And if they're going to ask you to say he gets away with that, make them convince you. Now, ladies and gentlemen, the problem with the defendant's excuses that you've heard repeatedly over the last 2 weeks is he can't keep them consistent. Just like a typical liar or a typical performer, the performance or the lie depends on who the audience is. What we see is a performance on the day he was arrested. We see him purposely evading questions of Ranger Briley by changing the subject and saying outlandish, bizarre things. We see him in the back of a patrol car, just fine, not muttering to himself, not bothered by the police outside, not bothered by the lights going on, but as soon as he has an audience, I feel psychotic, I feel paranoid, I feel schizophrenic. These words start rolling off his tongue. But let's talk about the myriad of excuses he's used time after time to try to avoid responsibility. And make no mistake about it, ladies and gentlemen, what they're asking you to do. They're asking you, by asking you to sign that last form on the verdict, they're asking you to find that he's not guilty, that he's not responsible for what he done. And if they're going to ask you to do that, think about all that this defendant has proven himself capable of. We've heard about psychosis, NOS, and we've heard about schizophrenia, and we've heard about cannabis-induced psychosis, and all these different things. We heard for a while about PTSD until 3 experts finally told you he lied about his military history, he lied about his PTSD, he lied about having an ailment on every single portion of his body to get his benefits. All that finally went by the wayside. But it is time for his deep well of excuses for violent criminal behavior to come to an end. In September of 2012, he threatens to kill his family. And what do we hear? We hear, I'm military. I have PTSD. I can't help myself. And what happens? He doesn't go to jail. He goes to the mental hospital. He gets clean off dope. He gets out. Goes right back to it. In January 2013, just before all this happened, he holds his girlfriend and her roommate hostage with a knife and a sword, to the point that the roommate was so frightened that she ran out the backyard and jumped a fence even before the police could arrive. And what does he bring out? I'm military. I have PTSD. And he avoids jail, and he goes to the mental institution. He goes to Green Oaks. He gets cleaned up for a few days, gets off dope for a few days, and what happens the very day he's released? You heard Jen Weed testify to a lot of different things, and she tries to protect him the best she can when they called her to the stand. But one of the most telling things we learned about this defendant is in January 2013, after he cleans up, gets sobered up, in the mental institution, in the VA mental institution, what's he do the very day he's released? One of the biggest fights he and Jen have is over what? She goes to see him the day he's released from the mental institution, and where is he? With Greg Lindemood, his dope dealer. The day he's released. The day he's released. And, you know, we can go through, I don't want to keep you all day because you've heard 2 weeks of testimony. We could go, you know, tit for tat, to use the phrase of the defendant, tit for tat on every little point and every little diagnosis. But every single time this defendant ended up in the mental hospital, tested positive for cannabis. Every single time. And every single time, those doctors diagnosed him with some condition or psychosis, NOS, not otherwise specified, which you now know is doctor code for he's got symptoms, but we all know the root of the problem. The guy's a doper. He will not stay off dope. We're not talking about the casual person who smokes a joint in Colorado once in a while. people can differ on whether that should be appropriate. We're talking about hardcore cannabis use. And every time he goes to the doctor, to the hospital, that's positive. And they diagnose him with psychosis, NOS, or mood disorder, and it's all traceable to that. But that's really fine and dandy. You know, we have all this talk about the doctors. And you know, I've listened to it just like you have, lived with this case for 2 years. In all candor, I'm a little tired of a couple of things from this defendant. You know, hundreds of thousands of men and women have served us in the military. And they've served in combat, they've served in bases, they've served overseas. And they don't ask us to tell them, because you served us, you're not responsible for what you do. They don't ask us that. Because, let me pose this to you. The minute we start saying, if you serve us in the armed forces, we can't hold you responsible for your crimes afterwards. That is also the moment we tell our armed services and we tell the men and women who serve us, ladies and gentlemen, we can't trust you. And I'm not ready to say that. I'm tired of that being proposed to us. And I'll tell you another thing I'm tired of hearing the last 2 weeks of this trial, is that people who deal with mental illness in themselves or in their families, their churches, their workplaces, that they expect to not be held responsible for what they do when they commit crimes. I'm tired of hearing that. Because we all deal with this. Some of us have heart disease, some of us have cancer, some of us have diabetes, some of us have mental illnesses. And we are good citizens, and we are good neighbors, and we are good friends, and we're good fathers. And I am tired of the proposition that if you have a mental illness, you can't be held responsible for what you do, because the next step from that, the next words that will roll off the tongue after you say you can't be held responsible is, we can't trust you. And I cannot stand for that proposition. We cannot stand for that proposition. So the deep well of excuse making by this defendant has to come to an end. And the big problem with his excuses is they don't match. We hear his rather wild performance for Ranger Briley on February 2nd, the night of, when he knows he's in a bind. He just murdered 2 men in cold, calculated blood. Cold blood, he gunned these 2 men down. And he's acting crazy for Ranger Briley, particularly when he asks him hard questions like, where did you shoot Chad? When he knows the answer's in the back. But a mere 13 days later, when he's not talking to the police, and he's not talking to the defense attorneys, and he's not talking to his psychiatrist whom he needs to convince you to let him get away with murder, when he's not talking to them, but instead he's talking to a reporter from the New Yorker, what do you hear? You hear a cogent, articulate, in control man talking about, here's what I need to get out of here and do some writing and get my story out. February the 16th. It's amazing how he recovered from that psychosis that Dr. Dunn has seen. It's amazing, too, that just a few months later, when that reporter gets a hold of him again, we have a series of conversations and we talk about the details of the crime. And you heard just today the 13-minute call when he's not talking to the police, and he's not talking to his lawyers, and he's not talking to the psychiatrist he needs to convince you to let him get away with murder. What does he describe? He describes riding in the car, getting angry, getting ticked at Chad. What's this mother effer even doing here? He's just watching. And I took care of business. He watched it. He watched it. His true colors came out then, ladies and gentlemen. His true colors came out then. He watched it. Ladies and gentlemen, you've learned a lot about what this defendant's capable of. You learned he's capable of gunning down 2 men in the back. You learned how he's capable of executing a man while he's down. And you've learned that he's capable of dreaming up excuses to get his hide out of trouble at the convenient times, depending on who the audience is. If he's talking to his psychiatrist, whom he needs to convince you to do this, or he's talking to the police, whom he needs to convince he's crazy, he's crazy. When he's taking the story out with a reporter, hey, it's almost bragging. I hopped in the truck, put in an effing dip, and took off. He wasn't one bit sorry for what he did. You know why? He knew it was wrong, because that's what this man is capable of. And I'm kind of tired of talking about the defendant. I want to talk about a profile in courage for a moment. Something you heard about 2 weeks ago. You heard in that witness stand a young man named Justin Neighbors. He's the Rough Creek employee who drove up with 2 other folks, a father and his 10-year-old son, and found this horrific scene that we've had to subject you to for 2 weeks, this horrific scene. And this young man, not knowing who did it, not knowing where the killer was, sends the father and his 10-year-old son, get out of here, get back to the base, tell him what you saw, and once he do, he stays there. And he heroically tries to save Chad and Chris. That's a profile in courage. Send the father and send the 10-year-old back. But I want to back up a little bit, and I want to ask you to visualize something. And I want to start with one of the exhibits that we gave you. And that's the picture of the back of the shooting sports range. Now I want you to visualize something. You've seen the horrific murders that occurred there. You've seen Chad and Chris brutalized by this defendant. And now you know, through the evidence, that after he shot Chad and Chris, he takes the gun he used to shoot Chris, puts it right up on the deck above the head of Chad Littlefield as he bled and died. And he stands over Chad Littlefield as he's bleeding and dying. And he pulls out the magazine out of the 9mm. And just like Clay Jeffers showed you, he one by one reloaded that thing with 15 rounds. And you saw how long that took. Now, I want you to visualize this. What if Justin and that father and that 10-year-old boy had been a little early? Now that you know what this defendant is capable of, is there any doubt in your mind?
I'm sorry, that's improper argument. That is absolutely outside the record, Your Honor.
Is there any doubt in your mind that this picture right here would be different? The father, Justin, and the father and the 10-year-old. Would you be hearing from this defendant that Justin had a pig face, or that the father?
Most respectfully, Judge, that is improper argument. The court knows that's outside the record. I object.
Overruled.
Now that you know what he's capable of, would Justin have a pig face? Would that father have made him mad because he refused to shake his hand? Would that 10-year-old boy make him fear for his life? Fast forward to Lancaster. Is there any doubt, now that you've heard the evidence of what this defendant is capable of and the excuses he will sling up before you when he's in a bind, is there any doubt in your mind that if those officers at Lancaster were out of bullets, or if those officers had their backs to him, is there any doubt in your mind what this defendant would have done with that 9mm and that 30-06 Remington 700 that he had right there at his disposal in the truck? And is there any doubt, now that you've heard him sling a variety of excuses here in front of you, trying to get you to bite on this, is there any doubt in your mind that we'd be hearing about how those police officers had pig faces, or that they were the wolf in the sky about to fly? Is there any doubt in your mind that we'd be hearing some excuse about how he was afraid of them? Now, miraculously, he didn't shoot them because they had bullets in their guns and they had their faces to them. And miraculously, when the truck finally, as he's on his way to Oklahoma, when that truck finally gives up the ghost, this insane man who can't control his actions, and this insane man who's afraid and having delusions that people are out to get him, this insane man, the minute the brake lights come on that truck, what happens? That door swings open and the hands are out before his body. The jig is up. Ladies and gentlemen, that's the behavior of a sane man. That's the behavior of a control man. And then the show begins. Now, ladies and gentlemen, I asked you in the opening statement, as you heard the evidence, to consider two core questions. Did he intentionally or knowingly kill these two men, these two fathers, husbands, sons, and brothers? Did he intentionally and knowingly kill them when he shot them in the back? And at the time, did he know his conduct was wrong? Two simple questions. Now, we've heard 2 weeks of evidence and excuses and justifications and diagnoses and all those things. But let's face it, this case comes down to those two questions. And this defendant's conduct speaks louder than his words, because his words change, as we've already established. You can't count on his words. Even as, and this is just an aside, but even his own doctor had to come around and acknowledge he lies to him. He didn't tell the truth. How do you base a diagnosis on something that when the doctor's not even, you're not even telling your doctor the truth? But so his words really have no meaning, because they change depending on whether he's talking to a reporter, to a police officer, or his psychiatrist that he needs to convince you to let him off the hook. Let's remember his actions. Their defense is really built upon this delusional belief that Chad and Chris were gonna kill him. Let's look at the scene. Look at the scene, ladies and gentlemen. You want your answer? Look at the scene. 2 bullets to the back of Chad Littlefield. He's down on his knees. 6 bullets up the side and back, and then the side of the face of Chris Kyle. He's face down in the ground. Who's going to hurt him now? Who's going to hurt him now? 2 bullets to the back. Chad, he's down on his knees, gasping for life. Hand in a pool of blood, clinging to life. He rolls onto his back. Rolls onto his back, ladies and gentlemen. And this man, who's afraid of guns, by the way, this man who's afraid of guns, it's not enough to make sure he doesn't hurt me. No, I want this man dead. James told you, dead, 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 dead. No, he wasn't afraid of Chad Littlefield laying on his back, paralyzed, bleeding, clinging to life. He wanted him dead, 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 dead. And that's what this defendant is about. He's gone to the well, the deep well of excuses for his violent behavior, too many times. It's time for it to stop. This defendant gunned down 2 men in cold blood, shooting them in the back in our county. Find him guilty.
All right, ladies and gentlemen of the jury, that concludes the argument in this matter. As I've continually instructed you up to this point not to talk about this matter, I'm lifting that instruction at this time. I will send the original and 11 duplicates of the court's charge to you. When you get back to the jury deliberation room, you'll elect the form and you'll begin your deliberations. As I'd always promise with regard to the alternates, the specific instruction is this: you are not to participate in the deliberations in any form other than listening. You're not to participate in any vote of any type. You are there to listen and listen only, and in the event that another juror becomes incapacitated and can't further perform the duties, then I will put the next alternate in line in that place. So you're listening, so you're not behind, but you're not participating until I order you to do so. So those are your instructions. Now for this time, I'll hand the verdict form and charge to the bailiff, and you will be at this time discharged to deliberate this proceeding. You will notify the bailiff once you inform the verdict. All right, the jury's been discharged to deliberate at this time. At one point in the trial, Mr. St. John, you'd requested that a photograph be made of the mannequin.
Yes, Your Honor.
For record purposes. If we can do that while the jury's out.
Yes, Your Honor.
And have that put in for the record only, that would be something for appeal purposes.
Yes, Your Honor.
Court will stand in recess until the jury reaches a verdict.
All rise.
All right, I've been advised that the jury's reached a verdict. The record reflects the jury's not in the courtroom at this time. State's counsel is present as well as defense counsel and the defendant. Let's bring the jury in. All right, you can be seated in the courtroom. All right, the record reflects the jury's returned to the courtroom at this time. Ms. Stafford, you're the foreperson of the jury.
Yes, Your Honor.
I've been advised that the jury has reached a verdict in this matter. Is this correct?
Yes, Your Honor.
If you'll hand that verdict form to the bailiff, please, ma'am. Mr. Routh, if you'll please stand. All right, we, the jury, find the defendant Eddie Ray Routh guilty of the felony offense of capital murder as charged in the indictment. That verdict is signed by Ms. Stafford as foreperson of the jury. You may be seated at this time. You wish to have the jury polled?
Yes, Judge.
All right, the request to have the jury polled has been made at this time. What I will do at this point is individually we'll start at the first seat, first juror, and I will ask you the same question of each and every juror. Is this a unanimous verdict of the jury? You have to answer out loud.
Yes.
Juror number 2, is this a unanimous verdict?
Yes.
Juror number 3, is this a unanimous verdict?
Yes.
Juror number 4.
Yes, sir.
Juror number 5.
Yes, sir.
Juror number 6.
Yes, Your Honor.
Juror number 7.
Yes, sir.
Juror number 8.
Yes.
Juror number 9.
Yes, sir.
Juror number 10.
Yes.
Juror number 11.
Yes, sir.
And juror number 12.
Yes, Your Honor.
All right, this completes your services, jurors, in this matter, and I will receive and accept your verdict in this matter. I will hand it to the clerk to have it filed with the papers of the court at this time. All right, Mr. Routh, if you'll please stand again. Having received and accepted the jury's verdict in this matter, by statute, I will now impose sentence in this matter at confinement for life in the Texas Department of Criminal Justice without the possibility of parole. That's the verdict of this court, and I will enter judgment accordingly. You may be seated at this time again. I will continue, Mr. St. John, as your attorney in this matter with regard to your rights to appeal, and that includes a direct appeal to the Eastland Court of Appeals. That's the home of the 11th Court of Appeals, which is the court for this jurisdiction, and also your rights with regard to filing a petition for discretionary review with the Court of Criminal Appeals in Texas. I will remand your custody to the Sheriff of Routh County to carry out the imposition of the judgment of this court and the jury's verdict in this matter. Do you have any legal reason to state at this time why sentence should not be imposed?
I would submit to the court he's legally insane, therefore cannot receive the verdict, otherwise no, Judge.
Finding nothing in bar thereof, I will now enter judgment and remand your custody to the Sheriff of Routh County to carry out the imposition of this sentence and judgment of this court in accordance with the rules and regulations of the Texas Department of Criminal Justice. Now then, turning back to my jury. Certainly appreciate your effort in this matter. I have constantly talked to you about the rules and what you can and can't do. From this point forward, I have no other control over you. I'm discharging you from those rules and obligations. I want to talk to you briefly about that. You're free to discuss this case with anyone at this point, or to not discuss the case. That's certainly up to you. I want to issue a statement to you, and that is that the lawyers in this matter are professionals, and they're not going to bother you about your verdict. I can assure you of that. Should anybody else attempt to bother you about your verdict, you make it known immediately to any one of these officers of these court, the bailiff or anybody in here, and we'll get it stopped quick, fast, and in a hurry. I have been asked by the media, as you understand this has been a high-profile matter, that they want to talk to you about your service as a juror. That's a decision that's wholly up to you at this point. I will issue a word of caution in this regard. You can talk to me if you want to, and you don't have to. Remember that what you say will be looked at from time immemorial. I mean, once it's out there and it's recorded, there's no takebacks. So be careful, be judicious about what you're going to say if you decide to make those interviews. I have the transport available to take you back home. This is done. There is a procedure that's going to be done here in a few moments. You're free to stay for that. If you don't want to stay, we'll let you go out the back door, and when we'll get completely done, we'll load the vans up and take you back to your vehicles. At this point in time, I also tell you, very serious matter. Appreciate your hard work. The compensation that you'll receive for this is certainly not anywhere worth the time and effort and emotion that you've invested in it. That's all we can do. With that, I want to turn, pursuant to Article 4203 of the Texas Code of Criminal Procedure, I have been advised that there is a desire to present victim impact statement to this court, to the defendant. Per statute, the court shall permit a victim or a close relative of a deceased victim to appear in person to present to the court and the defendant a statement of the person's views about the offense, the defendant, and the effect of the offense on the victim. The victim, relative, or guardian may not direct questions to the defendant while making the statement. The court reporter shall not transcribe the statement. I have received the jury's verdict. imposed sentence and pronounced sentence. So at this point in time, it becomes proper to consider the victim impact statement, and at this point forward, I'll direct the court reporter not to transcribe these proceedings, and I want to make 100% certain that that camera is not running out there. We're shutting it down.